ಹಸ್ಬೆಂಡಾ ಎಂಟೈರ್ ಫ್ಯಾಮಿಲಿಗೆ ಸ್ಟೇ ಇಲ್ವಾ? ಆಯ್ತು, ಮಂಡೇ ಕೊಡಿ ಅದು. ಇವತ್ತು 2022 nobody has moved. I have got all the matters listed. Nobody is interested. 2 years in ಹಂಗೆ ಇರುತ್ತೆ, ಸಡನ್ ಆಗಿ ಅರ್ಜೆನ್ಸಿ. What application is this? When did you file it? Judgment post ಆದ್ಮೇಲೆ? Then? When did you file it, sir? That's all right. At what stage did you file it? ಏನ್ ಪೇಪರ್ ನೋಡಿಲ್ಲ, ಏನಿಲ್ಲ, ಸುಮ್ನೆ ಒಂದ್ ಮೂವ್ ಮಾಡೋದು. ಕೊಡಿ 12th ಕೊಡಿ. Vacating interim orders, ಯಾವ್ಯಾವ applications, give all those applications. Give all the applications where vacating stay is filed. Vacating stay. Wait.
Vacating, sir.
Vacating stay applications ಕೊಡಿ ಎಲ್ಲ. I will assign dates for that. Yes.
Vacating.
Fresh matter ಎಲ್ಲ ಮಂಡೇ ಕೊಡಿ, ಮತ್ತೇನ್ ಮೂವ್ ಮಾಡ್ಬಿಡಿ. ಎಸ್ ಎಸ್ ರವಿಶಂಕರ್ ಕೊಡಿ. ವೆಹಿಕಲ್ ರಿಲೀಸ್ ನಾಳೆ ತಗೊಳ್ಳಿ. Give it. Yes.
DA case, my request for tomorrow, since all the matters coming tomorrow.
We'll see. Give it. Yes. All the matters ಮುಂಚೆ ಇದ್ದಿದ್ದು, ನೀವು ಇವತ್ತು ಫೈಲ್ ಮಾಡಿದ ತಕ್ಷಣ ನಾಳೆ ಬರ್ಬೇಕು ಅಂತಿಲ್ಲ.
No, it is all.
Give it. We'll see. ಪರವಾಗಿಲ್ಲ. Yes. New DA cases, whatever is filed, madam.
My lords,
New DA cases, whatever is filed, don't post them tomorrow. We'll
Lords,
post it next week. Give it. Yes.
498 matter, husband and family members who are residing in Coimbatore.
Are pending, sir.
It's like we have filed an IA number
Fresh
20.
or pending?
Pending, sir.
Pending. Right? It has come once already.
Yeah, on 2nd of this month, it just came, we have filed an amendment
It
application.
has come, not came.
Yes.
Yes. Give it.
May post it on Wednesday, my lords.
Give it. Next week ಹಾಕಿ ಎಲ್ಲ.
Sir, it's urgency, sir.
No
Staying in
urgency.
Coimbatore.
Why day after tomorrow? ನೀವೇ ಡಿಸೈಡ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಡೇಟ್ ಇಲ್ಲಿ? ಯಾರಿಗೆ ಅವ್ರಿಗೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Give it on Monday. Yes.
Well, a small submission, please. I was.
MMRD Act covered by judgment.
Maybe, sir. Give it fresher.
Yes, sir,
If it is fresh
tomorrow.
matter, please don't wait. Give the memos.
Not
No,
fresh
this week, all on Monday.
matter. Particular case will be listed tomorrow.
Maybe, sir. Tomorrow you move the matter when the matter is listed.
Well,
Yes. Give all the memos. Fresh matters, please give all the memos. I'm not going to take anything for this week. Give it. Yes. Wait.
this,
If it's pending, wait.
this one submission, please.
Give it. No problem, sir. So what, sir? Can't help. What were you doing till 17th August? Yes.
One submission, please, my lord.
Give it. Monday, all Monday, give it.
Can I submit, please, my lord?
ಎಲ್ಲ ಮಂಡೇಗೆ ಕೊಡಿ. Fresh matters, I'm not taking anything, sir, all on Monday. Everything on Monday, give it. No, sir, Monday. Can't help, yes. Next.
Small submission, please, my lord.
ಎಲ್ಲರೂ ಹೇಳಿದ್ರಾಗಲ್ಲ, ಮೆಮೊ ಹೇಳಿದೀನಿ. Whichever is fresh matters, please give it.
My lord, this is.
Please give all the fresh memos. Give that, yes. At 2:30 ತಗೊಳ್ಳಿ. 2:30 ತಗೊಳ್ಳಿ.
Your lordship permits. My lord, I've been tried and convicted already under the Provident Fund Act. My lord, on that appeal is pending now. My lord, on the same facts, my lord, I've been charge sheeted for an offence under 406. That is the problem, my lord. Your lordship may assign any date, my lord.
Pending matter,
Not pending, my lord. Fresh matter.
Monday, sir.
Monday, please.
All Monday, I've told you, ಮತ್ತೆ assignment of dates there.
Grateful.
Yes, give it.
Monday.
Withdrawal of the amount, petition and section.
Take that tomorrow. Withdrawal of the amount tomorrow, yes. Tomorrow, respondent, tomorrow, yes. No problem. Next week, yes.
One submission, my lordship. 2023 fresh matter, my lordship.
Monday.
9 memos, my lordship, not being listed so far.
This is the 10th, give it, Monday. Yes.
My lords, may I make a mention?
Give withdrawal, sir.
My lords,
ಯಾವ ಬೌನ್ಸ್ ಆದ್ರೆ ಏನಂತ? ನೀವು ರೆಸ್ಪಾಂಡೆಂಟಾ? ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ ಕೊಡಿ, ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಕೊಡಿ, ಅದು ಯಾವ ವರ್ಷದ ನೋಡಿ ಅದು ಹಾಕಿ.
Fresh matter, my lord, was to be listed today.
Monday.
I request
Why?
date Monday barely.
Why today?
Like today it was scheduled, it was.
Monday it will come, sir, give it.
But
Monday ಅಲ್ಲ, Monday is a holiday, Tuesday, yes.
Lordship, one pending
my
matter.
lords, in this
It is for.
cryptocurrency exchange, my lords. FIR was filed in 2021, my lords. Now, my lords, my bank account has been attached, my lords. My name is not disclosed in the FIR itself, my lords.
Monday.
My lords, bank account, salary account is.
ಯಾವಾಗ ಆಯ್ತು?
23/8 ಆಗಿದೆ ನನ್ನ sir. Attached-
23/8 ಈಗ
Please.
ಸ್ಯಾಲರಿ ಡೇಟ್ ಆಗೋಯ್ತು. ಇನ್ನ ನೆಕ್ಸ್ಟ್ ಏನಿದ್ರು ಅಕ್ಟೋಬರ್ಗೆ. ಸೊ ಗಿವ್ ಇಟ್
Difficulties, sir. Tomorrow at least.
ಮಂಡೇ.
Tomorrow if it's possible, my lords.
Give it on Monday. They'll come on Monday. Madam, ಯಾವ್ದು Tuesday, no memo should be held. Post everything.
Lords, matter for being spoken to, my lords had cost.
Tomorrow.
My lord, this
Being
is.
spoken to, my lord, this-
Tomorrow. In being spoken to now. 2:30 ಯಾಕೆ sir? Yes. So what? So what? Matter ತಾನೆ? Monday, yes.
My lord,
Thursday ದೆಲ್ಲ ಇವತ್ತು ಡೈರೆಕ್ಟ್ ಆಗಿ ಹಾಕಿದೆ, ಯಾವುದು ನಿಲ್ಸಿಲ್ಲ. ಸೊ ಮಂಡೇ ಏನ್ Thursday ಏನ್ ಬಂದಿಲ್ಲ.
my lord, this is. Lordship,
ಮಂಡೇ.
Your Lordship, in this matter,
Fresh matter.
is pending matter.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಕೊಡಿ ಸರ್.
ಅಲ್ಲ, it is,
ನಾ ಈ ವಾರದಲ್ಲಿ ಏನ್ ತಗೊಳಲ್ಲ, ಕೊಟ್ಬಿಡಿ.
Lordship in,
10ನೇ ಮೆಮೋ ಆದ್ರೆ ಈ ವಾರದಲ್ಲಿ ತಗೊಳಲ್ಲ, ಕೊಡಿ. Yes.
Lordship in pending matter, it is notice is ordered, on 19/7 it is posted. On that day, since notice is not served, await is ordered.
ಆಯ್ತು.
Thereafter, it is not posted. I have
Sari.
moved to 3 memos, Your
So what?
Lordship, there is urgent.
No, give it, yes. ಬರ್ದ್ ಕೊಡಿ, when do you want?
My lord, this is the, please, this is the first matter.
Monday.
I moved 3 memos, my lord.
10th ಆದ್ರೂ ಮಂಡೇ.
ಅಲ್ಲ, Monday ಗೆ ಬರ್ಲಿ, Monday
Sir, no
ಬರ್ಲಿ.
precedents like that, give it, yes.
My lords, one
ನಿಮ್ಗಿಂತ ಮುಂಚೆ
FIR was
ಮಾಡಿದ್ರೆ
stayed by-
ಮುಂಚೆ ಬರುತ್ತೆ.
My lord, one FIR was stayed, my lord. Another FIR has been registered against the same petition, my
Monday,
lord,
sir.
for the same fact, my lord.
My lord, my lord,
Huh?
government servants are suspended for the, by registering non-cognizable. offence,
Government
my lord.
servants are suspended, why are you moving this court?
In FIR is registered for non-cognizable offence, my lord.
Ah.
And we have approached the KIT.
Ah.
KIT has refused to stay, granting stay.
Ah,
Telling
so?
that FIR is registered.
So,
For non-cognizable offence.
you were inside for 48 hours?
My lord, no.
Were you arrested for beyond 48 hours?
No, no.
ಮತ್ತೆ ಯಾಕೆ, why were you in suspension? Mere registration of the crime will not put you under
suspended
suspension.
for the-
No,
Day after.
challenge it, service ಅಲ್ಲಿ challenge ಮಾಡಿ, ಇದಕ್ಕೆಲ್ಲ ಬರಲ್ಲ, ಕೊಡಿ.
It is registered.
Monday.
Day after tomorrow, KIT is.
Monday,
KIT is
sir.
fixed. Tomorrow, my lord.
ಏನ್ ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ಸ್ ಅಂದ್ರೆ suspension is not dismissal, give it, yes.
Your lordship,
Fresh matters, my lordships.
Monday.
Petitioner is student, my lordships.
Monday,
Fresh matter.
your lordships,
all for Monday.
lordship,
Give it, which year? Give all the memos.
Pending, my lord, 2023 matter.
Thank you, give it, yes.
Interim order granted, subsequent interim order is not extended, my lord. Now,
That's all right, we'll see, give it, yes.
charge sheet ಹಾಕ್ಲಿಕ್ಕೆ ಅವ್ರು ಕರೀತಾ ಇದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ.
ಅದ್ ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಯಾವ್ದು ನಾಳೆಗೆ ಹಾಕಿ ಅದು.
your lordship, there's an MC case.
Where charge, where interim order is not extended, please take that.
Connected.
Give all the memos, other memos, please ಕೊಡಿ, yes.
Your lordship, there's an
If you want
MC
to give,
case.
call the cases, madam.
Lords, may I
Yes.
make one?
Lordship, please,
1 minute, sir.
there's an MC case, your
If you
lordship.
want to give the memo, give the memo. Yes.
My lord, petitioner has to go to abroad, day after tomorrow, my lord.
Day after tomorrow, why have you fixed without taking the leave of the court? ನಿಮ್ ಪ್ರೋಗ್ರಾಮ್ ಹೆಂಗ್ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಂಡ್ರಿ?
No, my lord, as per, I mean, like, he has to go, or else, my lord, he can't able to, continue his education, my lord.
Oh.
So there is-
ಆಯ್ತು ಕೊಡಿ. Yes.
Lord,
Tomorrow,
My lord, basically, my lord, as per previous memo, Thursday was scheduled, my lord. So.
tomorrow you come give it, sir. ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಸ್ಟೂಡೆಂಟ್ ಯಾವ್ದು ತಗೊಳ್ಳಿ, tomorrow.
Tomorrow.
Pending ಕೊಡಿ, sir. Yes. How many extensions? Already have granted everything. Just give it,
Your
yes.
lordship, one submission, your lordship. It was already posted for 12. This is a DV case. The respondents are really old, your lordship. And-
DV case or DA case?
Sorry, domestic violence case.
Domestic violence, all
Yes, your
right.
lordship, please, if you could post it maybe just before 12.
No. Yes, Monday.
Requesting
Much
for
obliged.
It's a fresh matter or pending, madam?
Fresh matter, your lordship.
What's your, when is the next date there?
12,
You are the husband?
yes, your lordship.
No problem, Monday, yes.
My lord, these 2 matters are 2:30 minutes.
Why, sir?
My lords, my bank accounts have been freezed, my lords.
Tomorrow.
My lords, tomorrow, my lords.
ಅದೇ 2:30 ಕೇಳಿದ್ರೆ tomorrow ಕೊಡ್ತೇನೆ, day after tomorrow, yes.
My lords, 2:30 only, my lords.
tomorrow ಕೊಡಿ. FR ಅದ ತಗೊಂಡ್ಬಿಡಿ ವಾಪಸ್.
Hello, it is complied, my lords. I've
ಸುಮ್ನೆ ನೀವು
complied with
ಆಫೀಸಿಗೆ ಬಂದ ತಕ್ಷಣ ಕ್ಲೈಂಟ್ ಇಲ್ಲಿ ಬಂದು ಒಂದು ಫೈಲ್ ಮಾಡಿ, ಡೋಂಟ್ ಡೂ ದಟ್.
I've complied with the office of
ಕಂಪ್ಲೇಂಟ್
objections.
ಇದ್ರೆ ಮಾತ್ರ.
My lords, tomorrow, my lords.
Tomorrow.
My bank accounts have been.
Your bank accounts won't be defrozen tomorrow, no worries, let it come.
Lords, one matter we had moved, my lords, your lordships, that's a Foxco case by the wife against the husband. By the time it came before my lords, your lordships were inclined to grant an interim stay. Charge sheet was filed, I brought it.
If
My
you
lords,
have withdrawn.
tomorrow it is posted for
Tomorrow, give it.
Lords.
You wanted it 2:30?
2:30 because
Sorry.
tomorrow it's posted for framing of
Yes,
charges.
I'm taking it because you withdrawn. at
Withdrawn.
the
I
insistence of the
withdrew it.
court, so I'm taking it.
That's-
Yes.
Next one.
IFR stay will always be pending if it is not granted, sir.
Last time, Kalburgi, the date was not given, my lord.
No problem, sir. Give it Monday. Monday or Tuesday, yes.
Lordship on
No
submission.
adjournments, yes.
It's number 2, my lord.
No adjournments in any list, yes.
Fresh matters, list 1, still number 1.
Lord, I appear for the petitioner in this case.
ಏನ್ 2 ವರ್ಷದಿಂದ ಏನಾಗಿದೆ? CC of 2014, sir.
My lord, there is an absconding, it's a split up charge sheet. But
Split
in
up,
so far as the accused
Acquittal
accused
ಯಾರ್ದಾಗಿದೆ?
numbers 1, 3 and 4 have already been acquitted.
Where is that? Orders ಎಲ್ಲಿ?
ಅದು ಎನ್ಕ್ಲೋಸ್ ಮಾಡಿಲ್ಲ, yes, not enclosed.
What is the orders? The learned
I will,
counsel for
my
the
lord.
petitioner submits that the case against the petitioner has been split up, notwithstanding the fact that other accused are acquitted. Petitioner shall produce those orders of acquittal by the next date of hearing, next Tuesday in the next Wednesday, fresh matters list.
Grateful,
That
grateful.
is on 18th. Next,
Number 2,
2021 crime ಏನಾಗಿದೆ?
My lord, B report is filed in this.
Learned counsel, learned HCGP on instructions would submit that police after investigation have filed a B report. In that light, the petition in the form that it is present is rendered infructuous, disposed as having become infructuous, reserving liberty. ಗೊತ್ತಲ್ಲ ಇದಕ್ಕೆ? Yes, next.
For the petitioner, your lordship.
Ah.
Your lordship, the allegations are that the petitioners have granted an illegal permission to run educational activities to one Shreyas public school.
Yes, government. 2017 incident,
ACB,
crime in 2021, today
ACB,
we are
my
in
lord.
2024. What has happened?
ACB is the respondent. ACB is the respondent.
ACB ಅಲ್ಲ, implead ಲೋಕಾಯುಕ್ತ.
Please, your lordship.
Who are you?
My lord, for the response. Previously, Manmohan sir was appearing for ACB.
Who was appearing? Manmohan. We'll delete his name.
Yes, my lord.
Registry to delete the name of PN Manmohan as appearing for the first respondent and print the name of B Latif as appearing for the respondent. Petitioner to serve set of papers upon counsel Shri B Latif. For an incident of 2017, the crime itself comes to be registered for offence punishable under section 13(1)(c) in the year 2021. Till today, no charge sheet is filed against these petitioners, is the submission of the learned counsel appearing for the petitioner. Therefore, there shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing. List the matter on 24th in the fresh matters list. Serve on Latif now, yes.
14,
For the petitioner.
ಎಲ್ಲಿ ಅವರು? Who is ಪರಮೇಶ್ವರ್ ಹೆಗಡೆ? Implead ಲೋಕಾಯುಕ್ತ. Yes, sir.
Sir, I am for the petitioner, my lord.
A3 and A4.
No, I am for A4, my lord.
A4 ಮಾತ್ರನಾ?
A4 patra. There is no role of the A4 as per the complaint and as per Annex B.
2015 CC.
My
What
lord,
has
in
happened?
this 2823 charges framed, my lord, now it is
28?
2823.
But this is filed on 30th March 22,
Yes,
sir.
my lord. Now evidence is commenced, my lord, almost witness.
But there's
towards
nothing
witness.
against him.
As per
They
Annex.
heard the learned counsel appearing for the petitioner. The learned HCGP on instructions and verification of the records would submit charges have been framed on 2/8/2023. It is long after the filing of the present petition. Merely because the matter was not listed before the court, the petitioner should not be put to prejudice. This is in the light of the fact that petitioner accused number 4 is accused number 4 and there is nothing that would pin him down for the offences laid in the charge sheet or the charges framed for forgery. Therefore, there shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing. 1 HCGP 2 emergent notice. 138 CC 2019.
138. ಅಲ್ಲ.
5 A2 and A3 Kashkan. Next.
My lord, in this matter, my lord, serial number 5, only FIR is challenged, my lord, but it
Charge sheet
is-
ಆಗಿದೆ,
charge sheet
maybe.
ಆಗಿದೆ, CC 88 of 22. That then.
ಅದ್ರ ಸ್ಟೇ ಮಾಡ್ಬೇಕಾದ್ದೆ ಅದು. First, yes.
Withdraw my lord's permission.
That is always there.
Please.
Next.
6,
No representation list after 2 weeks. Registry is directed not to list the matter prior to the expiry of 2 weeks. Next,
7,
same order.
8,
For the-
IO existing. ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ?
I am not moved, my lord.
List the matter, post the matter for admission. Interim order subsisting shall continue to the next date of hearing. You have to respond.
Yeah, I am the second.
Okay, any urgency?
No urgency.
Yes. Yes.
9,
2022 crime charge sheet ಆಗಿದೆಯಾ?
Please, my lord, charge sheet is filed.
What happened ಇದಕ್ಕೆ? Charge sheet ಆಗಿದೆಯಾ?
Charge sheet ಆಗಿದೆ.
Same order, SJK. 9, serial number 9,
10,
charge sheet.
Lord, I appear for the petitioner in this matter.
Yes, sir, I have stated the warrant. What is the arrears?
Lord, I will ascertain, Lord, and Lord.
Learned counsel for the petitioner to ascertain the arrears and make submissions on the next date. Kapil Dikshit,
I for the first
come
respondent.
this side.
my lord.
What arrears ಎಷ್ಟಿದೆ? Arrears?
I'll check with, I'll
You
get it.
you also have to ascertain. Both the learned counsel appearing for the petitioner and the respondent are not aware of the arrears that are to be paid to the wife. Therefore, list this matter on next Thursday. In the fresh matters list. Next.
11,
CC of 2019,
My lord,
stage.
it is for
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ? Number ಕೊಡಿ. Learned counsel, sorry, your name? Learned counsel B. Vijay Shetty submits that he would, undertakes to enter appearance for the second respondent, registry to print the name of so-and-so, tag this petition along with so-and-so. Yes, Devraj? Adhe. Admission, we'll post it for admission. CC of 2019.
And I handed over the file back.
You're not Gopal Singh error. Registry to delete the name of Devraj G as appearing for the petitioner. List the matter after 2 weeks. Why, sir? Interim order ಇಲ್ಲ. One ನಿಮಿಷ. List the matter if there is no representation on behalf of the petitioner Gopal Singh. ಮಾಡಿ. List the matter after 2 weeks. Pendency of this petition will not come in the way of any proceeding before any fora. These are the order which has been done. But subsequently, we are challenging the order. But in spite of the order, in spite of there is no say or they are not releasing it in my favor. ಬರ್ಕೊಳ್ಳಿ. ಆಮೇಲೆ the pendency of this petition will not come in the way of any consideration of any application filed by the respondent before the concerned court. Yes. Because in his absence, I can't dismiss it. More than this, I can't do. ಅದಕ್ಕೆ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಹೇಳಿದ್ವಿ. ಏನ್ ಬೇಕಾದ್ರೆ ಫೈಲ್ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್.
12,
ಕಂಪೌಂಡಿಂಗ್
respond number 1.
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
Settle ಆಗಿದೆ.
ಎಲ್ಲಿದ್ದಾರೆ?
Respond number present.
Huh?
Respond number 1 present ಇದ್ದಾರೆ.
Where is the petitioner, sir? Pass over.
Okay.
Next.
13,
Crime of 22. Charge sheet ಆಗಿದಾರಾ?
B report is filed, my lord.
B report. Yes, next. Memo ಕೊಡ್ತಾರೆ. Memo in terms of the memo. Next.
14,
13 also B report is filed.
13,
13 ಈಗ ಹೇಳಿದ್ದು.
Sorry, my lord. 13 B report is filed, my lord.
14 ಏನಾಗಿದೆ?
14 acquittal ಆಗಿದೆ before the trial court.
Acquittal order. Yes. Next.
15,
Mohan Chandra. No representation list after 2 weeks.
16,
ಇದೇನಾಗಿದೆ?
My lord, in this charges framed on 7/12.
Anyway, even otherwise it is husband.
Lords, and 2020 itself, there's a decree, judgment passed by the family court.
For what?
On the ground of cruelty and desertion, I had filed a divorce petition against the respondent complainant.
What happened to that?
There are findings that there is a judgment and decree in my favor. Marriage is dissolved and the petitioner is also remarried, my lords, after the appeal.
All right, then wait.
There are findings that.
Take out notice. The petitioner submits that he had instituted a suit, instituted proceedings for annulment of marriage and has a decree in his favor which has resulted in dissolution of marriage. It is his submission that the correspondent complainant is already married and.
No, my lords, the petitioner accused.
You are married.
Yes, after
Then
the
you have
appeal
to-
period, my lords, he got remarried.
After that. So, and the petition, ಏನು ಬರಿಬೇಡಿ. In that light, emergent notice to the second respondent returnable by the 26th of September, one HCGP mail ಹಾಕ್ಬಿಡಿ. So and so, list on 26th of September, there shall be an interim order of stay of further proceedings, square the petitioner till the next date of hearing. Next.
17,
My lords, I appear for the petitioner.
Anytime,
In this
please.
case, B report has been
Report is
filed.
my lord, in
Report,
17.
all right. Even otherwise, it's a matter to be stayed.
17 B report is filed.
17, B report, yes.
18,
Next.
for the petition.
My lord, the matter is still in the stage of hearing before charge. Discharge application is filed. However, my lord, they've suppressed the fact that there was another complaint which was filed wherein the victim was being threatened with her obscene photographs. Charge sheet was also filed in that. And they claim that dowry harassment was done. However, repeatedly, the victim has transferred money to the complainant, my lord. Her father, bank statements are also produced. Further, my lord, we have also produced the charge sheet of the Andhra Pradesh police, which indicates that she was being harassed for obscene photographs. Nevertheless, here, they also claim that a site was registered in the name of the petitioner. However, my lords, that site was registered in the name of the victim even prior to marriage in 2015 itself. More so, my lords, if the Andhra Pradesh police charge sheet is perused, it indicates he's an auto driver, my lord, while she was working here as an engineer along with the petitioner. And such being the case, he claims that 30 lakhs cash dowry is paid and 500 grams gold. Hence, before this honorable court, ma'am. Notice was issued, my lord.
304B, 498A.
Please, my lord, however,
Death of the
documents. My lord, the document.
all these material that you're now trying to project are a matter of evidence.
Please, ma'am.
In 482 will not consider all this, particularly when it is 304B read with 498A.
Please, my lord, however, previously notice was issued to the respondent number
come.
2. Please.
So far as the charge sheet that is filed by Andhra Pradesh police is concerned, that was about 7 months
Whatever,
prior to that.
take advantage of all that in a trial. In a 482, I will not. Prima facie offences are glaringly found. Your
My lord-
A1, 2 and 3. Right?
My lord, prima facie offense is not made out, my lord. If your lordships may kindly
Oh,
read us
no.
201. Page 225 would explain, my
Page
lord.
54. You want me to go
Please,
through the
that's charge
statements
sheet,
also?
please, my lord.
Yes,
My lord, however, the documents speak contrary.
that is a matter of trial, madam.
Please, my lord, please. I leave it to your lordship.
Yes, you want to avail remedy of discharge, you
May I
can avail.
Please,
Yes.
please.
That
my lord.
application is already filed, is pending.
Filed, pending.
It's
pending.
Let the
pending, my
court
lord.
consider. We'll dispose on that ground.
Please.
The petitioner is before this, petitioners accused 1, 2 and 3 are before this court calling in question proceedings in SC 1938 of 2019 registered for offense punishable under section 304B read with and 498A inter alia. The learned counsel appearing for the respondent complainant submits that the petitioners have also filed application seeking their discharge from the array of accused in SC 1938 of 2019, and the same is pending consideration. In that light, I decline to entertain the petition, leaving open the petitioner to pursue the remedy of discharge that the petitioners have availed of as on today. With the aforesaid observation, petition stands disposed. All contentions left open.
May I make a request for expeditious
That we will see. ಯಾವಾಗ ಹಾಕಿರೋ discharge? ಅಲ್ಲಿ 4-5 ವರ್ಷ ತೀರ್ಮಾನನೇ ಮಾಡಲ್ಲ.
2019 is the
Yes, the application seeking discharge, if pending as on today, shall be expeditiously disposed at any rate within 4, 5 weeks, 6 weeks from the date of receipt of the copy of this order. Yes.
rating.
ಅದೊಂದು ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ order according. In the meantime, next.
20.
Correct. In terms of the memo, withdrawn.
21.
ಸೇಮ್ ಪಾರ್ಟೀಸ್ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ ಕ್ರಾಶ್ ಆಗಿದೆ ಮೆಂಬರ್ಶಿಪ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಡೇಟ್ ಒಳಗಡೆನೆ
ಸೇ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ವಲ್ಲ? ಕೊಡಿ, ಅದು ಯಾವುದು? ಗವರ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ ಡೇಟ್
ಯಾವುದು ದೇಶ್
ಡೇಟ್
ಅಂದೆ ಸೇಮ್ ಕ್ರೈಮ್?
ಸೇಮ್ ಪಾರ್ಟಿ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್
Similar matter. You can't draw similarity. If it's same accused, then the co-accused of the same crime, yes. No, look at it. List on Wednesday in the fresh matters list. Next.
22.
20. Petition is 6 months. Weeks time will be granted.
You want to
Charge
withdraw?
sheet is filed, my lord.
Then
FIR is.
file. If you want to challenge the charge sheet. Learned HCGP on instructions would submit that the police after investigation have filed a charge sheet. The learned counsel of the petitioner seeks leave of this court to withdraw the petition. So and so, same charge sheet matter. Challenge the charge sheet, yes.
23.
In the meantime, ಇಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಅಂದ್ರೆ ಬೇಡ. List after 2 weeks, yes.
24.
Pay report is filed, my lord.
Pay report.
25.
Petitioner.
My lord, the alleged incident has been taken place on 4/11/2019, my lord. The complaint has been lodged on 1/12/2021.
ಪರವಾಗಿಲ್ಲ.
No, my lord,
That is not the issue. Why did you blackmail her?
my lord.
Why did you blackmail her? See page 27. ನೀವೇನು ಓದಿಲ್ವಾ? ಓದಿಲ್ವಾ? ಎರಡು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ, ಓದ್ಕೊಂಬಂದ್ಬಿಡಿ. List after 2 weeks. Yes.
26,
Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
26,
Appealing for petitioner.
2, 3 and 4 Kashkan. Next.
Same parties, accused number 1 already crash ಆಗಿದೆ my lords. ಅದ್ರೊಳಗಡೆ accused number 3 ಇದೀವಿ ಇದ್ರೊಳಗಡೆ. Already judgment copy ಕೊಟ್ಟಿದ್ದೀವಿ.
ಕೊಡಿ, ಅದೆಲ್ಲಿದೆ? Even otherwise ಏನೂ ಇಲ್ಲ ಇವ್ರ ಮೇಲೆ. ಏನು MPML ಇದೆ ಇದು? What are you saying, madam? Which matter is this? ಯಾವ serial number ನಿಮ್ದು?
26.
26 offense punishable 498 ಇದೆ, I think.
498 ಹೇಗೂ MPML ಅದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ?
ಅವ್ರು second list ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
Madam, yes. Kashkan 2, 3 and ನಾನೇ ತಪ್ಪು ಓದ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅನ್ಕೊಂಬಿಟ್ಟೆ. Yes.
27,
2, 3 and 4. Will stay only 341. Stage.
Here before
Petition.
charge, man.
Huh?
HBC ಇದೆ stage.
The petitioners are before this court calling in question so and so. A perusal at the summary of the charge sheet would indicate that there is no foundation or facts that would become an offense under section 341 of the IPC. Therefore, there shall be an interim order of stay only insofar as the offense under section 341 is concerned. The further proceedings qua the other offenses shall continue. 1 HCGP, 2 emergent notice.
28,
Yes. Madam? ಯಾರು ಇರ್ಲಿಲ್ವಾ? ಅವ್ರು ಯಾರು ಮತ್ತೆ? ಹಂಗಾರೆ ಬೇಡ, ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks. 28.
28, my lord, 15/4/23, my lord, charges framed and 5 witnesses already been examined in.
But 2022 matter. Even otherwise, no case, A to owner of the spa. There is no representative by the petitioner. List after 2 weeks. Registry is directed not to list. Yes.
29,
And pendency of this petition will not come in the way of further proceedings before the concerned court.
My lords, in this matter, my lords, we issued NOC and some other learned counsel named Nagaraj SS filed his wakalat, my lord.
29 ಅಲ್ಲ?
Please, my lords.
ಅದಕ್ಕೆ ಫೈಲ್ ತಂದಿಲ್ವಾ?
We have returned it back, my lord, NOC. my lords.
29.
Please, my lords. KG Sadashivaya has issued NOC, my lord, no objection.
ಎಲ್ಲಿದೆ? Where is the memo for retirement?
My lord, they have taken away the entire
File it,
file.
sir. Nobody has filed wakalat. List after 2 weeks. Yes.
30,
This is the interim order, madam.
2017 sir, ಏನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
Because there is one interim order in another matter, madam.
What interim order ಕೊಡಿ?
Accused number
Criminal petition 299 of
219,
2019.
accused number 4 and 7. Now the matter is for evidence before charge. B report was challenged, madam.
Learned counsel for the petitioner submits that the coordinate bench, qua the other accused, has granted an interim order of stay in criminal petition 299 of 2019. Tag this petition along with so and so. There shall be an interim order of stay in the case at hand as well, in the light of the interim order subsisting in the companion petition. List after 4 weeks.
31,
1 HCGP, 2 emergent note.
I have filed the petition on
Ah.
filed petition on 30/11/22, my lord. Charge framed on 14/7/23, my lord.
That's all right. CC of 2014, sir.
Yes,
10 ವರ್ಷ ಆದ್ಮೇಲೆ ಏನ್ stay?
name of the petitioner included after the charge sheet, my lord.
So what? ಮಾಡಬಾರ್ದು ಅಂತ ಎಲ್ಲಿದೆ? FIR ಎಲ್ಲ ಹೆಸರು ಇರ್ಬೇಕು ಅಂತಿದ್ಯಾ?
Accused
Rudimentary, don't make submission.
number 2 also quashed by this honorable court, my lord.
Quashed.
Yes,
ಕೊಡಿ.
case number ಇದೆ ನಾನು print ತೆಗೆದು. Sorry.
Get the order. List the matter day after tomorrow in the fresh matters. Get the order.
32,
Seniors is out of session.
A case also out of station. List after 4 weeks. Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
33,
My lord, 21/1/23, my lord, charges framed and witness already been
No
examined. my lord.
representation. List after 4 weeks. Even otherwise it's 306.
306.
No case.
34,
34, my lord, settled in Lok Adalat, my lord.
Learned HCGP on instructions and verification of the records would submit that the matter has been settled between the parties in the Lok Adalat. In that light, the petition stands disposed as having rendered infructuous in the light of the aforesaid settlement. Yes, next.
35.
I appear for petitioner, my lord. Now the stage is for summons only. Deficit stamp paid, so it is for the stage of summons only, my lord.
Is
This
comment?
138
138,
section.
my lord.
138. My lord, in this, the
Learned
relationship
counsel
between
for
the
the petitioner is directed to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement. List the matter on 24th in the fresh matters till such time further proceedings before the concerned court shall remain
have
scheduled.
order sheet, everything order sheet is here.
File Madi. Kodi. Learned counsel of the petitioner
The order sheet.
files the entire order sheet. The same is taken on record. Next.
36.
No representation. List after 2 weeks, not to list.
37.
The offense is under section
376, 420.
420.
ಎಷ್ಟು
The
ವರ್ಷ?
incident took place in the year 2013. The complaint was came to be large on 2019. There is inordinate delay. And in the meanwhile, my lord, the petitioner,
Meanwhile, touch ಅಲ್ಲೇ ಇರ್ಲಿಲ್ವಾ ನೀವು ಅವ್ರ ಜೊತೆ?
he has filed the complaint against the petitioner, against the victim
For what?
on 7/1/2018 for the offense punishable under section 384,
Extortion.
extortion.
Charges
It is
framed, 5 witnesses have examined. my lord, in
Examined.
this.
But I have filed the discharge
Two
application.
ಯಾಕೆ ಮೂವ್ ಮಾಡಲ್ಲ?
Discharge application was filed.
ಅಲ್ಲ ಸರ್, ಫೈಲ್ ಮಾಡಿದ್ರೆ 2022 ಅಲ್ಲಿ.
Please.
ಇದನ್ನ ನಾನು ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಬೇಕಾಯ್ತು.
I have filed the memo.
ಏನ್ ಮೆಮೋ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ. ನನ್ ಅಪಿಯರ್ಸ್ ಫಾರ್ ದಿ ಪೆಟಿಷನರ್. You filed a memo. ಇಲ್ಲಿ ಬಂದ್ ಬೆಳಗ್ಗೆ ಅರ್ಜೆನ್ಸಿ. 2 years in the none of you would comply the office objections. What would happen to the clients? ಅವರು ಒಂದು ರಿಮೈಂಡರ್ ಫೋನ್ ಮಾಡಿದಾಗ ಇಲ್ಲಿಗೆ ಅರ್ಜೆಂಟ್.
Sorry.
Memo. I will not interfere now.
No, I filed the discharge application. On that basis, discharge also I filed. It has came to be rejected.
When?
On 9th of November 2022. It's at page number 19.
That is what ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ page 19.
Please.
ಈಗ ಯಾವ ಸ್ಟೇಜ್ಗೆ ಹೋಗ್ಬೇಕು? ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿ 2 ವರ್ಷ ಆಯ್ತು. What should happen to a case that is good on merits, evidence is commenced, 5 witnesses are examined? Why should I interfere now? ಏನ್ ಮೆಮೋ ಹಾಕಿ? ಒಂದು ಮೆಮೋನು ಹಾಕಿಲ್ಲ, ಒಂದ್ ಸರಿನೂ ಬಂದಿಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ. ಒಂದೇ ಸರಿ ಬಂದಿರೋದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ.
Subsequently, I filed the memo.
Subsequently filed a memo. Subsequently 2 ವರ್ಷದಿಂದ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Don't tell me this. This is highly incorrect. 2 years in you keep the petition pending and now urgency springs. I will not interfere in this case.
Even in the cross examination, she has accepted.
Acquit ಆಗ್ತೀರಾ ಬಿಡಿ. Acquit ಆಗ್ತೀರಾ.
In page number 223, my lord.
I know you have an excellent case on merits.
She has lodged the complaint, and in that complaint also she has not stated about the sexual intercourse.
It's all
Of
right.
trial,
Yes.
my lord, because 5 witnesses examined. Let the trial court take the decision because we
We
don't
will
know what
direct
is
the
the.
conclusion of the trial.
Yes.
ಇವ್ರ ಮೇಲೆ ತೊಂದರೆ ಆಗುತ್ತೆ, ಸುಮ್ಮನೆ ಇರಿ. The party will go against the advocate then. ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ನೀವು. ಕರೆಕ್ಟ್. 2 years ಇಂದ ಮೆಮೊ ಪೋಸ್ಟ್ ಮಾಡ್ಸಕ್ಕಾಗಿಲ್ಲ ಅಂದ್ರೆ ಏನು ಬಂದೇ ಇಲ್ಲ ಕೋರ್ಟ್, ಮೆಮೊನೇ ಕೊಟ್ಟಿಲ್ಲ. Not one memo is in the file. Is it not a mistake on your part?
Please.
Then what? The petitioner is before this court calling in question proceedings in so and so. The learned HCGP would put up vehement opposition, contending that the charges have been framed after the filing of the petition and the matter is set at the stage of trial. A perusal of all the statements, the summary of the charge sheet or even the complaint even would indicate an incident, that too consensual, that took place in the year 2013 is projected to be a crime in crime number 15 of 2019 for it having been registered in the year 2019 for offense punishable under section 376 and 420 of the IPC. This comes about after the petitioner registers a crime against the complainant for extortion under section 384 of the IPC. Adil charge sheet ಆಗಿದೆಯಾ?
Adil be report ಆಗಿದೆ.
So and so. Notwithstanding, though the police have filed a B report on the charge of extortion against the complainant in the peculiar facts in peculiar facts and the fact that the charges have been framed after the filing of the present petition. I deem it appropriate to stall further proceedings before the concerned court. Pay the petitioner till the next date of hearing. 1 HCGP 2 emergent notice returnable by the 27th of September. Next.
38.
Here for R2 in this matter, my lords. Matter where on the last
The
date, the
directed
honorable court had
payment of
directed them
rupees-
to make payment of 10 lakh.
10 lakhs
That payment has been received, my lords.
received, huh?
We have made the payment.
May I just,
Innenide?
may I just point out, my lords, what offense is made out in this particular petition?
we
I
are
just
willing to
take a
settle
few
the
minutes,
matter.
that's all.
Only
10 lakhs ಬಂತಾನೆ.
ಬಂದಿದೆ.
ನೀವು ಹೇಳಿದ್ರೆ ಏನು ಬರೋದೇ ಇಲ್ಲ, ಬರೀ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂತ. ಎನಿವೇ ಈಗ ಬಂದಿದೆ. Next installment.
We have already paid another 3 lakhs in the past. my
That's
lord.
okay.
That's
If
2
the
minutes,
matter
that's
will-
not 3.
Very well. Okay. We will negotiate. Matter may be referred to mediation, my lord. We will sit
Alright,
across the table
well,
and we
Let us-
will.
There is no, my lords, if at all any payment has been made, it's only before this, my lords.
I
that
will
this
stay
is
for the
happened.
proceedings.
My lords, may I point out, my lords, what is the conduct and how the offense is made out?
Conduct may be anything. You want money, right? 35 lakhs ಎಷ್ಟದು?
First 35 lakhs was the due
It's a
amount.
principal.
Now
It's
with
principal,
interest,
interest
please.
ಆಮೇಲೆ ಬರುತ್ತೆ. That I will order. You take 35 first. Next.
Lord, I have instructions to state that there is a new apartment under construction. I'm willing to give him.
They will not receive it,
the
my lords.
the
They will
concerned
not, they will not
apartment-
receive it, my lords, because they don't trust him. Our flat itself, they have sold to someone else. If it's any monetary payment of the
The merits of
35
it, my
lakh,
lord, I have not sold.
12 lakh is
Landowner
paid.
sold it, saying it is coming out of his
ಈಗ
share.
ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಿ first.
Out of 35, 12 is received, my lords. If at all, my lords, they are willing to.
Another next concern, sorry, installment
Yes.
ಯಾವಾಗ?
Month's time because he's in custody.
ಆಯ್ತು.
That's why. This is
You
14
want
year.
money, right? Yes. You want pass orders on merits, I will pass. You go the execution way and do anything you want.
My lords, it's only pursuant
That-
to my lord's orders
If
that
that
they
is
have
going to
made
get
any-
over by 4 weeks, let's see.
This is the largest payment they have made in 14 years.
ಆಯ್ತು ಬಂದಿದ್ಯಲ್ಲ ಈಗ. So you're seeing some money. Yes.
Indeed, my lords, indeed.
Some oasis in the desert, sir, just
Indeed, my lords, indeed,
try to
indeed.
relish that first.
Indeed,
Yes. Now, I'll list it on 27th.
Very well.
By then, another 10 lakhs.
We make efforts to make payments in installments, my lord. Let there not be a.
ಅದೇ installment
Alas,
ಹೇಳಿದ್ದು.
my lord, the only
Not
issue is-
EMI, sir.
ಇಲ್ಲ, the only issue is, my
Lord,
lord,
could I pray for a
that-
shorter date, my lords? It's 10 lakh rupees and that
Wait,
could,
sir.
lords, this previous installment only because of,
Wait, sir. List the matter on 27th. The petition, it is made clear that the petition would stand dismissed in the event the petitioner would not pay to the respondent another 10 lakhs by the said date. This direction would not come in the way of the parties sitting across and arriving at a settlement, comma, if any. List on 27th in the fresh.
If I may
matter.
request, my lord, 30th, my lord.
30th, but at 27th.
then my lords, 15 lakh, let that.
My lord, in the interim, my lord, my bail application is pending
Lords, I'll
consideration.
then submit, my lords. If some interim protection is being sought, then I will also request my lord.
My
to
only
kindly
interim
see
protection
some.
is that my lords may kindly direct my
The
bail
trial
application.
court has not been able to secure his presence. He is hoodwinking
here.
everyone.
Where are you?
In the custody as.
You're in custody.
My lords, senior APP impresses upon the court that police agency is not properly executing warrants in the above case. Police
Well,
actually
don't-
execute madaki. If he is let out, my lords, he is.
Birthday. I'm not letting you. Where? Friday, 27th will pass some order.
My lords may kindly.
27th, 35 ಕೊಟ್ಬಿಟ್ರೆ, I will pass some order and interest we will drag this.
He's in custody for
35
last 1 month. Kindly, please, my lord, because we are making.
Money is
payments
also in their
installments.
custody. He may also be in custody.
No
Small amount. For a small amount of 35 lakh rupees, my lord, we are. we're
How
sitting-
the small is this one?
1 minute, sir. ನೀವು ಸುಮ್ನೆ ಇದ್ರೆ
I'm sorry.
ಊರ್ಕೆ.
I'm sorry.
Yes,
Lords may kindly pass directions to consider the bail application. That's all.
no,
On the
that
merits
I
of
will
the
pass
case.
on the next date.
Please, my lord, only on the
Rightly
merits.
in
of-
custody.
Only on the merits of the case, my lord. Nothing. else.
Definitely, I will consider it. Another 10 lakhs you pay. List on 27th.
Great.
Avath will direct. Anyway, you're in custody. Next.
39.
A2 and,
498.
yes, sir. A2 and A3.
498 matter has
Ashkan.
been settled.
Settled.
Settled and divorce has also granted.
So we'll close this.
No, my lord, the respondent number 2 has to. be-
Ashkan, 1 HCGP, 2 emergent notice returnable by 27th. Yes, stayed. Next. Madam. ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಷ್ಟೇ, ಲಿಸ್ಟ್ ಆನ್ 27th ಅಷ್ಟೇ, ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಅಂದ್ರೆ 27th.
This, in the inordinate delay of 4 months, my lord. the
ನೋ
date of-
ಪ್ರಾಬ್ಲಮ್ ಸರ್. ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಿದೆ ಥೆಫ್ಟ್ ಆಗಿದೆ ಅಂತ ಗೊತ್ತಾಗಿದೆ 4 ತಿಂಗಳ.
They got to know that on 24/10/2016, my lord. Thereafter, after we filed an NI act against the informant, this complaint
No
has been
problem, you
filed.
serve on the respondent. One,
But it is for framing of charges.
maybe sir, one HCGP to emergent notice, next Wednesday in the fresh matters list. ಅಲ್ಲಿ counsel ಇದಾರಲ್ವಾ, petitioner to serve on the counsel who represents the respondent in the trial proceedings.
Prosecution case.
Complainant ಇಲ್ವಾ?
Complaint ಅಲ್ಲಿ.
ಕಂಪ್ಲೇಂಟ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ ಇಲ್ಲಿ?
ಇದ್ರಲ್ಲಿ ಮಾಡಿದ್ವಿ.
ಹಾ ಸರಿ, ಅಲ್ಲಿ ಯಾರು ಇಲ್ವಾ?
ಅಲ್ಲಿ ಯಾರು?
ಸರಿ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಗೆ ಸರ್ವ್ ಮಾಡಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
41.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file next date ಏನು?
ನೆಕ್ಸ್ಟ್ 1/10
ಹಾ, 1 ಲಿಸ್ಟ್ ಆನ್ 21st in the fresh matters list.
Meanwhile, stay.
ಅವತ್ತು ಸಾರಿ 24th in the fresh matters list.
Meanwhile, stay.
Meanwhile ಬೇಡ, meanwhile adjournment. Yes.
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಏನೂ ಆಗಿಲ್ಲ, ಏನ್ ಕೇಸೇ ಇಲ್ಲ, ಒಂದು ನೋಟಿಸ್ ಅಷ್ಟೇ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಇನ್ವ್ಯಾಲಿಡ್ ಚೆಕ್ ದಟ್ ಈಸ್ so
let it come.
After the merging of our bank.
Non-CTS check, that is not a ground in under 138 at all. I will give you the judgment now.
One Allahabad judgment is there.
No sir, Allahabad ನನ್ನ judgment ಇದೆ. Should I follow Allahabad or mine? ಅದಕ್ಕೆ ಬರೀ notice. Yes. Non-CTS check is not a ground, sir. RBI has issued circular the moment merger happened in 2016.
After the merging has been more than 5 years, they have to prove the check.
We'll see. ಅದಕ್ಕೆ notice. Yes.
42.
Appearing for petitioner, Your Honor. My lord, the petitioner.
1,50,00,000
ಅಲ್ಲ,
recovery.
ಇಲ್ಲ, 3-1 application. There is only 1 lakh is recovery, my lord.
1,50,000.
1 lakh. But we have paid already 7.5 lakh. In this case, my participation is not at all involved, my lord. I have been implemented by way of 319 application. My lord, FIR came to be filed, accused 1 and 2 were.
Yes, government.
Lord, in this 3 witnesses examined, my
No,
lord.
that's all right. 319, he is newly brought in. We'll see. Get the, where is the order?
My lord,
Order or notice ಏನ್ challenge ಮಾಡಿದೀರಾ?
order I have challenged, my lord.
We'll see.
Please. My
Learned
lord, page number
HCGP is
25, Your
directed to
Honor.
accept notice for the respondent. Emergent notice to the second respondent returnable by 27th fresh matters. Till such time, the order that brings in the petitioner back to the web of the proceedings shall remain stayed. Next.
Much of it.
43.
I pay for the petitioner's counsel. I run a platform. I have nothing else to do with anything. What happens is that the person who actually runs the cryptocurrencies gives me an intimation, page 166, saying, please, I want to delist these. I send an intimation to him, to the complainant. What he would do, page 168, I send the intimation. The following day, he sells. It's not, ultimately, he suffered some loss in the sale, apparently, but the complaint would come almost 10 months later.
We'll see. We'll hear the complaint. Heard the learned senior counsel C.K. Nandakumar appearing for the petitioner. 1 HCGP, 2 emergent notice, 26th in the fresh matters list, returnable by.
Crim protection till then.
No, not a case for that.
But the reason is this, he is, if your lordships are kind enough to look at the complaint, all he says is, and of course your lordships would have seen, all he says is, I want to know who the owners are, and please be kind enough to see one other. I'll just show your lordships one document if your lordships permit.
Let the government also get the papers.
I'm told they've been served, my lord, I'll verify.
Yes.
There is a transcript of a conversation between us, page 189,
Exactly.
where he says, I want to contest for elections. That is, this seems to be his motivation. There is something else, this, which
Any of the grounds that you have taken are a matter of trial.
I bow down to that. I'm not saying,
Let him get the papers.
Please, I bow.
Yes. PCR of here ilva? Gopal Krishna. No representation, 2 weeks, not to list, prior to the expiry of 2 weeks.
55.
In the meantime. Independence one, pendants, ಎಲ್ಲದರಲ್ಲೂ pendants. In the meantime, next,
46.
state madam, yes, next.
46.
ಏನ್ ಗ್ರೌಂಡ್ ಇಲ್ಲ ವಿಷ್ಣುಮೂರ್ತಿ.
Supreme Court, Honorable
Down
Supreme
stay
Court
application
judgment,
again.
your lordship, that regarding.
ಏನು
The Mehal court has jurisdiction, your lordship, that as per your lordship that.
emergent notice to the respondent. Yes, next. Stay. Application ಅಲ್ಲಿ.
Stay ಇಲ್ಲ ಅಲ್ಲ ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅದಕ್ಕೋಸ್ಕರ ರೆಸ್ಪಾಂಡ್ ನೋಟಿಸ್
ಆಯ್ತು,
ಅಕ್ಯೂಸ್ಡ್ ಇನ್
emergent
ಅಟೆಂಡ್
notice
ಆಗಿದೆ.
to the respondent. Next.
Please.
7.
Pokso.
For the petition, my lord.
ಇದೇನಾ?
Notice
Permission
for-
ಕೊಟ್ಟಿದ್ದಾರೆ. Jagdish ಅಲ್ಲಿ. We'll pass it over. All matters are there. We'll see if possible. We'll take it to. Yes. Pass over.
48.
MMDR.
ನಾಳೆ most of the matters
Alright.
that can up tomorrow. More charge ಇದೆ ನಾಳೆ.
Tomorrow. Please.
49.
Judicial custom, petitioner, 9,
Judicial custody.
is last time.
ಗೊತ್ತು, ಮದುವೆ ಆಗಿದ್ದೀರಲ್ಲ.
15 days
Was there
time was
20
granted.
ಅಲ್ಲ, interim bail was granted for marriage.
20 years, 21 years ಆಗ್ಬೇಕು ಅಂತ
ಆಯ್ತು, ಗೊತ್ತು.
ತಗೊಂಡಿದ್ದೀನಿ.
Recorded everything in the
Please.
audit. This we will dispose.
Please.
He's in custody also. ಆಯ್ತು, ಇದು ಡಿಸ್ಪೋಸ್ ಅಂತ ತಗೊಳ್ಳಿ. ನಾಡಿದ್ದು ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ.
Please,
We will give a direction to the jail authorities to
Please.
release you.
please,
also. ಈ ಜಗದೀಶ್ ಕೇಳ್ಬಿಡಿ, this case where
Yes.
I will record everything and do it.
Marriage certificate.
50.
ನಂಜುಂಡೇಗೌಡ್ರೆ, ನಾಡಿದ್ದು ನಂಜುಂಡೇಗೌಡ.
Please.
I'll release it day after tomorrow. Till then, don't be in a hurry. Yes.
Please.
Yeah. Disposed.
Please, they were supposed to provide the marriage certificate. 15 days bail was granted.
20 years
ಗೊತ್ತೇನೆ ಅಂದ್ರಲ್ಲ ಎಲ್ಲಿ?
ಅಲ್ಲ 21 years ಆಗ್ಬೇಕು ಅಂತ ಸಿಸ್ಟಮ್ ತಗೊಂತ ಇಲ್ಲ ಅಂತ ಆಲ್ರೆಡಿ ಮ್ಯಾರಿಡ್ ಆಗಿದ್ದಾರೆ. ಮ್ಯಾರಿಡ್ ಆಲ್ಸ್.
ಇಲ್ಲ, dot. Child is also there. ನೀವು ಯಾರಿಗೆ? Yes. Objection ಇದೆಯಾ? Next.
50.
A234 Kashkan. Next. State, sir.
Case
Next.
was still in there.
The 7C and 12 list on 16th. ಅಲ್ಲ, next 13th ಅಲ್ಲ, 16th ಅಲ್ಲ. Next Friday ಏನ್ madam? 18th. No, next Friday, what's the date? 20th, sorry. List on 20th.
52.
A234 Kashkan. Next.
53.
The petition, my lord. No, we withdrawn one.
A withdrawal, we'll do it fast. Yes.
Lord, allegation offenses are 306 and
498A
498A,
and
my lord.
306.
Please, my lord. Lord, there are no specific allegations with respect to 306 of
Oh.
IPC, my lord. Lord, initially what had happened, the complainant has filed a complaint, my lord, on
1
23/8.
minute, sir. ಯಾವತ್ತು ಸರ್ವಾಗಿದೆ ನೋಡಿ?
13/7/20.
I will give one more chance.
Lord,
List
last
the
two
matter on
occasions.
24th in the fresh matters list. ಅದು withdrawn,
Connected.
ಇದು adjourned.
53.1 withdraw.
Huh?
53.1.
3.1.
53.1 is withdrawn. Memo ಇದೆ. Yes, next.
54.
What betting?
54, my lord.
Betting ಅಲ್ಲಿ ಬೆಟ್ಟಿಂಗ್ ಆಗಿ ಸಾಲ ತಗೊಂಡಿದ್ದು ಅಂತ ಅದಕ್ಕಾಗಿ ಎಲ್ಲ ಲೆಂಡರ್ಸ್ ಎಲ್ಲ they were threatening him, calling him, saying that
Yes, Tejas.
Lord, in this charge sheet is filed, my lord.
ಮಾಡಿ.
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಇಟ್
ಆಗಿದೆ.
recalled against.
ಆಗುಂಟು ಅಂತ ಹೇಳ್ತಿದಾರಲ್ಲ.
19/8, my lord, 24 charge sheet is filed. We are awaiting the C number, my lord.
But you then keep it with you.
ಆಗಿಲ್ಲ. ಇನ್ನು ಆಗಿಲ್ಲ. ನಾನು ಅದೇ
The petitioner is accused number
6 months.
accused number 6. He is drawn in crime number 90 of 2024 for the offense punishable under section 306 of the IPC. The allegation against the petitioner is that the deceased, that the
Husband of the deceased was
husband of the complainant.
ಅಲ್ಲ deceased, husband of the deceased was working in irrigation department and he had borrowed loans for cricket betting.
Husband of the
Husband of the
complainant ಯಾರು sir?
ಅಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಅಪ್ಪ deceased in ಅಪ್ಪ.
That the son of the complainant who was an employee in
ಅಲ್ಲ
the
son-in-law
of the complainant who was an employee in the agriculture department had borrowed certain loan and had indulged himself in cricket betting,
cricket betting,
in
IPL betting.
cricket betting, IPL,
betting.
in cricket betting. And due to certain losses, the amount of loan that was raised was sought to be returned by the petitioner and several others. The son-in-law of the complainant commits suicide. abetment charge is laid against these
ಅಲ್ಲ
petitioners.
son-in-law ಅಲ್ಲ, ಅದೇ daughter has committed suicide.
ಆಯ್ತು, ಡಾಟರ್ ಯಾರ ರಿಲೇಷನ್ ಕರೆಕ್ಟ್ ಆಗಿ ನಾನು ಕೇಳ್ತಾ
ಇಲ್ಲ,
ಇದ್ದೀನಿ,
ಅಲ್ಲಿ-
ಕಮಿಟ್ ಸೂಸೈಡ್.
ಅಲ್ಲಲ್ಲ,
ಅದನ್ನೆಲ್ಲ ಅಡ್ಜಾನ್ ದಿ ಮ್ಯಾಟರ್ ಬೈ 2 weeks.
ಅಲ್ಲಲ್ಲ, son-in-law was
Sir.
employed.
1 minute. Who commits
Committed
suicide?
suicide, complainant's daughter,
Complainant's daughter. Son-in-law was employed in agriculture
agriculture,
department.
he had borrowed.
Why did the daughter commit suicide?
ಅದೇ ಈಗ, that is the question.
ಅದೇ ಹಂಗ ಟ್ರಯಲ್ ಆಗ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ, that is the problem. ಅವನು suicide ಮಾಡ್ಬೇಕಿದೆ, ಅವನಿಗೆ ಫೋನ್ ಮಾಡಿದಾಗ she has committed suicide, that is the allegation.
How are you
My lord,
involved in this?
kindly come to page 60.
How are you involved in this?
ಅಲ್ಲ, they say that one of the lenders ಅಂತ, one of the lenders. My lord, kindly come to,
ಕೊಡಿ,
ಅಲ್ಲ,
records
page
ಕೊಡಿ.
16 ಅಲ್ಲಿ ಕೆಳಗಿದೆ. Last four.
This is not the way. Give it. Yes, you should be fast. List day after tomorrow in the fresh matters. Records ಕೊಡಿ. Next.
55,
In the meantime,
56,
55 ಇದರ ಇಲ್ವಾ? Yes, next.
56,
ಆಯ್ತು ಸರ್, ಕೊಟ್ಟಾಯ್ತು. Next. 143A.
The London magistrate has rejected the application and the
I know, emergent notice to the respondent.
in other petition, your lordship granted stay after service of notice.
Correct.
Same petitioner.
ಅವ್ರು ಬರ್ದೇನೆ ಕೊಟ್ಟಿದ್ದೀನಾ?
ಇಲ್ಲ ಬಂದ್ಮೇಲೆ ಬಂದೆ ಅವ್ರು appear ಆಗಿ
ಬರ್ಬೇಕಲ್ವಾ ಈಗ? ಬರ್ಲಿ. Yes.
57,
may be permitted to serve the copy on the
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. Yes.
date may.
All right. List on 24th in the fresh matters.
Please.
Yes.
57,
Same order. Same order. 58 to same. No representation list after 2 weeks. 2010 CC. ಈಗೇನ್ ಮಾಡ್ತಾ ಇದೀರಾ?
It's a PCR, my lordship.
So what? 2010
This is a
PCR.
matter settled, my
ಎಲ್ಲಿದೆ?
lordship.
Where is the settlement?
The endorsement is there, my lordship. I filed
Settlement
the
memorandum, where is the conditions of settlement? Where is the settlement?
There is only endorsement they are issued
Give
by
the
the
settlement
complainant.
copy. Get complete records, I'll take it.
So that is, I.
No, I'm
produced
not saying the endorsement. You should give me the settlement.
That is only settlement letter is there, my lordship. I produced.
Where is the memorandum of settlement? Before whom did you settle? Which court did you settle?
Before not court, that is before the parties, the matter was settled. And prior to this
Where?
complaint,
Where did you settle? Where are the terms of settlement? 2010 the sir ido.
house.
Yes, list the matter.
There is annexure A, my lordship. There is a page
No, no.
number 14.
Get the complainant. Get the complainant, we will hear and then see if settlement is there, we'll close it. Petitioner shall serve on the complainant.
There is a page number 14, my lordship.
No, sir. ನೀವು ಇದೀರಾ? Respondent.
No,
Next matter.
Next matter. ನೀವು
Fresh
fast
matter.
ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಾ. ಆಯ್ತು ಸರಿ.
the fresh matter, my lordship.
Fresh matter, correct. Emergent notice to the respondent. Next.
of license.
60,
I am per respondent number 2.
Keep it to emergent notice. ಅಷ್ಟೇ.
There is an interim matter subsisting in this matter.
Why did it get posted then?
I am per respondent number 2.
Vacating stay ಹಾಕಿದ್ದೀರಾ sir?
They have not filed, they are yet to file their response, my lords.
File your
Okay,
objections.
Investigation ಗೆ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ ಗೌರ್ಮೆಂಟ್ ಇವ್ರಿಗೆ.
ಇರ್ಲಿ, ತೊಂದರೆ ಇಲ್ಲ. ಎಸ್, ನೀವು objections ಹಾಕಿ. List the matter on 24th September. Objections, if any, by the respondent by then. Interim order subsisting will continue till the next date of hearing.
Great.
61,
Yes, get the investigation papers.
So it is submitted, my lord, in this matter.
Oh, ಇದೆಯಲ್ಲ, ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ, sorry. Yes. No representation on behalf of the petitioners list after 2 weeks. Registry is directed not to list the matter prior to the expiry of 2 weeks. Next.
62,
Same order.
63,
Number 1 and 2 before this on report, my lords.
Hello, what are the 2 crimes?
My lords, he has filed two other private complaint before this very same court.
This is PCR of 2013. Which are the other crimes?
Other crimes, my lords, at page number 176 and 182, my lords.
At what
PC
stage they are?
My lords, this honorable court stayed the further proceedings in this.
Number ಕೊಡಿ ಅದೆಲ್ಲ.
My lords. 1352 of 2023 and.
ಬರ್ತ್ ಕೊಡಿ ಸರ್.
Please.
ಎರಡರಲ್ಲೂ ಸ್ಟೇ ಇದೆಯಾ?
ಎರಡರಲ್ಲಿ ಇದೆ.
The learned counsel for the petitioner. The petitioners petitioner accused number 1 is before, petitioners accused 1 and 2 are before this court calling in question proceedings in CC 50 of 2015. Though the matter is of vintage today, what merits entertainment is the projection of the petitioner that the present crime is the third in line, 2 of which are registered before the very same court and both of which are stayed at the hands of this court in so and so. Tag this petition along with so and so, there shall be an interim order of stay of further proceedings, for the proceedings in CC 50 of 2015 till the next date of hearing. Emergent notice to the respondent.
Notice served Swami. Yes, represented.
Idara?
Idar.
Illidare. Charan Kumar. Anyway, no representation. We have the respondent and Baradu. Ameli order ಮಾಡಿ. Next.
Oblige.
64.
ಎಲ್ಲಿದೆ ಕರ್ನಾಟಕ ರೇಸ್ ಬೆಟ್ಟಿಂಗ್ ಇಲ್ಲದೆ ಇರೋ ಸೆಕ್ಷನ್ ಎಲ್ಲ even charge sheet is filed. What do you file? Mysore race betting act is okay. Karnataka race betting ಎಲ್ಲಿದೆ? That is repealed.
Any of stay is there, my lord, day after tomorrow.
List the matter on 24th in the fresh matters. This interim order subsisting shall continue to the next date of hearing.
65.
306 and 120 P, my lord.
Huh?
306 and 120 P.
Correct.
The complaint allegations is, my lord, at page number 21. my lord.
506 part 2, sir. 306 and 506 part 2.
Yes.
The records have been submitted, my
You have
lord.
to file discharge. No question of interference.
That there is no allegation against the
No,
petitioner, my lord.
Anything else? We'll only adjourn it if you don't. Yes. No stay. Yes, sir.
Notice may be issued.
1 HCGP, 2 emergent notice. Pendency of this petition will not come in the way of further investigation or proceeding. Return the papers. Next.
Kindly pass over, Lord, senior is on his legs in Court Hall 4, kindly pass over.
Interim order in Kodala, sir. 7A.
But there is a prima facie material, Lord.
ಎಲ್ಲದರಲ್ಲೂ prima facie material ಇಲ್ವೇ ಇಲ್ಲ.
Kindly pass over.
Yes, list on 20th in the fresh matters list. Next.
67.
In this matter, I appeal for the petitioner. Not the respondent, not the executed a shielding.
Yes, sir.
For rupees 2 crores 10 lakhs. Not 90 lakhs has been not transferred to RTGS.
Yes, sir.
Not remaining 1,20,000 was remaining. Not he has issued, not the petitioner herein has issued being accused, not he issued six checks, not which spread over to 6 months for not the payment.
All right.
2 payments were made, not
All right.
other not 4 checks, not so what happened, not when I went to the possession, not his wife and children came and locked the house stating that they are having the right over the property.
Oh.
Immediately, my lord, she approached the High Court of Bombay, my lord, judicature,
Oh.
for my lord, the seeking for declaration and my lord, for my lord, removing the lock and all.
Oh.
My lord, he came from my lord, Bombay to my lord, the Coorg. My lord, filed a my lord, initiated my lord, the check bounce case against the my lord, the petitioner herein, stating that my lord, he had issued a check. My lord, since my lord, the matter is pending before the my lord, the Bombay High Court for my lord, the adjudication. Not here, not during the pendency of not the proceedings. He died, not his second wife, not continued with the proceedings. Not I have sought for not the stay.
Get the respondent.
Not here, not this is not clear case. May I take
Please,
page number 21, not
counsel for the petitioner to serve on the counsel who represents the respondent. No stay, sir. Counsel for the petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement to that effect. List the matter on 20th in the fresh matters list.
There are 4 checks, not 4 petition numbers are there, not so I will give. All are not ready for only 2 today, not it is listed.
Move it, yes. ಇವತ್ತು ಒಂದೇ ಇರೋದು.
ಅಲ್ಲ ಎರಡಿದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ?
ಇನ್ನೊಂದು ಸೀರಿಯಲ್ ನಂಬರ್ 73 ಇದೆ.
ಆಯ್ತು ನೋಡುವ.
And other 2 are.
Yes, next.
68.
My lord, 2/3/2019, my lord, charges framed, my lord. Now, 7 witnesses have already been examined in this.
The learned HCGP on instructions would submit that the instructions and verification of the records would submit that the charges are framed in the year 2019 and the matter is set at the stage of trial and trial has advanced to a large extent. even otherwise, perusal at the summary of the charge sheet would clearly indicate an assault by iron rod on the respondent wife. In the aforesaid circumstances, entertainment of the petition is not warranted. Disposed, reserving liberty to the petitioner to urge all the contentions before the concerned court. Next.
69.
The matter has been stayed against accused number 1 and 3.
Recovery of money, give it. Yes. Tag this petition along with so and so. Counsel for the petitioner submits that this court has granted an interim order of stay. The co-accused, the order reads as follows. In that light, there shall be an interim order of stay qua the present petitioner as well. 1 HCGP to emergent notice, tag the petition. Next.
Obliged, my lord.
70.
Against the co-accused, please, my lord, coordinate bench has stayed against accused number 7, producing the order copy, please.
But you are what accused, sir?
My lord, I am accused number 2, please, my lord, accused
Exactly.
number 1, accused
Accused
number 1
number
is my
7
wife.
stay mandra ಆ ಕಾರಣ.
Allah, accused number 1 is my wife, please, my lord.
Exactly.
Exactly, please, what happened, what has happened, please, my lord? Just because she is being my wife, my lord, she has access to my laptop and the internet connection, please, my lord, where the petitioner, this petitioner is being.
Get the complainant, sir.
Please, my lord. Complainant is the RTO, please, my lord, the investigation, and more so, please, my lord.
Direct record.
In the
statute ಆಗಿದೆ.
complaint, my lord, in the complaint, he would refer, there are 386 illegal transaction, please, my lord, but in the.
A7 stay ಮಾಡಿರೋದು different ground.
Allah, in the computer, my lord, in the FSL report, they would only show 40 transaction, please, my lord. In the further statement of the complainant also, it reflects only 40 transactions, he would further state. My lord, the remaining, please, my lord, is something fishy, please, my lord, the complainant in order to, please, my lord.
Will issue notice.
My lord, my submission, please, my lord, he is, my lord, he is on his wife, please, my lord, as the allegation in the charge sheet in column number 17 would only reflect his wife role.
Correct.
My lord, just because, please, my lord, I am an husband.
Can
please-
you give up your wives?
My lord,
Can't you?
Allah, that is it there, please, my lord, what has happened, please, my lord? She used my-
ಸ್ಟೇ ಮಾಡಿ. ಕಮ್ ಟು ಪೇಜ್ 66 and 67. ನಿಮ್ಮ ಮೇಲೆ ಏನಿದೆ ಅಂತ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. 2ನೇ ಆರೋಪಿ 1ನೇ ಆರೋಪಿಯ ಗಂಡನಾಗಿದ್ದು ಸೋ ಅಂಡ್ ಸೋ.
Please, my lord.
Yes, sir.
Allah, that, my lord, what they would. My lord, ಅವನಿಗೆ process ಸಹ ಬರೋದಿಲ್ಲ. ಅವನು is not a technician, qualified technician, my lord, in order to, my lord, that is the
You
reason.
don't
please.
know, sir. Yes. Learned HCGP is directed to accept notice for the respondent.
My lord, date, if I may request, please, my lord.
List on 30th.
My lord, HCGP to take.
ಅದು ಹೇಳಿದ್ನಲ್ಲ. Yes.
71.
The petitioners. Complaint under section 406, 506, 420, read with 10 of
The main.
Immigration Act.
Hey, Mohan has come this side. Yes. Stayed, yes.
The affair for the petitioner, my lord.
52.
The affair for the petitioner.
ಆಮೇಲೆ I am for petitioner ಕೇಳಿಸ್ತೀನಿ.
I am challenging the crime number 237
ಆಮೇಲೆ
ಇದರಲ್ಲಿ 13 days delay ಇದೆ.
ಅಷ್ಟೇ.
ಅದರಲ್ಲಿ ಇನ್ಸಿಡೆಂಟ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂತ ಇದ್ದೇ ಇರ್ತಕ್ಕಂತ.
The petitioners are before this court calling in question proceedings in so and so. On an incident that happens on 17/6/2024, the petitioners register a crime against the complainant on 17/6/2024 itself in crime number 221 of 2024. Long thereafter, as a counterblast, on the same incident, verbatim similar complaint is registered against these petitioners by the respondent, complainant and others, which becomes a crime in crime number 227 of 2024 for it having been registered on 29/6/2024 without a speck of explanation for the delay of 14 days. Generally, delay of 14 days would not be fatal since the present crime registered against these petitioners is a counterblast. I deem it appropriate to stay further proceedings with these petitioners till the next date of hearing. 1 HCGP to emergent notice.
73.
ಇದು ಸೇಮ್ ಯಾವತ್ತು ಹಾಕಿದೀವಿ ಅದನ್ನ 20th ಲಿಸ್ಟ್ ಆನ್
Fresh matter list.
ಹ್ಞೂ ಸರ್, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್. ಮೇಡಮ್ ಯಾವ್ದು ಇವ್ರದ್ದು 6 serial ಇನ್ನೊಂದು ಯಾವ್ದು ಪ್ರಭೋದು 67 and 73. Tag them and list them. Yes, next.
24.
Jambu Bandari, yes. We'll dispose it.
There are two other connected matters, 7-7.
ಒಂದ್ ಹೇಳಿದ್ರೆ buy one get one free ತರ ಆಯ್ತು.
Alla,
Yes.
Milords has already granted stay in that matter.
Which is that? ಕೊಡಿ.
7730 and 7733 of 2020.
My memory is not strong, sir.
This
So
order will
write
be-
and give.
Yes, my lord.
Yes. They tag this petition along with so and so. There shall be an interim order of stay of so on. We'll list them all and close them.
Certainly.
List on 20th.
75.
My lord, in this case.
Only if charge is not framed, I will grant stay on that condition.
My lord, kindly peruse the page number 109. Your Honor.
Charge frame ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮಾತ್ರ stay ಕೊಡ್ತೀವಿ.
Charge framed, but she is living with another person with two children.
That's a matter of trial.
Kindly peruse.
ಅದು
the
ಏನು
page.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ 4 to 7 ಮಾತ್ರ ಕೊಡ್ತೀವಿ. Because 4 to 7, 69, 62, 68 years. ಅದಕ್ಕೆ.
Even though trial court is
No.
compelling the all the accused present.
No,
upon
no,
hearing itself.
compelling ಅಂದ್ರೆ all the accused persons ಹೋಗ್ಲಿ.
My lord, 1 year back, she itself filed a memo before the trial court in the.
ಅದೆಲ್ಲ matter of trial
this
ಮಾಡ್ಕೊಳ್ಳಿ.
matter. Kindly peruse
Yes, if
109.
charges are framed, I will not interfere. But ಆದ್ರೂ ಈ 4 to 7, they are all 65 years. ಅವ್ರ ಮೇಲೆ ಏನೂ ಇಲ್ಲ. ಇವ್ರ ಟೈಮಿಗೆ ಬರಲ್ಲ.
My lord, in last 1 year, she appeared only one day. Your
No,
Honor.
no, I
That
will
day
direct
itself she
I will direct the trial court to conclude the trial within a time frame.
My lord, kindly peruse 109, my lord, please, my lord. That memo filed before the trial court in 676 of 2018 at the DV Act matter, Your Honor. That in that memo, she stated that Sadari ಅರ್ಜಿಯಲ್ಲಿ ಆರೋಪಿಸಿರುವ ಆಪಾದನೆಗಳು ನಿರಾಧಾರವಾದವುಗಳು. Same complaint in this case also, Your Honor. In 498 case also in the same allegations, which have alleged in the.
We'll see,
DV Act.
get the complainant. 1 HCGP 2 emergent notice returnable by 26th.
Please.
26.
ಇದು ಅಷ್ಟೇ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ವಾ?
Framed, my lord, on 7/12/22
Allegation
ಅಲ್ಲಿ
of
charge.
506.
Before filing of petition or after? 506 is not the problem, 509.
9.
Yes.
The only on the reason that my lords cursed ಅಂತ ಹೇಳಿ. Cursed that
Whatever, 509 is
reason-
the problem in this case, 506 is okay.
when we go through
Charge
the
ಯಾವಾಗ
complaint
after
and
filing?
charge sheet.
7/12/22, my lord.
No, man.
My lords, here, my lords, only the reason why the 509 has been included, my lords, allegation is that cursed that due to your attitude, your son is suffering so. That is the reason. Only this, my lords.
ಅದ್
If we go
ಮುಂಚೆನೆ
through,
ಬರ್ಬೇಕಾಗಿತ್ತು. Why did you not approach the court? Now the matter is at trial. 506, yes.
it's like, my lords, the
No,
process
madam,
itself,
that's-
my
Yeah,
lords,
I've been closing petitions. I will direct the court to conclude the proceedings within 6.
this is first time it has come, my lords.
So, first time dismissal.
The complaint itself.
Otherwise, you
is
want to
about-
settle with the complainant, you settle. If she is prepared to settle, because 6 ವರ್ಷ ಅಲಿಸಿದಾರೆ,
Yes,
ಅದಕ್ಕೆ
yes.
ಏನಾದ್ರು ಸೆಟಲ್ ಮಾಡ್ಕೊಂತಾರೆ ಮಾಡ್ಕೊ.
ಅದು
ನೋಟಿಸ್ ಮಾಡ್ತೇನೆ ಅಷ್ಟೇ. Only for the purpose of settlement, otherwise will not come in the way. The 1 HCGP 2 emergent notice returnable by 30th. If she comes forward for settlement, we'll see.
77.
OS number ಏನು?
995/2000.
The petitioners, who has instituted complainant?
Petitioners
The
here,
petitioners have instituted OS 99,
5/2017.
so and so. Immediately thereafter springs the impugned crime. In a matter that is purely civil in nature, criminal law cannot be permitted to be set into motion. Therefore, there shall be an interim order of stay of so and so. Next.
8.
CC 2018. ಏನಾಗಿದೆ ಈಗ? ಇಲ್ವಾ? ಗೊತ್ತಿಲ್ವಾ? CC of 2018, discharge rejected on November 2020. Petition filed on 10 July 24. ಹರೀಶ್ ಭಂಡಾರಿ, ನಿಮ್ದೇ ತಾನೆ?
ಹೌದು.
ಅದೇ ಡೇಟ್ಸ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ, ಬೇರೆ ಏನು. So dismissed. Anything else?
ಅಲ್ಲ,
Not a case for stay at all.
Yes, lordship, because A2, your lordship, kindly refer to your lordship. He was only the representative, your lordship.
We'll see. 1 HCGP 2 emergent notice.
Representative, Is the different than?
Next.
29.
For the petitioners, my lords, husband's
Husband.
petition, please, my lords.
File discharge.
My lords, there are no grounds made out, my
Ah,
lord,
Yes.
kindly, my lords may kindly see on 16
Please, sir.
23, my lords.
ಏನ್ ಬರಲ್ಲ page 44 ಅಲ್ಲಿ second paragraph ನೋಡಿ sir, unnumbered. Yes.
My lords, to that my explanation is this, my lord.
Explanation trial.
Notice may kindly be issued, my lord, later.
But you have to file, better file discharge.
Notice may kindly be issued, my lord.
One HCGP 2 emergent notice, pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
80.
For the petitioner in this matter, my lords, petitioner is a coffee estate owner.
Correct.
In Kodagu.
RFO is the complainant.
Please, my lords.
Yes.
My lords, the course of action is that, my lords, on the date of incident, my lords, a herd of elephants enter the petitioner's property. They start vandalizing the property because one elephant, my lords, was carrying and it gave birth to its calf. My lords, naturally, it starts clearing of a certain, the yield of the petitioner gets vandalized, my lords. My lords, he calls the forest officials, forest department. The respondent number 2 comes almost 8 hours after him calling.
As usual.
My lords, please, that is the reason, my lords. The petitioner threatens him to threatens to file complaint.
Allegation ಇದೆ ಕೈಯಿಂದ
Allegation is page 23.
My lords, allegation is there. The
If
only
it is
material
there,
record, the only material on the record is a
Emergent
phone
note,
certificate.
learned HCGP is directed to accept notice for the respondent. Ibru, respondents.
Yes.
Next.
My lords, framing of charges is on 310, my
No
lords.
problems. Yes.
81.
Same order earlier, interim orders ಅಲ್ಲಿ ಕೊಡಿ. Tag this petition along with so and so. Same order.
Petition number 2 to 7 are the in-laws, my lord.
Correct. Accused number 1 and accused number 4, I will not grant. Others I will grant.
4 is sister.
No. You look at the allegations against her.
Please.
Wherever I will grant. The petitioners are accused 1 to 7. Have knocked at the doors of this court calling in question proceedings in CC 16685 of 2024 registered for offence punishable under section 498A 504 506 149 of the IPC. A perusal at the complaint, the summary of the charge sheet would clearly indicate certain offences offences against the husband and certain offences against the accused number 4, the sister-in-law. Other accused, there is not even a sprinkling reference to overt acts committed by them for it to become an offense as alleged. Therefore, except accused number 1 and 4, there shall be an interim order of stay qua others. It is made clear further proceedings before the concerned court are not stayed qua accused number 1 and 4 and the same shall continue. List on HCGP 2 emergent notice.
Public.
Next.
83.
For the petitioners, man, it's accused number 4, man, 306.
Ah.
Accused number 8, 9 and 10, they granted stay by this law. Interim order 4, accused number 8, 9 and 10.
You are what, sir?
Accused number 4, my lord. Allegation that, my lord, 11 months before, my lord, he has completed work, my lord. I have asked for the bribe.
Page
that is-
44, sir.
44 is the interim order, my lord.
We'll tag with that, sir.
My lord, in the allegation.
Tag ಮಾಡೋದು ಬೇಡವಾ?
Same
Same order, ತೊಗೊಳ್ಳಿ. Page 44 order.
2 petitions.
ಇನ್ನೊಂದು ಯಾವುದು?
Page 43.
43 and 44. Tag with those. Same order, interim order. Next.
84.
Charge sheet is filed, my lordship.
For petitioner.
Even otherwise 376 2 and not a case for interference at all.
The consent, my lord.
No, you consent? No, sir.
The contents of the complaint shows that, my
No,
lord,
not in
the
this
incident
case.
happened in the September 2023, my lord. Complaint has been filed, my lord, February, my lord.
No, it was not a consensual act at all. Yes.
Please, my lord.
No, sir.
Consensual, my lord, because, my lord.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಚಾಲೆಂಜ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ ಇಲ್ಲ ಐ ವಿಲ್ ಗಿವ್ ಮೈ ಫೈಂಡಿಂಗ್ ನೋ ಪ್ರಾಬ್ಲಮ್ ಐ ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್ ನೌ ನಾಟ್ ನೌ ಟುಮಾರೋ ಐ ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್ ಅಂಡ್ ಗಿವ್ ಮೈ ಫೈಂಡಿಂಗ್
I'll
ಚಾರ್ಜ್
challenge
ಶೀಟ್
the
ಚಾಲೆಂಜ್
charge.
ಮಾಡಕ್ ಲಿಬರ್ಟಿ ಎಸ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫಾರ್ಮ್ಯಾಟ್
85.
Additional insisted.
504, 506 and 307.
ಏನು ಚಿಕ್ಕದು ಹೇಳಿ ಆಮೇಲೆ ದೊಡ್ಡದು.
Husband and wife.
7 sir.
The matter has been settled.
Settled
Joint affidavit
husband and wife.
is present, parties are present.
Yes, government. Husband and wife 307. What did you do for 307?
ಮಗು ವಿಷಯದಲ್ಲಿ ಏನೋ ಗಲಾಟೆ ಆಗಿ
Where is the member, where is the settlement?
Joint memo.
my lordship.
Huh?
Charges are framed.
So what, settlement avagale agak sir.
Page number 7, madam.
Page number
7,
of what?
petition. Joint affidavit.
Joint petition.
Affidavit has been, illa. Joint affidavit has been.
Where are you from?
Devanalli is matter. They are from Nepal.
Nepal. Where are you from? Devanalli.
The matter is pertaining to Devanalli.
Yes. ಯಾವ್ದ್ರ ಸೆಟಲ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ ಕೊಡಿ.
ಅದೇ ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್ ಅಷ್ಟೇ. ಅದರಲ್ಲಿ
ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್
ಪೇಜ್ ನಂಬರ್ 7 ಮೇಲೆ ಆಫ್ ದ ಪಿಟಿಷನ್.
ಪಿಟಿಷನ್ ಹಾಕಿರೋದೇ ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್ ಸರ್. The petitioner is the husband, the second respondent, his wife. The two had a squabble and the squabble led to registration of a crime in crime number 47 of 2022 for offense punishable under section 307, 504 and 506 of the IPC. During the pendency of the petition, the parties to the list have resolved the dispute amongst themselves and have filed a joint affidavit through this petition, seeking compounding of the offense. Since though the offense is the one punishable under section 307 of the IPC, which cannot be quashed by way of by way of acceptance of a settlement, since the issue is between the husband and the wife and the complaint not meeting the ingredients of section 307 of the IPC, I deem it appropriate to accept the joint affidavit, compound the offense and give a quietus to the proceeding. In that light, for the aforesaid in the following order. Disposed, quashed.
Great.
56.
Disaster management 51B in the meantime. Next.
87.
List the matter for admissions. Interim order ಇದೆಯಲ್ಲ? ಮತ್ತೆ
R2 undertaking.
learned counsel heard the learned
Grant 2
senior
weeks time
counsel.
to file occurrence.
ಕೊಡ್ತೀನಿ. Heard the learned senior counsel G. Krishnamurthy appearing for the petitioner. The learned counsel so and so undertakes to enter appearance for the respondent and would seek 2 weeks time to file statement of objections. List the matter on 26th. Interim order subsisting shall continue to the next date of hearing. Yes, sir.
Rejection of application 456, my lord, we are before the court. Lord, the
Notice
emergent.
emergent. All right.
59.
In the meantime, till the next date of hearing, list the matter on 24th in the fresh matters list, the learned HCGP to secure the investigation papers till date and place it before the court. Next.
90.
90. In the meantime, next.
Connected matter.
Kodi, tag the petition along with so and so in the meantime. Nanjundegaudre, page 43.
My last, may kindly look into the wound certificate.
Simple in nature.
No,
So
there are
there is a
there are
wound.
no external injuries. And
There
more
is a
so,
wound.
Lords, may kindly refer to page number 42, my lord.
In the meantime, yes.
Please.
Next.
92.
CC of 2019,
Yes, my lord. Petitioner is accused number 4, my lord. Accused number 1, 2, 3 and 5 have been acquitted by the trial court.
acquitted,
Yes, my lord.
split charge. I
Yes,
think.
my lord.
Then we'll day after tomorrow in the fresh matters list.
Oh, bless.
Next.
Proclamation is issued against the accused.
Then go appear, sir.
And charges are
My lord.
framed on.
That's all right. Split charge will charge free. Proclamation act.
Yes, my lord, because my lord complainant have, my lord, again, you have filed 2 more cases, my lord, by filing
I
PCR
will
again.
see on Wednesday.
Oh,
Yes,
bless.
next.
93.
Notice only.
On my lords. My lords, earlier there's a stay, my lord, of the
In
FIR.
which? Kodi,
In the very same matter. Annexure M may kindly be seen. my lords. In
page.
Annexure M, page 322. Lord, interim order at page 324. Further investigation was stayed.
1 minute, 1 minute. Sir. Even then they filed charge sheet.
Yes,
320,
324.
the counsel for the petitioner takes this court through an interim order granted by the coordinate bench dated 14/12/2023, eque the same petitioner. The contention is that in the teeth of the subsistence of the interim order, charge sheet is filed by the jurisdictional police. In the light of the aforesaid reason, there shall be an interim order of stay of further proceedings, square the petitioner till the next date of hearing, 1 HCGP 2 emergent notice. Next.
94.
For the petitioners, my lord. The petitioners are accused number 2 and 3, my lord. The first accused was working with working as a manager in the jewelry shop of R2.
Correct.
But these petitioners are nowhere concerned there. The petition number 2 is residing in Bangalore. That is is working as a software engineer. It has nothing to do with the transaction in between accused number 1 and R2.
1 HCGP 2 emergent notice.
Date.
No.
Let the ಯಾವ್ದಾದ್ರು
Early, 26th.
ಅಲ್ಲ let them point out. ಇಲ್ಲ
He will
material
point out. Let the complainant come, he will point out. Yes.
ಅಲ್ಲ ಅದಕ್ಕೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರೆ ತಾವು
26th, sir. Yes.
Fine.
Emergent notice returnable by 26th, list on 26th and the fresh matters list. Adu
private-
previous matter. 90,
95, private complaint without.
case and counter case.
ಅಲ್ಲ, case and counter case ಆಗಿದ್ರು after lapse of 6 months, please, my lord, they filed a private complaint without an affidavit. And one more point,
In
please,
the meantime, yes, next.
my lord,
Bedwa.
PCR, ಅಲ್ಲ, ಇರ್ಲಿ.
Irli.
PCR records to be called for, please.
We'll see, yes. Sadyಕ್ಕೆ ಇರ್ಲಿ. Yes.
96.
8 and 8, ಇದರ 96 ಗುಹಾ. ಈ ಕಡೆ ನಿಮ್ದೆ ಬನ್ನಿ ಸರ್. Yes. A2 and A3 in the main, ಇದು ಕಾಶ್ಖಾನ್. Yes, next.
84.
ನಿಮ್ಗೆ ಯಾವ ಕೇಸ್ ಒಂದು ನಿಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ.
94, 8460.
94 94
96.
Yes.
87.
97 ನಡೀತಾ ಇದೆ, 96 ನಿಮ್ದು. ಓದಿಲ್ವಾ? ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಇದ್ದೀರಾ? ಈ ಕೇಸ್ ಓದಿಲ್ವಾ? ಎಸ್, ಸ್ಟೇಡ್ ನೆಕ್ಸ್ಟ್.
97. I am referring to the petitioner.
ಮೇಂಟೆನೆನ್ಸ್ ಎಷ್ಟು ಇದೆ ಅರಿಯರ್ಸ್?
That maintenance was stayed by this court, that in a connected matter.
ಆಯ್ತು, what is the-
8,000 was ordered.
ವಾಟ್ ಈಸ್ ದಿ ಅರಿಯರ್ಸ್ ಟುಡೇ?
Arrears is that, that already that
I am,
application,
don't beg the question, sir, direct answer. Arrears ಇದೆಯಾ ಇಲ್ವಾ?
there is no arrears.
No arrears.
Because of that, that in the divorce petition was already granted.
Arrears ಇದೆಯಾ ಇಲ್ವಾ?
Arrears is this one.
ಹಾ,
But that was stayed by this court in connected.
ಇರ್ಲಿ. ಅರಿಯರ್ಸ್ ಎಷ್ಟಿದೆ?
Arrears, I will not calculate that.
1 lakh ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ? ಐ ವಿಲ್ ಸ್ಟೇ.
At 50,000.
ಅದೇ ಬಾರ್ಗೇನ್ ಇಲ್ಲ.
Because of that, that there is no marriage relations between the petitioner and.
ನೋಡೋಣ,
respondent.
ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ ಹೇಳ್ತೇನೆ.
That divorce petition, decree of divorce has been granted.
We'll see, sir, you deposit before this court. Because you're in huge arrears there. Yes, the
50,000.
emergent notice to the respondent returnable by the 30th of October. List the matter on 30th of October in the fresh matters list. There shall be an interim order of stay as prayed for, subject to the condition that the petitioner would deposit 75,000 before this court by the next date of hearing. Yes.
50,000, that. Make it 50,000.
No, sir,
Yeah.
won't make it.
No work at all, that.
No
husband,
making it. Yes.
It is heavy. 50,000, that. Your lordship.
Sir, in bargain.
No
1.5 lakhs then. I'll make it 1 lakh. Yes, next.
8 for the petitioner.
90?
8 my lords.
CC of 2015, sir.
But I'm challenging an order, my lords.
What order?
Witnesses were dropped, my lords. If my lords were to peruse order dated 13/9/2023, my lords. Ink page.
ಯಾರ್ದು? ಇವ್ರದ್ದ? ಅದೇ. That is different. That will stay the maintenance.
Ink page 58.
ಮಾಡ್ಬೋದು.
Ink page 58, my lords. Even though issuance of notice and proclamation, my lord, CW 1 and 2 does not appear. CW 1 and 2 are dropped from this case. Issue summons to CW 3 and 5, my lords.
Why you did not appear?
No, I am for the accused number 2, my lords. CW 1 and
TW 1 and 2 have not appeared.
Yes, my lords. Thereafter, on an oral request, my lords, without an application at a 311, my lords, court recalls them and examine, my lords. On 18/6/2024.
What's the prejudice cost to you, sir?
No, without an application, I have not been granted an opportunity, my lords.
311 application ಇರ್ಲಿಲ್ವಾ?
Hakilla.
Those witnesses had been discharged?
Yes, dropped, my lords.
Dropped. Heard the learned counsel appearing for the petitioner. The petitioner calls in question an order dated 18/6/2024 passed by the concerned court, allowing an application under section 311 of the CRPC. Permitting CW
1 and 2, my lord.
1 and 2, who had been dropped on account of them not cooperating with the trial, to come back as witnesses without any application being filed. There appears to be a procedural aberration till the respondent complainant error.
Complainant is de facto respondent number 2, my lord.
Till the state would go through the papers and make submissions, the order dated 18/6/2024 shall remain stayed. It's made clear for the trial is not stayed at the hands of this court. List on 25th on the fresh matters list. Next.
99.
My lord, 406 and 420. Petitioner is accused number 4, my lord.
ಆಯ್ತು ರಿಟರ್ನ್ ಮಾಡಿ 2.13 crore.
ನಾವ್ ಇಸ್ಕೊಂಡಿಲ್ಲ ನಮ್ಗ
ಯಾರು
ಟ್ರಾನ್ಸಾಕ್ಷನ್
ಇಸ್ಕೊಂಡಿದ್ದಾರೆ?
ಅವ್ರು 1 and 3
ಹಾಗಾದ್ರೆ ಅವರೇ ಬಂದು ಹೇಳಿ ಯಾರು
1 and 3 ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದಾರೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ.
ಎಲ್ಲಿದೆ?
ಹೇಳಿ ಸರ್. ಪೇಜ್ ನಂಬರ್ 14, my lord.
ಯು ಆರ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1, ಸರ್.
4, my lord. I am 4. Sorry, my lord.
4
4.
ನಿಮ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ನೋಡಿ.
Sorry, my lord. 4.
ಹಾಗಾದ್ರೆ ವಿಲ್ ಸ್ಟೇ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1.
4, my lord.
In the meantime, proceedings shall remain stayed qua accused number 1. ನೀವ್ ಹೇಳಿರೋದೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Sorry, accused number 1.
ಅದಕ್ಕೆ ರೆಕ್ಲೆಸ್ ಆಗಿ ಹಾಕ್ಬೇಡಿ.
Sorry.
Yes. Correct ಮಾಡಿ. Qua accused number 4, the petitioner. Next.
100.
For petitioner. That is the offense is in 324, 332.
Case for settlement actually. Yes, anyway.
He is an advocate also, Your Honor. Petitioner, she is advocate.
One
Same
emergent
intention.
notice, one HCGP, 2 emergent notice. Returnable by 26th, there shall be an interim order of stay of further proceedings qua the petitioner till the next date of hearing. Yes, settle ಮಾಡ್ಕೊಳ್ಳಿ.
Definitely.
It's a case for settlement, yes. 1.
For the
Yes.
petitioner in this case, my lord. 304A, my lord, accused of that.
A1 ಗೆ order ಮಾಡಿದಲ್ಲಿ.
A1 is already.
Where is the order?
My lord, I produced it in page number 94, my lord. Settlement was arrived, my lord, and this is accused number 3 and 4. They have been made as parties only as their site manager and he was the manager and the other one was a
Page
site engineer.
93. Page 93. 93 ತಾನೆ?
94 ಅಲ್ಲಿ ಇದೆ.
93 ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
Okay, apologies.
ಅದು ಯಾವ accused?
Accused number 1 was FIR was quashed against accused number 1.
Accused number 1, this court quashed the proceedings. Again, accused number this court quashed the proceedings on account of a settlement arrived at between the parties. In that light, the petitioner being accused number 2 and 3.
3 and 4.
3 and 4, who are site managers and who had nothing to do with the alleged site manager. Nothing to do ಹೆಂಗಾಯ್ತು?
Site engineer.
Accused number 1 ಯಾರು? What was accused number 1?
He was the CEO, my lord. He was the CEO of the company along with MD, managing director.
Yes, government.
The allegation is only with respect to A2, my lord. That
A2 ಯಾರು?
JCB operator ಅವರೇ ಮಣ್ಣು ತಗೊಂಡೋಗಿ ಹಾಕಿರೋದು ಅಂತ ಹೇಳ್ತಾರೆ. Only with respect.
ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸೈಟ್ ಮ್ಯಾನೇಜರ್ ಆಗಿ? You are responsible.
ಅಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರು A3 ಮತ್ತೆ A4 ಇರೋದ್ರಿಂದ ಅವರದ್ರಲ್ಲಿ ಅದು is not at all related as on that day.
Will not dispose it.
ಅಲ್ಲ.
The emergent notice to the 1 HCGP 2 emergent notice returnable by the 30th of October, list on 30th of October in the fresh matters list. Till such time further proceedings qua the petitioner shall remain stayed.
102.
Yeah, for petitioner also.
Accused 2 to 6, Kash Khan. Big. September 30. One not 3, notice.
103.
No, ಇದು ಯಾರಿಲ್ಲ, but notice to the respondent, victim. Yes, same order ಕೊಡಿ.
Victim's petition.
ಅದಕ್ಕೆ ನೋಟಿಸ್ ಮಾಡಿದ್ವಿ. ನೋಟಿಸ್ ನೀವು ನೋಟಿಸ್ ಅಥವಾ ಬೇಕಾ ಯಾರಿಗಾರು ಬೇರೆ?
She has challenged the PW 19 ಕೆಲವು ಡಾಕ್ಯುಮೆಂಟ್ ನ ಮಾರ್ಕ್ಸ್ ಮಾಡಿ ಮಾರ್ಕ್
ಆಯ್ತು,
ಮಾಡಕ್ಕಿಲ್ಲ.
Certain documents were seized under a major.
All right.
And notice to second respondent. Second respondent in custody, I may be permitted to serve notice on the counsel representing the second respondent.
Counsel for the 103 ಅಲ್ಲಿ 1 HCGP 2 emergent notice. The second respondent is said to be in custody. Therefore, the learned counsel of the petitioner is permitted to serve on the counsel who represents the second respondent. Yes.
Please, ma'am, great.
Next.
104.
78-3 dispose ಮಾಡಿದ್ವಲ್ಲ ಅವತ್ತು?
ಒಂದು
ಏನು?
ಮಾಡಿದೆ ನಾನು 2/9/2024 ಇನ್ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ 8196
ಬರ್ಕೊಡಿ.
ಬರ್ತೀನಿ.
Disposed. Next. Rajendra Reddy.
105.
Offence punishable under section
304. ಅಲ್ಲ negligence.
negligence.
Lineman. No. Yes, one HC.
There is
Complainant ಯಾರು?
some defect of complaint.
One HCGP2 emergent notice. Next.
6.
Non-signatory to the check. In the meantime, emergent notice to the respondent. Next.
107.
Already the connected.
192 A.
Connected matter stay ಆಗಿದೆ.
Tag this petition along with so and so. In the light of the interim order subsisting in the companion petition, there shall be an interim order of stay in the case at hand as well. Next.
108.
For the petitioner, my lord, dispute between family members. I filed a complaint. My mother and brother filed a counter complaint. That counter complaint, your lordship has stayed.
Yes, give it. Heard the learned senior counsel Pramod Nair appearing for the petitioner. The dispute is between the members of the family. It is a case and a complaint and a counter complaint. In the counter complaint, this court has granted an interim order of stay in terms of its order dated so and so. 24/6/24. The interim order reads as follows. In the light of the interim order granted, the counter complaint, there shall be an interim order of stay in the case at hand as well. There's a matter for settlement, settle it.
It is, my lord.
Yes. Tag the
Right.
petition with so and so, list on 30th September. Yes.
109.
498A.
Charge sheet has, CC number has come, my lordship.
Even otherwise, only 4 to 8, 2 and 3 ಇಲ್ಲ. Challenge ಮಾಡ್ಬಿಡಿ. Yes, charge sheet file ಆಗಿದೆ, format. Yes, next.
110.
and 498.
Accused number 13.
Yes, my lordship.
ಏನು ಇಲ್ವಾ?
Before registering FIR, my lordship, I resigned the job, my lordship,
No, sir.
and pay the entire amount also, my lordship.
See page 28.
Yes, my lordship.
ಅದು
But
ಪೂರ್ತಿ ನಿಮ್ದೇ ಗುಣಗಾನ ಇರೋದು.
yes, my lordship, but
Yes.
entire amount also paid, my lordship.
Let's see. One HCGP2 emergent notice. Next.
111.
Girinagar, same order, madam. Where are those orders?
Please.
ಇನ್ನು ಉಳಿಸ್ಕೊಂಡಿದ್ದೀರಾ?
There are 3 petitions pending, ma'am.
ಕೊಡಿಯಲ್, yes. Give that. Same order. ಅದು 2:30 post ಮಾಡಿಸಿ, ಅದು ಮುಗಿಸ್ಕೊಂಡು. Yes, next.
Much obliged.
112.
Hearing for petitioner, my lord.
A1 ಇಲ್ಲ, ಮಿಕ್ಕವ್ರು ಕೊಡ್ತಾರೆ.
One submission, my lord.
ಹೇಳಿ.
After separation, my lord, the petitioner number 1 filed a petition for divorce, my lord. And the respondent filed a petition for DV Act, my lord. That came to be rejected, my lord. Thereafter filed a PCR, my lord.
All right, list them. One HCGP2 emergent notice. There shall be an interim order of stay for the proceedings quay the petitioners. Investigation ಏನು?
PCR.
So further proceedings before the concerned court quay these petitioners till the next date of hearing. One HCGP2 emergent notice. Next.
Then 30.
HCGP ಇಲ್ಲ. ಇದರ? Emergent notice to the respondent. HCGP. One.
I may be permitted to appear on behalf of the petitioner.
127A. Yes, sir. In the meantime, emergent note, who appears for the respondent? 113. 113, right, sir?
113, yes.
One HCGP2 emergent notice. In the meantime, yes, state.
ಅಲ್ಲ madam.
114.
ಇಲ್ಲ, people present in.
Yes, Nishit. Who is the tenant? Who is the landlord?
Brother, my lord, brother. It is between the brother, my lord. 37 years, my lord, after private complaint was filed.
The petitioners are before this court calling in question proceedings, complaint so registered for offense punishable under section 406 and 420. You are the tenant?
No, I'm the brother and he's saying that I'm a tenant. It was written in my wife's name.
The dispute is between the brother, dispute is between the siblings, and the complaint is registered after 36 years after the alleged incident. Therefore, there shall be an interim order of stay of further investigation. Quay these petitioners till the disposal of the petition. One and HCGP two
No,
emergent.
only one respondent, private complaint.
Sorry, HCGP, emergent notice to the respondent. Sir, next.
115.
List on 20th,
For the
13(1)B,
13(1)B of prevention of corruption.
20th, yes.
116.
ಅದು ನೋಟಿಸ್ ತಗೊಂಬಿಡಿ ಲೋಕಾಯುಕ್ತಾಗಿ. Learned counsel BB Patil is directed to accept ಇದರಲ್ಲಿ ಇದು ಮೇಡಮ್ 115 ಅಲ್ಲೇ. Learned counsel BB Patil is directed to accept notice for the respondent, registry to print the name of so and so is appearing for the respondent, petitioner to serve set of papers upon counsel Shri BB Patil. Yes, list on 20th.
Petitioners, my lord, please.
Who is in possession?
I am in possession of the property to
In the
establish.
meantime, next.
117.
For appear of petitioners.
Yeah, it's sir.
Please, my lord. ಅದು YS case ಅವರು CW6 ಮೇಲೆ ಪೆಂಡ್
117.
170.
Yes, sir.
CW6 ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಮಾಡಿಬಿಟ್ಟು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು ಮಾಡಿ.
Page 28, sir.
ಅದು ಫಸ್ಟ್ ಸ್ವಾಮಿ ಅದು ವಯಸ್ಸು ಆಸ್ ಪರ್ ಅನ್ನೆಕ್ಷರ್ ಡಿ ಸ್ಟೇ ಇತ್ತು ಸ್ವಾಮಿ. ಅವ್ರು ಬಂದ್ಬಿಟ್ಟು ಕಟ್ತಾ ಇದ್ರು CW6 ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಮೇಲೆ SC/ST ಯಾರು ಅಂತಾನು ಗೊತ್ತಿರ್ಲಿಲ್ಲ ನಮ್ಗೆ. ಅವ್ರು ಬಂದ್ಬಿಟ್ಟು ಕಟ್ತಾ ಆಸ್ ಪರ್ ಅನ್ನೆಕ್ಷರ್ ಡಿ. ಆಮೇಲೆ ಎಫ್ ಅಲ್ಲಿ ಸ್ಟೇನು ಕೂಡ ಆಗಿದೆ ಸ್ವಾಮಿ ಆಸ್ ಪರ್ CW6 ಮೇಲೆ. ಸ್ವಾಮಿ ಇದಿದೆ ಸ್ವಾಮಿ, ಅವರು ಪಕ್ಕದ ಮನೆಯವರು ಇವ್ರ ಜಾಗದಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಕಟ್ಟಿ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡಿ ಕಟ್ತಾ ಇದ್ರೆ ಬಂದ್ಬಿಟ್ಟು ಕೇಳಿದ್ದೆ ತಪ್ಪು ಅನ್ನೋ ಮಟ್ಟಕ್ಕೆ ಬಂದೋಯ್ತು.
ಆಯ್ತು ಸರ್. One HCGP two emergent notice. Next. ಬರ್ಲಿ. Yes.
Petitioner, my lord.
2, 3 and 4 in the event petitioners are accused. DV 118 ಅಲ್ವಾ?
118.
ಏನು? DV Act ಅಲ್ವಾ?
FIR already stay ಆಗಿದೆ.
ಆಯ್ತು ಕೊಡಿ. Tag the petition along with.
54, my lord.
Page 54 ಅಲ್ಲಿ tag the petition. Page 54 of the petition.
Accused number 1 is not in the party.
I know sir. 2, 3 and 4 ಮಾತ್ರ ಇರೋದು. Yes.
54 and 5.
5, 6, all right. There shall be an interim order of stay with these petitioners in the light of the interim order subsisting in the petition filed for an offence, challenging an offence under section 498A of the IPC. Yes. Tag the petition. So on page 53, Lwa?
54, my lord.
54. Yes, next.
Then 19.
No representation list after 2 weeks.
20.
Petition number notes.
I may permit you take notice for respondent number 2 here in the.
Even otherwise, forgery is found. Yes.
Please, madam.
Learned counsel KH Shekhar accepts notice for respondent number 2, the complainant, registry to print the name of so and so is appearing for the complainant. File your objections if you want.
Please, madam.
List the matter on 20.
Connected matter, my lord.
759
of 2020.
Tag, adult stay idea.
Adult stay.
ಮಾಡಿದ್ದಾರೆ.
Tag this.
But suppressing the fact that, my lord, though there is a.
No, my order.
Yes, my lord.
List the matter on 19th in the fresh matters list. 18th, sorry, 18th in the fresh matters.
19.
Oh, sir, why you're out of station?
Out of session, 19.
19th.
19.
Yes.
Stay ಕೊಟ್ಟಿಲ್ಲ sir.
ಇಲ್ಲ.
121.
Lords appear for petitioners, please, lords.
NCR date in.
Please, lords.
NCR date.
14, please.
14?
14, 2 of 14/2/2024, please, lords.
Heard
Page number
Learned counsel
54.
appearing for the petitioner. The first crime sought to be registered by the complainant is rendered with a non-cognizable report after you were called to the police station.
Lords.
After interaction with the complainant and the petitioners. The second crime comes about before the very same police station and which has become a crime and second complaint comes up before the very same police station which has become the impugned crime. Therefore, there shall be an interim order of stay of further proceedings with the petitioners till the next date of hearing. 1, 2, returnable by 25th. List on 25th in the fresh matters list. Next.
22.
Civil suit number
436 of 2023.
on the same cause of action between the parties. The parties are before the civil court in OS number
436 of 2023.
436 of 2023 during the teeth of the pendency of these proceedings, the criminal law is set into motion which is clearly impermissible in law. Therefore, there shall be an interim order of stay, quay the petitioner till the next date of hearing.
23. My lord, question the FIR registered for offense under 420. On the previous occasion, my lord, I tendered the complaint. Just an endorsement, my lord.
We'll see. Yes, the papers kodi. We'll take it day after tomorrow in the fresh matters. Kodi, adu kodi. Yes, let's day after tomorrow in the fresh matters. Next.
124.
Accused number 1 to 3, my lords.
307.
There is no complaints affidavit as 156 clause 3, my lords. And also,
Compliance affidavit. We will get the records. Yes.
no, and also, my lords, wherein the
We'll get the records. Yes.
complaint
learned,
is after 1 year, my lords.
HCGP to secure the investigation papers conducted till date, list on,
And also,
right, Friday, bada, list on 24th, sorry, 18th in the fresh matters list. 18th, madam? 18th, yes. No, nothing is there still. Yes.
498, my lords.
We'll see, sir. Yes.
125.
In the meantime, next.
Your lordship, hand delivery may be permitted.
Why?
Your lordship, the reason is that the second petitioner has gone abroad for studying. He's in the process of securing a job. So when they do a due diligence,
I think a Madhyanadolge you'll secure a job, is it? By evening you'll get it, madam. Yes. Elladukku hand delivery.
we uploaded on the website.
That we'll see, yes.
126.
Lord, appear for petition, my lord. There is a dispute between my lord husband and wife. Lord, in the complaint governments, my lord, my name is my lord. Tony.
You are not an accused.
I am not an accused, my lord.
Then why
Police
are you
have
before the court?
I request-
35(3) notice is issued
The
summoning
police
you.
have issued a
Appear,
notice, my
sir.
lord.
Appear.
But there is no allegation, my lord.
All right, sir. You are not even an accused.
This
Why
one,
are you,
my lord,
why are you before the court on a notice under 35(3) of the BNSS?
but there, as per the my lord notice, there are some, my lord, ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ ಸಾಕಷ್ಟು ಪೂರಕ ಕಾರಣಗಳು ಕಂಡು ಬಂದ್ರೆ
ಅಪಿಯರ್ ಆಗಿ ಸರ್, ಪೂರಕ ಕಾರಣ ಕಂಡು ಆಮೇಲೆ ನೀವು ಅಕ್ಯೂಸ್ ಆದ್ರೂ ನೋಡೋಣ.
my request, my lord, they are ready to, my lord,
ಏನು, you don't cooperate ಅಂದ್ರೆ they will arrest.
blood sample ಕೊಡಿ ಅಂತ ಅವರು. Lord, only single line, my lord, in the complaint. Entire allegation are ex-husband. ಇವನ್ ಜೊತೆನೂ ಕೂಡ ಸಂಪರ್ಕ ಇದೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಒಂದು ಲೈನ್ ಹೇಳ್ತಾರೆ.
Yes, government. ಯಾಕೆ ಬ್ಲಡ್ ಸ್ಯಾಂಪಲ್ ಕೊಡಲ್ವಾ?
ನನ್ಗೆ ನೋ ವೇ, my lord, she is not, my lord.
Yes.
He has to cooperate with the investigation. ma'am.
Let him cooperate. You cooperate with the investigation. You are not an accused still. I will not interfere.
But
Whatever sample they are asking. Yes.
there is no serious allegation, my lord. There is no such allegation against this.
The
Entire
petitioner is
allegation, my
direct,
lord,
the
against her
petitioner is
ex-husband.
before this court, even before he is declared to be an accused in a crime, apprehending that coercive steps will be taken against him by the police. The petitioner shall cooperate with the investigation as is directed, as is sought for in a notice issued under section 35(3) of the BNSS. In the garb of investigation, no coercive steps will be taken against the petitioner.
Please.
Yes, till the next date of hearing, list the matter on 24th.
Please.
Yes.
27.
For the petitioner.
19/7/24 is the crime.
No, there is no crime actually, my lord.
Actually, we'll see later.
Because as per the complaint itself, he doesn't state that we committed any crime.
Yen parayala, it can't be an encyclopedia.
Allah,
Yes.
they have said that even the other petitioners, petitioner number 2 to 6 ಮೇಲೆ ಏನು ಇಲ್ವೇ ಇಲ್ಲ sir.
One HCGP, 2 emergent notice returnable by the 25th. The learned HCGP to secure the investigation papers of investigation conducted till the 24th of September.
Stay I have
No,
sought for. My lord, in so far as the respondent number, no, petitioner number 3, ಅಲ್ಲ ಅವ್ರು ಎಲ್ಲಾನು officials, so they have been unnecessarily been dragged.
Avat, yes.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಸ್ಟೇ ಕಾಪಿ ಪುಟಪ್ ಆಗಿಲ್ಲ. That is one thing that has also not come.
Application,
That we have filed it, my lord. Reason.
ಅವತ್ತೇ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ, ಇವತ್ತು ಇಲ್ಲ. Yes.
ಅಲ್ಲ last time when it had come up, my lord, it
4th, yes. Next.
ಅಲ್ಲ my lord, because what their official work ಗೆ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ. They have been unnecessarily been called to police station.
No problem, yes. Next.
128.
13(1)(e).
ಯಾಕೆ ಇಷ್ಟು ಜಲ್ದಿ ಹಾಕಿದ್ದೀರಾ? 2008 proceedings.
Unless they have filed charge sheet in the year 2020.
20?
20.
ನೀವು 4 ವರ್ಷ ಆದ್ಮೇಲೆ ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ ಈಗ?
No, that's now, my discharge application came to be
When?
redischarged. On 18/7, please.
List on 20th. Learned Counsel B.B. Patil is directed to accept notice for the respondent. Next.
129.
This cashier have granted interim order in identical case where?
My lords,
In identical case of grant an interim order, where is that?
my lords, the principle of Lalit Chaturvedi applied to this. It's a civil dispute. The complainant has filed a civil suit.
192A, that's what I'm saying. Anyway. We should get the orders that I've granted, yes. So in the meantime, next.
130.
Petitioner, my lords, offenses under 192A, 51 of the Disaster Management Act, 353, 427, 447 IPC, my
In the
lords.
meantime,
131.
My lords, the allegation is under section 207. I have not answered.
serve the DSGI. You're already on record?
This should be.
This
may be tagged along with 8655 of the
Same.
report, please.
The learned DSGI Shanti Bhushan is directed to accept notice for the respondent. Petitioner to serve set of papers upon the learned DSGI registry to change the name of DSGI as appearing for the respondent. Tag the petition along with so and so. ಅದ್ರಲ್ಲಿ interim order ಇದೆಯಾ?
ಇಲ್ಲ, ನಾಳೆ
ನಾಳೆ ಬರ್ತಾ ಇದೆ.
come up tomorrow.
ನಾಳೆ ತಗೊಳ್ಳಿ. Yes. Yes, next.
132.
For the petitioner, my lord. 132 and 133 is the
Same.
same incident.
Correct.
Same incident. Only for university, they have gone in third person as assaulted, not the petitioner's hearing. Absolutely no allegations, not
Absolutely no allegation.
so far as the,
Correct. But I'll see the investigation papers.
but so far as second petition, your lordship can be considered second petition, my lord. ಅವ್ರು ಅಲ್ಲಿ ಹೆಸರು ಹೇಳೋದ್ ಬಿಟ್ರೆ ಏನೂ ಹೇಳಿಲ್ಲ. And is a respected senior person, my lord,
All
senior lawyer.
We'll see. Yes.
My lord, the only allegation is that, and moreover, my lord, in the second case, 174, my lord, because our role, non-cognizable offense. my lord.
Correct.
That's also not complied with.
Yes. No, precisely because you have traveled United Nations Congress.
That,
Then
my lord, that,
treatment of offenders in
I
Cuba.
understand.
ಇದೆಲ್ಲ ನೀವು, if I have to digress all this and
That
write
I will not get
there,
into, my lord. Your lordship,
I'll have to hear the other side.
that I will not get into, my lord.
ನೀವು ಇಂಡಿಯಾದಲ್ಲಿ
The
ಇದ್ರೆ
offense
ಪರವಾಗಿಲ್ಲ.
market-
You have traveled to Cuba also. I know Cuba is.
It's a bit excessive on the our part, but I
yes.
will, your lordship kindly ignore that part, my lord.
ಅದಕ್ಕೆ.
But yeah, offense wise, my lord, no offense as against the petitioners here.
But why did you bring United Nations of offenders?
I will, I know it was, anyway, I have to own the responsibility, which I will do.
All right. Yes, madam, get the investigation papers. We'll take this on Friday.
Very well.
List on third. Heard the learned counsel so and so, one learned HC, will not issue notice to the complainant. We'll see the
Please.
papers and then
Please.
list the matter on 13th in the fresh matters list. The learned HCGP is directed to secure the investigation papers and place it before the court on the next day.
In both the matters.
Both.
Same incident, two complaints.
Correct.
Of course, a different complaints, not all.
Yes, sir. Same incident to two different
Two
complaints.
different first permits.
Yes.
Yes, Mr.
Adrallu United Nations, huh?
Anyway, I will
Okay.
not get into that.
List on 132 and 133 both. Vipin sir, crime is registered on 21/8/24.
Yes, my lord.
I would see the papers only and then do it.
My lord, the allegation is that, my lord, we have hit the vehicle from behind.
307 and
307 ಹಾಕಿದ್ದಾರೆ. That is the allegation, my lord.
toll
Page
plaza,
seven- page
toll
seven.
plaza assault. Allegation.
Allegation is, my lord, page 17, saying that, my lord, the complainant was going in a two-wheeler. He came, my lord, from the behind, that is the accused, and hit him, my lord, in the vehicle. ಅದಕ್ಕೆ
Let's see.
307
Let's see. ಅದು ಹಿಂದ್ಗಡೆ ನೋಡಿದ್ರು ಅಷ್ಟೇನೆ.
ಅಲ್ಲ, my lord, maximum, my lord, it will be negligence, accident ಇದು ಬರ್ತದೆ.
We'll see, yes. List on same 13th, heard the learned counsel Bipin Hegde appearing for the petitioner. The crime was registered on 21/8/2024 and the offense alleged is section 307 of the IPC. Though 307 ಹೆಂಗ್ ಹಾಕಿದ್ರಿ 27 ಗೆ? BNS ತಾನೆ ಹಾಕ್ಬೇಕು.
ಅಲ್ಲ, complaint is on 21/8/2023.
23 ನಾ?
23,
24 ಅಲ್ವಾ?
ಇಲ್ಲ 23.
ಏನಾಗಿದೆ ಇಲ್ಲಿವರೆಗೆ ಮತ್ತೆ?
ಏನೂ ಆಗಿಲ್ಲ ಇಷ್ಟ ತನಕ.
Yes, government. 24
Even-
ಹಾಕೊಂಡೆ, sorry, yes.
Even we were not aware of, my lord, about the complaint being lodged. Now, my lord, the police.
ವರ್ಷದಿಂದ ಏನ್ ಮಾಡಿದ್ದೀರಾ?
I'll get the records. ma'am.
Heard the learned counsel Bipin Hegde appearing for the petitioner. The complaint comes to be registered on 21/8/2023, alleging that the vehicle in which the petitioner was driving has hit the two-wheeler,
Yes, my lord.
has hit the two-wheeler as the two-wheeler had applied sudden brakes at a toll plaza. The learned HCGP is directed to secure the investigation papers conducted for the last 1 year and place it before the court till such time further proceedings before the where the petitioner shall remain stayed.
Problem.
The 24 uncombated. Yes. Next.
135.
35, my lords. Petition is a bona fide purchaser to the accused number 3.
A2 only.
Lords, A1 is the purchaser, bona fide purchaser.
A2 is the advocate.
Yes, A1 is the advocate. A2 is the advocate. A2
ಫಸ್ಟ್
is-
ಅವ್ರನ್ನ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ ಮೇಲೆ ಅದಕ್ಕೆ A2 ಮಾತ್ರ. Yes, 1 HCGP 2 emergent notice returnable by 30th. There shall be an interim order of stay only insofar as the first petitioner hyphen accused number 2 till the next date of hearing. Yes.
36.
Victim was 17 years, 11
Who
months.
got them married? The
They are not
parents.
married.
ಮತ್ತೆ?
They are only agreed. That is what the understanding between the parents.
Agreed. ಏನ್
They
agreed?
agreed. They have agreed.
What agreed?
Since post now presently is in judicial custody.
Correct.
In fact, post is
No, this is
released.
POCSO and
17 years, 11 months. The accused is 20 years.
17 years, 11 months.
at the time of the incident.
Please.
This
DNA report matching.
ಎಲ್ಲ ಇದೆಯಾ? Then we'll, he's in judicial custody.
Please.
Yes, Jagdish.
We'll have to see, my lord, because.
Judicial custody ಇದೆ ಇಲ್ವಾ ಅಂತ?
ಅಲ್ಲಲ್ಲ.
ಅಲ್ಲ 17 years 11 months verify ಮಾಡಿ. I'll take it day after tomorrow. If it is 17 years 11 months, then we'll see. Supreme Court judgment will come in the way. Justice Oak judgment.
Please.
Get that judgment.
Please.
Yes. List on day after tomorrow in the fresh matters list. Yes, next.
37.
Lords, I appear for the petition.
We'll post it in admission and here.
My lords, there is an IA, my lords, for issuance of NOC for passport.
Passport.
Yes, my lord.
ಏನಾಗಿದೆ?
Because of the
Have
pending
you
criminal.
implemented the RPO?
My lords, they are only asking for a NOC from the court, my lords. If your lordships will see the IA, my lords,
Complete the RPO, sir. ನಿಮಗೆ ಜಲ್ದಿ ಬೇಕು ಅಂದ್ರೆ you get Shanti Bhushan.
I'll do that.
The petitioner is directed to implead the regional passport officer office as party respondent to these proceedings. The
For
learned
initiating surface act, they have filed section
Minute.
499.
learned DSGI Shanti Bhushan is directed to accept notice for the second respondent. Petitioner to serve set of papers upon the aforesaid council.
Yes.
List the matter on Monday ಹಾಕೋಣ. Tuesday 16th.
Much of it.
16th, 17th in the fresh matters. ಇವತ್ತೇ serve ಮಾಡಿ.
Much.
Yes. By then he will get all instructions. It will be easier.
38.
Post the matter. Urgency ಏನಿದೆ ಮೇಡಮ್?
Urgency passport application ಇದೆ job he is losing. his-
ಇದನ್ನ ಅದು same order. You implead Shanti Bhushan will grant.
That
Sorry, implead RPO.
writ is pending. That writ.
Which
where-
writ?
Where ಇದೆ ಅದಕ್ಕೆ
Number ಕೊಡಿ. Writ number ಕೊಡಿ madam.
I'll furnish me.
ಕೊಡಿ, will tag this petition along with so and so. Yes, next.
If this is disposed of, that clears me.
ಅದು ಟ್ಯಾಗ್ ಮಾಡ್ಬೇಡ ಬಿಡಿ. ಒಂದೇ ಸರಿ ಎರಡು ಮಾಡಿದ್ರೆ.
Yes.
Next.
130.
Date ಯಾವ್ದು?
139.
This case I am.
ಅದು first tag ಮಾಡಿ. It will come post the matter on 13th. Yes, next.
In this case, I am for the petitioner.
Post immediately after service of notice upon the first respondent.
This is not necessary because the petitioner is the complaint before the trial court. He filed a PCR. PCR was in the PCR source statement mode recorded.
ನೀವೇ ಹಾಕಿದ್ದು. ಅಯ್ಯೇ.
The recording of the sworn statement, my lord, 55 documents are marked. After marking of the documents.
List day after tomorrow in the fresh matters list. Learned counsel submits that he's filed an application not to press. ಅಯ್ಯೇ one ಏನು? Stayna.
Stay ಕೇಳಿದ್ವಿ, not press.
Not to press the application seeking stay. The submission is placed on record. IA 1 of 24 is disposed as not pressed. Next.
140.
My lord, I am permitted to represent the petitioner.
CC of 2019, sir.
Yes, my lord. Now the charges are not framed. The only allegation is that
Ah.
while I was the only allegation is while I was the manager, I had sanctioned the loan for a sum of rupees 49 lakhs. it is essentially a suit which ought to have been filed for recovery, my lord. Now, the amount that is claimed for 49,67,000 by the
Well,
company.
see, yes, one HCGP, two emergent notice. Yes.
My lord, may I request, my lord, so far as petitioner number 4 is concerned, the order of taking cognizance is
You are
very
the
bad.
only petitioner here is accused number 4. Yes.
Therefore, my lord, if the
No, sir.
proceedings, if
Yes.
the only difficulty that we are facing is that, my lord, if charges are framed,
No.
very
we'll see,
purpose of
sir.
petition.
No problem. You have filed a petition, we've issued notice, even charges are framed, we'll take care of it.
My lord, may I request for a shorter date, my lord, since
In
emergent
the
notice is ordered.
meantime, yes. Next.
My lord, may I request for a shorter date? my
What
lord?
is the civil suit number?
It's 1802 of 2014.
All right, anyway, in the meantime, next.
Public.
142.
Represent petitioners, my lord. Arising out of the Copyright Act in respect of the same matters, CC number 1005/24. On 2/2/24, my lord has granted the stay order, stay of the further proceedings.
2/2/24, not my order. Could you know?
My lord,
Where is that page?
it's page number 22, my lords. I have stated so, but I could not keep the order on my hand. Page number 22, I have mentioned it.
If it's 2/2/24, it's not my order.
No, page. Three criminal petitions have been entertained by this court with reference to
Page
page
numbers.
number 22, grounds for interim relief. Criminal petition 5620/23.
Tag this petition, heard the learned senior counsel M.B. Nargund appearing for the petitioner. Tag this petition along with ಇಲ್ಲಿ ಇದು ಹಾಕಿದ್ದೇನೆ.
Criminal petition 1005/24.
ಮೂರಿದೆ. ಅದ್ರಲ್ಲಿ ಏನ್ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಆಗಿದೆ ಅದು ಮಾಡಿ. ಅದ್ರಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅದು ಮಾಡಿ. Yes. List them all on 30th. Yes. In the meantime, next.
144.
13th, sorry, 20th. ಆಯ್ತು ಮಾಡ್ಲಿ ಬಿಡಿ. ನಾನು ಕೇಳಿದೆ ನಿಮ್ಗೆ ಸರ್ಕ್ಯುಲರ್ ಕೊಡಿ, DA ಕೇಸಲ್ಲಿ ಸಸ್ಪೆಂಡ್ ಮಾಡಬಾರ್ದು ಅಂತ. ವೆರ್ ಇಸ್ ದಟ್ ಸರ್ಕ್ಯುಲರ್? ಗವರ್ಮೆಂಟ್ ಸರ್ಕ್ಯುಲರ್. ವೆರ್ ಇಸ್? ಅದು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿ ವಿಲ್ ಪಾಸ್ ಮಾಡ್ ಅಂದ್ರೆ ಯಾರು ಕೊಡ್ತಾನೆ ಇಲ್ಲ ಸರ್. ವೆಂಕಟೇಶ್ ದಳ್ವಾಯ್ ಅವ್ರಿಗೂ ಹೇಳಿದೆ. Get it tomorrow?
Only one submission.
All right, your submissions tomorrow.
Yes.
Yes. Next.
145.
7A, 13th.
Please,
This
permit it to notify. No.
Learned counsel B. Latif is directed to accept notice for the respondent. Registry to print the name of counsel B. Latif as appearing for the respondent. Petitioner to serve set of papers upon so and so list on 13th. Other matters are there on 13th.
Please, in the meanwhile.
Heard the learned senior counsel. In the meanwhile, 13th. Yes, sir. Yes.
Please.
In the meantime, serve on the counsel, the.
It's covered by your lordship's order
Ah,
from
I
the
know.
Kalburgi bench.
Kodi. But you have to serve.
Please. Minutes.
17A, yes. Learned HCGP is directed to accept notice for the respondent. Second respondent yaru? Same.
The
Learned
competent
HCGP is
authority.
directed to accept notice for the respondents. List the matter on 26th till such time further proceedings where the petitioner shall remain stayed in the light of the submission of the counsel for the petitioner that the issue in the list stands answered by the judgment rendered by this court and writ petition so and so will mail it. Next.
147, my lords.
A1,
A1 may
no?
urge your lordship that
Charge
he
sheet
requires
Charge
protection.
sheet file ಮಾಡಿದ್ದಾರೆ.
170 of 24, charge sheet number.
Challenge that.
Please.
Yes, so and so. A1 even then have to make out a case. Others, no problem. Yes.
Please.
48.
For the petitioners, my lord. There are the three complaints and both complaint is before the learned magistrate. And first complaint NCR is dated 19/1/22 and second complaint NCR is on 24/11/23.
One emergent notice, two HCGP. The emergent notice returnable by 27th in the meantime. Yes, next. Date, sir. Stayed.
149 appearing for the petition lordship. Still is in summons stage lordship.
FB post, yes. In the meantime, yes, next.
Obliged.
150.
323 and
Correct. 2016 crime.
yes, my lord, kindly see the
TC
annexure.
20, petition 24.
Yes,
ಎಲ್ಲ 4 ವರ್ಷ ಗ್ಯಾಪ್ ಅಲ್ಲಿ.
well, please see the annexure B, my lord.
What is C, sir?
Annexure B, my lord.
No,
Annexure B ನಲ್ಲಿ ಅಲ್ಲಿ ಕೂಡ ಏನು ಅಲಿಗೇಷನ್ ಹೇಳಿದ್ರು ಅದು ಕೂಡ
ಪರವಾಗಿಲ್ಲ 8 ವರ್ಷ ಆಗಿದೆ.
ಅದ್ರ ನೇತ್ರಾವತಿನ ಕೈ ಬಿಡಬೇಕು ಏನು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಅದ್ರ ಕೂಡ annexure B.
Yes, what's the stage, madam?
ಇದುವರೆಗೂ ಕೂಡ ಮೇಲೆ
We'll call this matter in 2028. 4 years gap ಆಗುತ್ತೆ ಎಲ್ಲದು ಕರೆಕ್ಟ್ ಆಗವ.
ಪ್ಲೀಸ್ ಸಿ ದಿ annexure B.
Yes. 1 HCGP 2 emergent notice returnable by 27th.
Stay, my
No, sir.
lord. Kindly please see the
No,
annexure
sir.
B, my lord. ಅದ್ರಲ್ಲಿ ನೇತ್ರಾವತಿನ ಕೈ ಅವ್ರು ಏನು ಮಾಡಿಲ್ಲ ಅಂತಿದ್ರೆ ಆದ್ರೂ ಕೂಡ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಮೇಲೆ
ಆಯ್ತು, ಈಗ ಏನಾಗಿದೆ ಅಲ್ಲಿ? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
ಇನ್ನು ಏನು ಮಾಡಿ
ಏನಾಗಿಲ್ಲ ಅಲ್ವಾ? ಏನೂ ಆಗಲ್ಲ ಬಿಡಿ. 27th, next.
ಪ್ಲೀಸ್ ಸಿ ದಿ
27th, yes, sir.
151.
B report is filed, madam.
ತಡಿ, ಒಂದ್ ನಿಮಿಷ. ಅರವಿಂದ್ ನೇಗ್ಲೂರ್ ಅವರೇ, ಒಂದ್ ನಿಮಿಷ ತಡಿ. ಏನ್ ನೋಡ್ಬೇಕು?
Case
ಹೇಳಿ.
counter case.
ಒಂದ್ ನಿಮಿಷ. ಏನ್ ನೋಡ್ಬೇಕು ಹೇಳಿ?
ಪ್ಲೀಸ್ annexure B, my lord.
ಪೇಜ್
Page 26, man.
ಹೇಳಿ. ಫಿರ್ಯಾದಿ ಹೇಳಿಕೆ.
Yes, my lord.
ಹಾ
ಇದು undated statement, my lord.
ಸರಿ, ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ಬೇಕು?
ಆಮೇಲೆ ಪ್ಲೀಸ್ ಸಿ ದಿ ಸೆಕೆಂಡ್ ಪ್ರಕರಣದಲ್ಲಿ ನನ್ನ ಮರು ಹೇಳಿಕೆ ಏನಂದ್ರೆ 17/11/16 ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೇಳಿಕೆ ನೀಡುವಾಗ ಘಟನೆಯ ಸಮಯವನ್ನು ರಾತ್ರಿ 10 ಗಂಟೆ ಎಂದು ಹೇಳಿಕೆಯನ್ನು ನೀಡಿರುತ್ತೇನೆ. ಆದರೆ ನಾನು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಚಿಕಿತ್ಸೆ ಪಡೆಯುತ್ತಿದ್ದರಿಂದ ಗಾಬರಿಯಲ್ಲಿ ಘಟನೆ ನಡೆದ ಸಮಯ 11:30 ಆಗಿರುತ್ತದೆ. ದೇವರಾಜು ರವರು ಸೌದೆ ಪಾಳಿನಿಂದ ನನ್ನ ಎಡ ಕೈ ಮುಂಗೈಗೆ ಹೊಡೆದು ರಕ್ತ
11:30 ಇನ್ಸಿಡೆಂಟ್ ಆದ್ರೆ 10 ಗಂಟೆಗೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಶುರು ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
ಪ್ಲೀಸ್ ಸಿ ಮುಂದುವರೆದ ಮೇಲೆ ಅದ್ರಲ್ಲಿ
Wait. Heard the learned counsel appearing for the 1 HCGP 2 emergent notice. The statement of the complainant is as vague as vagueness could be, as the incident narrated is at 11:30, but he gets admitted to the hospital for treatment at 10 PM, 1.5 hours before the incident. Therefore, there shall be an interim order of stay for the proceedings by the petitioner till the next date of hearing. Sorry. Yes. Next.
151.
B report has been filed, madam.
B report.
Please.
Same order, Kavya.
52.
Grateful.
The petitioner is before this court calling in question so and so. The proceedings instituted would clearly indicate, proceedings instituted through the private complaint would clearly indicate that the same is instituted for the purpose of recovery of money, which the apex court in the case of Lalit Chaturvedi reported in 2024 SCC online SC page 171 has observed that such proceedings should not be permitted to be continued. Therefore, there shall be an interim order of stay. So on. Next.
This is a matter where we have sought for bail, my lords.
Bail?
How, this is a matter, my lords, 50 cases that were registered against him, he gets bail. 51, totally 110 cases, my lords, against him. 110 ಅಂದ್ರೆ ಒಂದು ದೊಡ್ಡ plot ಅಲ್ಲಿ, my lords, different survey numbers. They say that he's cheated using various survey numbers by getting certain orders from the court. Now, my lords,
Coca court rejected the bail petition of the accused.
But that doesn't.
Three,
My
4
lords,
days
I'll just please I'll point out 3 illegalities, my lords, on the basis of which the entire arrest becomes illegal. My lords, the first is 41A notice issued to me, my lords. On the basis of 41A notice, I approach the concerned police. Police arrest me. Now that goes contrary to Satindra Arthin's case, my lords, where you can't. 41A notice, if you are going to be complying with, you can't be arrested. Then, my lords, after I'm arrested, in that particular case, my lords, I get bail. After I get bail, I'm not released. They say in the other crime number, we show your arrest, we continue.
What to do if you have done 110 cases? ಒಂದಲ್ಲ ಒಂದರಲ್ಲಿ ಒಳಗೆ ಇರ್ತೀರಾ?
ಇಲ್ಲ. No, my lords, now the position of law is this. A person can be detained in jail only in one case. In so far as the remaining cases are concerned, you can ask for PT, my lords, or transit. Once the purpose is achieved there, you are sent back to the main case. Now, in the main case.
We'll take it tomorrow in the fresh matters list. List tomorrow in the fresh matters list. Heard. Not Senate Council. List tomorrow.
Also, my lords,
ಇಲ್ಲ ತೋರಿಸಿಲ್ಲ ಅಶೋಕ್ ಚೆನ್ನೈ.
Registry to print the name of so and so's appearing for the respondent.
Now also, my lords, the present position is grounds of arrest has to be given.
That is true.
If that is not given, my lords, the whole arrest becomes illegal. That's also there, my lords.
You're on grounds of arrest or rounds of arrest?
Don't say Prajna Singh.
My lords, I'm on three aspects. 41A, Satyendra Kumar Antil's case, my lords, clearly
Aito,
covers the
Ale.
situation. Second, a coordinate bench, my lords.
Ale.
Please.
Yes, tomorrow, fresh matters list.
154.
Application is allowed?
The application is allowed,
Ah.
but the case is that when during the investigation stage, the lien was marked. Charge sheet was dropped. Afterwards, the application is allowed and the money is.
But we'll have, where is the money now?
Money is released to the petitioner.
Then if it is to come back to you, we have to hear.
Yes,
One HCGP2 emergent notice returnable by 30th October.
maybe in the fresh matters.
Avatella fresh. Yes. Next. Sorry, September.
155.
OS number.
OS number 67 of 2024.
Ondena?
One day.
Complainant. Who has registered instituted OS?
We have issued a suit against this complaint. my lords.
They heard the learned counsel, senior counsel PP Hegde appearing for the petitioner. The petitioners institute a civil suit in OS number so and so against the complainant. As a counterblast, the impugned crime is set in motion by the petition, by the respondent complainant. Therefore, there shall be so and so till the next date of hearing. Next.
Great.
Oh, Your Lordship, 156.
This will ivattaga.
Connected matter is listed tomorrow,
Aಯ್ತು, list number kodi.
23868 of 24.
Right? Yes. Next. Tomorrow, list tomorrow.
57.
Notice.
I don't even have to explain my lords what's happened in this case.
West Coast.
West Coast, we buy starch, my lords, from Millennium Starch. They ask us to make payment to one account. We were making payment to that account. They ask us to change it to another account.
Lalit Chaturvedi.
We change it to the other account. How am I to be liable, my lords, for making payments?
Yes.
First time for making payments, I'm making.
One HCGP heard the learned senior counsel appearing for the petitioner. List one HCGP2 emergent notice returnable by 30th of September 20. List on 30th in the fresh matters list till such time.
Obliged.
Yes. Yes.
158.
It's gone for repair.
Ashtena, are you able to see me?
Yeah,
Yes.
I have no problem, Lord. I'm seeing better now. There is only to see through people.
Yes, sir.
If every time, Lord, we terminate an employee files a criminal case against us.
Always there. Heard the learned senior counsel Dhyan Chinnappa appearing for the petitioner. One HCGP2 emergent notice till such time. Stayed. Yes. Yes. Termination of employment cannot result in a crime, sir.
And that too, after 3 months, he says.
List number 2.
But serial number 137, there's an interim order,
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಎಸ್ ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ ಅದು ಮಾತ್ರ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಎರಡರಲ್ಲಿ ಒಂದ್ರಲ್ಲಿ ಮಾತ್ರ ಇದೆ ಅಂದ್ರೆ ಎರಡರಲ್ಲಿ ಇದ್ರೆ ಎರಡು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Here for the petitioner's counsel. This case where charge sheet has been presented. In this matter, where we have filed
Hear
application.
this in camera.
Sorry,
We'll have to hear this in camera.
please.
This can't be heard in the open at all.
I have only one request. But they have filed charge sheet.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
All right.
But they have not furnished us a copy of the charge sheet.
You'll
Before-
get it, sir.
ಅಲ್ಲ, no, one.
ಅಲ್ಲ ಅಲ್ಲಿ ಏನಾಗಿದೆ
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೀನಿ ಸರ್.
ನಾವು ಕಾಗ್ನಿಸೆನ್ಸ್ ಸ್ಟೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ
ಇದ್ರಲ್ಲ.
A1, A2, it's not there.
If that is clarified, let the,
How is this man involved in the other stake ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
ಇದು ಜಾಯಿಂಟ್ ವೆಂಚರ್ ಇದು.
No. No. These the
That's
casual
all what I
remark.
can- I'm
No.
sorry, I'm sorry.
No,
I should
that
not.
cannot be the
I
statement,
should
sir.
not- I
Casual
should-
remarks.
That's
ಈ ತರ
not-
ಮಾಡಿದ್ರೆ.
I
not
should
this
not,
statement at
I should
all.
not say that.
Yes, yes.
I should not.
It
say
is
that.
not.
I should
So
not.
it's not.
Lord,
Fa-
my,
it's against the father allegations are
I-
different.
I
This is not.
I have one request. Now, my lord, as on today, my lord, without the charge sheet, my lord, they're all bailable offences. They invoke 376 by giving a requisition based on a subsequent 161
we'll
statement.
have to
No, those
consider that.
papers has to be given to us,
No, no,
so
where-
as to enable us to argue.
I would want to see the charge sheet.
ಅಲ್ಲ ತಮಗ್ ಕೊಡೋ ಕಾಪಿ ಇದೆ.
ನನಗ್ ಕೊಡಕ್ಕೆ ಅವ್ರಿಗಲ್ಲ.
ಅಲ್ಲ ನಮಗ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ my lords. I
We'll-
can't argue on this.
You'll get it.
No, it's against me if not, I am not furnished with the charge
You'll
sheet.
get it in the normal course
ಅವ್ರು-
before the concerned court.
They
I
have
will clarify the order now.
Very well, very
I will clarify the order
Very
that the taking of cognizance is deferred only qua accused number 2 alada.
Accused number one.
Accused number-
Thereafter, my lord,
That is against HD Revanna.
cognizance, my lord, your lordship said cognizance is taken on offense, not an offender. Therefore, your lordship said that let it be for both.
Yes, for both.
Because
ಅಲ್ಲ
cognizance.
Have I said so in the order?
First ಹೇಳಿದ್ರಿ.
ಅದು ನಂಬರ್ ಕೊಡಿ ಟ್ಯಾಗ್ ಮಾಡಿ we will,
ಅಲ್ಲ ಟ್ಯಾಗ್ ಮಾಡೋದೇನ್ ಬೇಕಾಗಿಲ್ಲ, ಇದ್ರಲ್ಲಿ ತಾವು ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ರೆ ಸಾಕು. We'll
ಅಲ್ಲ if that if Jagdish is saying that I
It's already an order.
I don't know.
I don't know, even I am not part of that, but if there's already an order.
I think Council
Offences
Stephen
are
Nagesh had appeared in.
Offences are also, if I may say so with respect, they are distinct and separate. No, it's only against petitioners 376 is involved.
All right, you want to make submissions, please make.
I want the copy of the charge sheet, my lord, because as on today, my lords, as on today, my lord, there is no 376. Subsequently, my lord, it
Copy
is
of the charge sheet you will get after the court takes cognizance of the.
Please. No, but at least the reason is this.
Adu, that
The reason is this, my lord. Lordships may kindly say. But as per the contents of the first information report and the first information lodged by the prosecutrix, there is no allegation of 376.
That's all right. It is added pursuant to permission being taken by the concerned. court.
Therefore, my lord, that statement subsequently she makes, invoking for the first time 376, my lord,
Yes.
I need to have the benefit of looking into it so that, my lord, I can make my
So that is
submissions.
that is at a stage when cognizance is taken. There is no bar in law. If there is something that is barred in law, you tell me. It's not, there is no bar in law.
Well, I can argue today, my lord. So without that statement,
You can
then, my lord,
argue. If you want to argue,
the
you argue.
prosecution cannot, my lord, then rely upon that statement. Is all my submission.
Oh,
my
no,
lord.
sir.
The reason is this, my lord. No, my lord, I need to know, my lord, what is the, my lord's, what is that which is imputed against me to invoke 376?
You'll get to know everything, sir. There are ಎಷ್ಟು volume
Now,
ಇದೆ?
Lord, for the purposes of
4
arguing-
volume charge sheet ಇದೆ. You'll
for
get
the
to know
purposes of arguing 439 application today, my lord. If lordships are to peruse the first information report, there is nothing 376. There is nothing on to state that
everything.
376.
When is 376 added?
Subsequently,
Subsequently ಅಂದ್ರೆ ಯಾವಾಗ?
the 4th of May 2024.
I'm not asking the date. At what stage?
Now, during investigations.
Are there?
That didn't, no, I have no difficulty with Very that. preliminary adding it. stage.
And
All the
with-
times-
with the permission of the concerned court.
course.
No, what's the bar? No bar, sir.
No, I have no objection for that. All that my limited request at this stage is either, my lord, they give the charge sheet or, my lord, those statements, particularly that 161 statement, my lord, wherein the prosecutrix alleges for the first time based on which the requisition is made. But there would be, it will cause serious prejudice insofar as I am concerned, not to argue that matter, insofar as that aspect of the matter is concerned.
Right? We'll direct the court to proceed further against you.
Please.
Then we will,
Please.
if the cognizance is taken, next week we'll take this matter and decide it. The court
For the benefit of the court, please.
Yes. ಅದು learned special public SPP. Learned additional SPPC Jagdish. ಹೌದು, okay. So hands over the copies of the charge sheet for a perusal of the court. Same is taken on record. The learned SPP would submit that the order passed qua accused number.
One.
Number one.
One.
Then it would become, the things would get jumbled if we don't decide them together.
That is why, my lordship, remember that because offense, cognizance is taken on offense, not an offender. So there is no, we cannot split the taking cognizance on. That is
That's
why your
what-
lordship said let it be for both.
But I would request, my lords, for the purposes of deciding 439 application, of course, lordships may consider that petition as well. For the
So
purposes
if you want to submit dehorse the charge sheet on the thing that is pending here, I'm prepared to hear. That's up to you.
May I, lordships will permit me to make at least this request, limited. Lordships may permit me or the council on record to peruse that statement of 161, all that for this reason, my lord. No, now, my lord, if not, my lord, 376 is for the first time alleged during the course of the investigation, which I have not
No
obviously.
bar, you will get all the opportunity. You're an accused. You will not get this statement prior to the filing of the charge.
Framing of the
Settled
charge.
They have
principle.
filed the charge sheet now, of course.
You will
Filed-
spring into action only then. Now there is a prima facie offense against you, which also includes 376. So you're in custody.
Now, my lord, that 161 statement has been recorded by them according to the which, based on
160
which 376 is.
164 or
161 ಅಂತ ಹೇಳಿದ್ರು.
Sir, 164.
That also, my lord, we don't have.
Sir,
You know,
you're
the
not
requi-
entitled
the
to that now.
requisition ಅಲ್ಲಿ, they
Sir,
don't.
You're not entitled to all that now at this juncture.
But then, Lord, I'll have to argue on the basis of.
What, if you want to argue, you argue. Otherwise, we'll permit the court to proceed further. If it to be taken note of there, we'll do it.
No, my lord, I would
then-
certainly have the benefit of, my lords, having a look at the charge sheet. My lord. That would certainly help us arguing the matter because.
ಈಗ there are 161 and 164.
ಈಗ ಅದು ಹೇಳೋದು ನಮ್ಗೆ
Of the victim.
nothing is on, we don't know, my lords. I don't,
Of the
I'm
victim.
oblivious of these facts.
If charge sheet is filed, then we will see.
No, the investigation is complete, charge sheet is presented.
But may I request then, Lord, to have one of these dates? Lord?
I'll take it on 12th. 12th or 19th, whenever you want.
12th, Lord, is Thursday, this
Thursday, yes. 12th is this MPMLA day.
Yes,
Even last Thursday I was not sitting, so I posted all that today.
Would lordships kindly consider having it on 13th or 17th, no, if it is all right.
ಅಲ್ಲ 19th ಬೇಡವಾ?
19th is fine.
19th ಬರ್ಲಿ.
Connected matter also. Connected matter.
Also is on
ಅದು
19th.
19th ಇದೆ.
All right. We'll take it on 19th.
So in the interim, if the court is permitted to proceed, taking
ಅಲ್ಲ
cognizance.
ಅದು it will get jumbled.
ಆಯ್ತು,
It's
ಆಯ್ತು.
neither here nor there ಆಗ್ಬಿಡುತ್ತೆ.
I'm sorry, 12th it's, I will argue. 12th.
12th ಮಾಡ್ತೀವಿ. ಮಾಡಿ. List on 12th.
ಅಲ್ಲ, ತಾವು ಇನ್ ಕ್ಯಾಮ್ರಾ ಅಂತ ಒಂದು ಡಿಸಿಷನ್ ತಗೊಂಡ್ರೆ.
That we will post it.
Ah.
Yes. If it is to be heard and the charges to be seen, then definitely it needs in camera.
Needs to be.
Yes. Then we will secure the order and then do it.
In fact, you want to read out the
No,
details.
that's.
It
See,
is such an
it
embarrassing.
should not be that any person should be, ignominy, should not be put to ignominy at any cost. That is the reason we'll hold it, yes.
Oblige.
We'll take it on 12th, sir.
ಅಲ್ಲ 12ಕ್ಕೆ ತಾವು
12ಕ್ಕೆ, ಅದಿದೆಯಲ್ಲ.
ಇದು ಬೇಡಿ 12.
ಅಲ್ಲಿ ಇವತ್ತೇನಾಗುತ್ತೆ ಅದ್ ನೋಡೋಣ.
It will take the whole day ಅಂತ ಕಾಣುತ್ತೆ.
I guess,
ಹಾ,
let's see.
ತಾವು
12
10:30ಗೆ ಅಂತ ಹೇಳಿದೀನಿ.
Troubling, sir. I think 19th is better. The other matter is also on 19th.
Lords, may I, lordships will tentatively fix on 12th, Lord. For any reason it's not possible, then 19th.
All right.
12th.
List on 12.
ಆಗ್ಬೋದು.
But serial number 7 and 9 also, Lord, they are
Both,
anticipatory.
yes,
both
yes.
of them.
ಹೌದಾ? ಮುಂದೆನಾ?
ಇಲ್ಲ,
7.
Heard ಎಲ್ಲ ಹಾಕ್ಬಿಡಿ. ಎಸ್ ಚಿಮರ್ ಕಳಿಸಿ. ಅದು ಕಟ್ಬಿಡಿ ಮೇಡಮ್, ಕಟ್ಬಿಟ್ಟು ಕಳಿಸಿ. We'll give it, yes. Because if I have to take it in camera, then I have to see what is there in that.
Yeah.
Yes.
Court may take a decision, but
Yes, I will do it. Yes.
we thought it should be brought before the court.
No, no, ಅದಕ್ಕೆ let me see that. I'll take a decision to what is
Court
to.
will see the 9th matter,
9th matter.
9th case. The
ಅದು
gory-
ಅವ್ರ್ದೇನಾ?
gory details of, yeah,
That is-
again, it's the same
That is
petition.
anticipatory bail.
ಹೌದು,
No,
anticipatory bill.
ಅದ್ರಲ್ಲಿ ಇನ್ನು
ಆಯ್ತು. Anyway, both will take it on 12th. Yes.
All of, all three men. There's no gory details. These parallel senior counsel prejudging the whole issue.
ಅಲ್ಲ, if
Well,
this
but
is
we will
not
show
gory.
before- No, I will show before your lordship, there's
ಅಲ್ಲ,
nothing.
if
I
this
will
is
know,
not
it's all
gory,
Gory
what else
details,
can
I don't know.
In fact,
Strong
I-
statements,
I-
not when particularly professor makes statement, I take it very seriously. Says,
He takes it very serious.
ಅಲ್ಲ, ತಾವೇ ನೋಡ್ಬಿಟ್ರೆ ಆಯ್ತು,
ನೋಡೋಣ,
whether
I
gory
will show
details
them.
ಅದು.
Yes.
ಆಯ್ತು.
Yes. ಎರಡು 12ಕ್ಕೆ ಹಾಕ್ತೇನೆ. 12ಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ 19ಕ್ಕೆ.
ಆಯ್ತು.
Three matters.
ಮೂರ್ ಇದೆಯಾ?
ಎರಡು anticipatory bill.
1, 7 and 9.
One and
ಏನೇನ್ ಹಾಕಿದ್ದೀರಾ? ಒಂದು bail, regular bail.
two are not, and two separate FIRs were filed.
Anticipatory bail.
And
Anticipatory bill.
the other two are anticipatory bail.
Anticipatory, both
Totally,
are-
there are 4 cases against this petition.
ಆಯ್ತು. ಎಲ್ಲ ಮೂರನ್ನು 12ಕ್ಕೆ ಹಾಕ್ತೀವಿ. 1, 7 and 9.
Please.
All right, yes.
Number
Yes,
2.
Venkatesh.
Difference between 200 and 223 of CR BNSS.
ಅದು ಕಂಪ್ಲೇಂಟ್ ಬಂದಿದ್ದಾರಾ?
Bandidare, I have served synopsis, my lords. May I just pass on the synopsis? It is after sworn statement, no show cause has to come to.
Should be allowed.
This is
Or
a clear misinterpretation of what the new provision says. 200,
misinterpretation.
yes, please.
Yes, but then I'll take it tomorrow. You interpret it properly.
No, what the, if I may be allowed to read only one
All
proviso.
right, tell me, ma'am. Yes.
There's a proviso added in 223 of BNSS.
BNSS, yes.
Which requires a pre-cognizance.
Pre-cognizance notice to be issued, yes.
The accused, my lords.
Hmm.
Now cognizance has not been taken. And the first sentence, the subsection 1 of 223 of BNSS read,
Yes.
a magistrate having jurisdiction while taking cognizance of an offense on complaint shall examine upon oath. Now, while taking cognizance, now complaint has been filed, immediately show cause notice has been issued to accused. So the cognizance stage has not occurred as of yet.
But notice is issued?
Notice is issued immediately after filing of the complaint, my lords. It's as good as a,
Yes, sir.
But so far as the recording of sworn statement is concerned,
That's not done.
that is not done. They have straight away issued notice. Now earlier under 200 CRPC.
No, now your submission is under the BNSS 223.
Yes.
Now the complaint, once it is presented,
Presented.
sworn statement
Has
should be
to be
recorded. And
Then show cause notice. Because the problem is, unless my lord's entire material is before the learned judge, my lords, he'll not be in a position to, when the complaint is ripe for taking cognizance. My lords, kindly take 226 for a moment of the same BNSS.
dismissal
I
of
can-
complaint. You can dismiss the complaint.
Yes,
also.
that is after recording the,
Sworn
based on the
statement.
sworn statement. So I will have to appear and say that this is not a case where he can take cognizance and proceed under 227. At that stage, my role will come, because even under 200 CRPC, till 204, I had no role to play. By that time, the sworn statement would have been recorded and the learned judge would form an opinion, then he would issue.
Well, consider there's something in what she says.
Not
And of also what you say, we'll see.
Yes.
226.
I have given the, I have given the chart, my lords.
Because this is for the first time coming
I
up before a
understand.
court, we'll decide.
My lords, synopsis I have played.
What is there?
I have given the chart as to how the 200 was worded and 223 was, we have, BNSS. Just now I passed it.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
Put it.
You have anything to say with this, madam? Seen this?
Yes, please, we have seen. He refers to 226, my lords,
So
which is.
your submission is that
It is a
that stage has
pre-cognizance.
not yet arrived. While taking cognizance, a notice to be
It's
issued.
been added in the new provision.
That is true.
Now, if my lords were to see 200 CRPC, court taking cognizance, definitely there was an indication that after cognizance only, sworn statement.
One
is to be
statement to be recorded
after
after
cognizance.
cognizance.
Now, BNSS, while taking cognizance, that's for, it has to be an exercise before taking cognizance by
So
the.
now it is before, so one statement before taking cognizance, notice issued and then
Yes.
hear you and take cognizance.
Take cognizance, then I can appear and tell the honorable court that under 226, you have no ground to proceed against me.
ಏನೋ ನಡೆಯಲ್ಲ.
So therefore, at that stage, 226, he can dismiss it, or he can invite me for as an accused under 227 by issuing a process. Otherwise, mere sending and show cause notice without the complaint is being ready for cognizance makes meaningless.
Because there is no judgment on this.
No judgment. I tried to find out, my lords.
No, in the entire new provision, no judgments.
Even
So
my lords,
unless,
226 also, it corresponds to the stage at
Correct.
the stage when cognizance is taken.
Will answer. ಅಷ್ಟೇ ನಿಮ್ಮ submission.
The proviso, my lords, I would rely on the proviso
Yes.
that no cognizance of an offense shall be,
Unless he is heard.
he is heard.
So it is only after his ground is that sworn statement should be recorded and then notice should be issued. Is that correct?
yes,
Yes.
Yes,
Lords,
for
unless they
which I
come-
would rely on while taking cognizance.
because it refers to pre-cognizance stage. While taking cognizance is pre-cognizance.
Will
stage.
interpret because
Very
this
well.
will have a far reaching,
Yes, my lord.
wide
We'll have a
ramifications. So-
Guidance also to be.
Yes. Reserved.
Grateful.
Yes.
Because interim order is there.
Interim order subsisting will continue till the next date of hearing. Answer it fast. Heard so and so ಅಂತ ಹಾಕಿ. Next.
Number 3.
Setting a garland on
Garland.
compromise.
Huh?
He went, the petitioner, my lords, allegation is 171F and 341 of the IPC.
ಕೊಟ್ಟಿರ್ಬೇಕಲ್ಲ.
My lords,
ಕೊಟ್ಟಿಲ್ವಾ?
lordships are ordered to defer the proceedings of the trial court. Not expressly ordered for a interim order.
Yes, sir.
341 without permission, they have conducted a rally, my lord, and.
No, there was no rally.
And that caused
Allegation is
public
that the
nuisance
public-
and.
Why did you need a JCB to Garland?
It was not organized. It was stated that, that the petitioner has gone there to put the saffron and he was wearing a shawl on his neck.
Yes.
Obstructed public.
List on 19th, the interim protection granted shall continue to the next date of hearing. Next. Suyog. Oh, yes, sir.
Offence alleged is section 188, my lord. Now, my lord, one private complaint has been filed, my lord, by the first respondent, and against which, my lord, for same offence, cognizance has been taken. That has been stayed. Simultaneously, my lord, he lodges a police complaint, my lord. That was not, my lord.
It was not even
registered as a
maintainable.
So,
Heard the learned senior counsel Arun Shyam appearing for the petitioner. The learned counsel for the petitioner was before this court in writ petition 15573 of 2024, challenging the
Private complaint for 188 offense.
challenging the registration of a private complaint for offense punishable under section 188 of the IPC. This court grants an interim order of stay. Immediately thereafter, it transpires that the very complainant registers a complaint before the jurisdictional police, which has charge sheet agidya.
charge sheet rejected, my lord, and the same has been treated as private complaint. Once again, he takes cognizance on that.
Yes, so it's,
188 is good.
the very complaint before the jurisdictional police was not maintainable for offense punishable under section 188 of the IPC. The concerned court rejects the charge sheet and treats it as a private complaint and takes cognizance of the offense, all over again. Therefore, there shall be an interim order of stay of further proceedings qua the petitioner. Stay of the impugned proceedings qua the petitioner. Tag this petition along with writ petition 15573 of 2024. List them both on 26th. Next.
For the petitioner. Can you grant me a week's time, my lord? I will get the instructions in this matter. Interim order.
List the matter on 26th at the request of Sharad Dodwad. Interim order subsisting shall continue till the next date of hearing. Next.
Order number 6.
Furnishing of copy.
Notice I'll accept.
During the course of the day, during course of the day, I'll furnish.
Counsel for the petitioner submits that the needful would be done during the course of the day.
Interim order.
List the matter on 20th.
Flying squad, I can.
Alle Sharath idralla, Sharad Dodwad. Sharath. Counsel Sharad Dodwad is directed to accept notice. Accept notice for the second respondent. Petitioner to serve set of papers upon the aforesaid counsel. List the matter on 26th. Interim order subsisting shall continue to the next date of hearing. Next. You don't go anywhere. Don't go flying. Flying squad gala anywhere. Come. Yes. Yes, next.
79 of Juvenile Justice Act and
Up to
188
your
non-cognizable offences.
post immediately after service of notice upon the second respondent. Interim order if any shall continue to the next date of hearing. Next. 9 illa. Arjana. 10.
38 petition, please.
ಓದಿಲ್ವಾ?
Anticipatory bail ಇಲ್ಲ ಓದೋದು.
Huh?
ಓದೋದಿಲ್ಲ. Slightly not well today.
Not well,
Yeah.
Then we'll take it next week.
Let's,
For a-
urgency is much 85-year-old man. He, only 420 is alleged. Now, kindly appreciate, page number 18 is the complaint. It pertains to, please, Millards, the offenses, Millards, are traceable to the year 2014 to 19. After 6 years, he comes around and files a complaint, please.
What is this page 56 orders?
Millards, an earlier instance, please, Millards, this honorable court, please, Millards, had granted anticipatory bail. That is the reason, Millards, we just placed that on
85
record. 85 ವರ್ಷ ಸಿದ್ದರಾಮಪ್ಪ ಸಾತ್ಲಿಂಗಮ್ಮ ಮೇತ್ರೆ Millards versus state of
ಸಿದ್ದರಾಮಪ್ಪ?
Sathringappa Maitre
Ah,
versus state of Maharashtra,
ah.
Millards, and ad interim, Millards, could be considered. Millards,
Till you file your
till
objections.
objections are filed.
Copy. Let him give copy.
No, the
The-
application, Master.
The petitioner. Second petitioner, yaru?
Millards, all are members of the HKE society, please.
Oh.
Millards.
Petition copy.
The first petitioner is an octogenarian. The second petitioner, septa. Then the third petitioner, hexa. Third and fourth hexagenarians are before this court seeking grant of an anticipatory bail owing to their anticipatory bail for an offense that is alleged against them, the one punishable under section 420 read with 34 of the IPC. The learned counsel for the petitioner would take this court through an order passed by the bench dated 4th July 2024, which has granted interim bail to identically placed to these, Yurgena,
ಇಲ್ಲ ಬೇರೆ,
in the same crime,
same crime.
to other accused in the same crime. The learned additional SPP would submit that objections ಆಗ್ತೀರಾ?
Don't have the papers, my lord. I have
If
asked for
the
a copy.
objections would be filed in the next 2 weeks. List the matter on 26th. Owing to the aforesaid ages of these petitioners and the coordinate bench granting an interim, granting anticipatory bail to the co-accused in the same crime, so as observed supra, it will grant them bail. Supra, the petitioners are also entitled to the grant of an anticipatory bail
Interim.
as
Interim.
interim go anticipatory bail.
Add interim anticipatory.
Add interim bail till the objections are filed by the respondents. List on 26th.
Great.
Next.
11.
Yes, Shivraj. ಬರೋದೇ ಇಲ್ಲ.
Copy is also not.
Huh?
Copy also not served.
Counsel for the petitioner to serve set of papers upon the additional SPP forthwith. List the matter on 19th. Next, there's no representation way of the petitioner. Amal Barevi. Next.
12 and 13, both, my lord.
12 and
13, my lord.
13.
Permitted to file wakalat. So for
13 M for the petitioner, my lord.
12 and 13, my lord. All the connected matters. It's connected to the same crime, my lord.
Yaudu, even 13 is it?
Yes, sir.
Yes, my lord, so 13 M for the petitioner.
13
It is,
for
it shall be,
13 is accused number 4.
Tag this.
it is
tag
supposed to be
serial
connected, my
number
lord. There
12
was a-
with 13. List them on 19th. Interim order diya?
Interim order.
There is an
Interim order subsisting shall continue till the next date of
May
hearing.
be permitted to come on record and file. my
Learned
lord.
counsel so and so undertakes to enter appearance for the second respondent complainant. Registry to print the name. 13 ಅಲ್ವಾ?
12 and 13.
ಎಲ್ಲದ್ರಲ್ಲೂ.
ಎಲ್ಲದ್ರಲ್ಲೂ.
Registry to print the name of so and so is appearing for the complainant. Next. Interim order subsisting shall continue till the next date of hearing. List on 26th. Next.
Much obliged.
19th, yes.
IMA.
ಎಲ್ಲಿ ಇವ್ರು? ಪ್ರಸನ್ನ ಕುಮಾರ್ ಇಲ್ಲಿದ್ದಾರೆ, ನಾನು ಅಲ್ಲಿ ನೋಡ್ತಾ ಇದ್ದೆ. Yes.
Not the same petitioner is not urging all these grounds. The trial court not again listed today.
ಬಟ್ ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳಿ
ಇದೆ.
ಇದೆಯಾ?
One ground, not the
Entries in the diary.
entries in the diary do not have 65B. Apex court has time and again held. 65B, it's a matter of evidence which can be given at any point in time.
Correct. I have also heard.
ಅಷ್ಟೇ. ಈಗ ಅದನ್ನ overlooking that judgment, trial judgment has passed an order in respect of one of the public servant holding that this is lacking 65B ಅಂತ discharge ಮಾಡಿದ್ದಾರೆ. Now he wants to rely upon that.
No, I've not relied upon it. I've just placed it for your lordship.
Ultimately,
My lord, I'm not saying, my lord, it is after, my lord, I've filed the petition. That order is passed 3 years after. So that's not my case at all. One of the circumstances is that.
ಹನ್ನೆರಡು ಕೇರ್ ಮಾಡಿ.
Please.
Your lordship,
We'll
Please.
close it on 12.
Please.
lordships had heard very well.
I have been hearing that.
12th.
ಅದೇ entries to tune of so and so.
Gross.
Sorry.
They recently contested in the elections also.
ಅದು ಮಾಡಿದ್ರ?
ಏನ್ ಮಾಡೋದೇನಿಲ್ಲ.
ಗೆದ್ರ?
ಅಲ್ಲ, ಕೆರೆ ನೀರನ್ನು ಕೆಳಗೆ ಚೆಲ್ಲದ್ರು ಅಷ್ಟೇ.
ಅಲ್ಲ.
ಸೋತ್ರು. ಈ ಲಾಸ್ಟ್.
ಗೆದ್ರ? ಇಲ್ವಾ? All right.
ಗೆಲ್ಲೋರು ನಮ್ಮ
ಹ?
ಗೆಲ್ಲೋರು ಆ ಕಡೆ ಹೋಗ್ತಾರೆ.
All right. Yes.
Please.
12th. ಅವತ್ತು ಪ್ರಸನ್ನ ಕುಮಾರ್ ಮುಗಿಸ್.
I shall.
Great.
Same conditions, ಅಲ್ಲಿ chamber ಅಲ್ಲಿ ಮಾಡಿ, all conditions.
15 minutes, hate speech.
ಒಂದು ನಿಮಿಷ. Yes.
Interim order is there, can be taken on 19th.
List on 26th, interim order subsisting shall continue till the next date of hearing.
34 also, same petitioner.
ಯಾವ್ದು?
34.
ಬರ್ಲಿ ಅಲ್ಲಿಗೆ?
Okay.
Yes.
Second respondent filed a complaint on behalf of the third and fourth respondent.
Respondents ಅಲ್ಲಿ interim order ಇದೆಯಾ?
Interim.
Same 26th IO.
My lords, short accommodation.
Interim order ಇದೆಯಾ?
Yes, my lords.
26th IO. Next.
This case. No, it's a civil case, please, my lords, blown out of proportion. What transpires, my lords have captured the whole issue, please, my lords, in the interim order.
Interim order ಕೊಟ್ಟಿರ್ಬೇಕು.
ಕೊಟ್ಟಿದ್ದೀರಿ. What transpires, my lord, they have sold the property to us for consideration of 9 crore rupees. Consideration is passed on. Thereafter, please, my lord, they go institute a suit, my lords, for declaration and injunction. Interim orders are not granted. After that, my lord, they come up, my lords, before the police to say, lords, I am making
No,
development.
there is a detailed order, right?
Please,
Yes.
it will only cover, the same thing will have to be.
Respondent ಬರ್ಬೇಕಲ್ಲ?
ಬಂದಿದ್ದಾರೆ ಸ್ವಾಮಿ, somebody.
ಎಲ್ಲಿದ್ದಾರೆ?
They gave us the objection statement also.
All right, learned counsel for the respondent seeks time to file statement of objections. List on 26th, interim order granted earlier, stands extended to the next date of hearing. Next.
Please, grateful, please.
ಇದೇನ್ ಮತ್ತೆ?
Date ಕೊಟ್ಟಿದ್ದು ಅಂತ.
It's appearing for proxy counsel, senior is in the out of station.
Out of station? Hello, what is this?
Not the one, what the order has been not observed by your lordship, see, not 195 capital A. You want whether 195 is a bar, may not.
Oh, this I
threatening
granted an
witness-
interim order.
Threatening
Correct.
witnesses. But I'll just bring to your lordship kind notice, maybe heard on some
Senior
other day.
ಇಲ್ವಂತೆ?
Alla, same, it
We'll
can
take
be
it
heard on
on-
some other day, but your lordship may have to may not consider 195 capital A of CRPC.
ಅದೇ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
ಅಲ್ಲ 195 ಮಾತ್ರ ಮಾಡಿದ್ರು, 195 capital A ಮಾಡಿಲ್ಲ.
ನೋಡಿ ಇಲ್ಲಿ ಆರ್ಡರ್.
But 195,
Interim order ನೋಡಿ.
I'll,
It's a 4-page interim order.
please, I'll,
195 capital A.
then I'll prepare myself on this
Exactly, sir.
grounds.
No, what if 195 capital A is introduced later by way of an amendment?
Please.
That does not take away the procedure to be followed under 340. No procedure is followed.
ಅಲ್ಲ,
Who has to
complaint
take,
ಇಲ್ಲಿ-
and which court has to complain? You have gone and registered the complaint before court at Dharwad. Everything has happened here before the special court. How do you do that?
ಅದ್ರಲ್ಲಿ ಮೇಡಮ್ ಇಲ್ಲ.
ಮತ್ತೆ ಅಷ್ಟೇ. I remember what I have granted. Yes. Heard, the list the matter on 26th, interim order subsisting shall continue till the next date of hearing.
Please.
ನೋಡಿ, I have,
Yes,
the interim order, it's a detailed interim order that I have granted, just see it.
Number 20, my lords, I appeal for the petitioner. My lords, senior appears, he's on his legs. My lords, your lordship may kindly have it on Monday, my lords, coming.
Then we'll vacate the interim order.
My lords, he is. he
List the
appears-
matter on 26th, interim order subsisting shall continue till the next date of the hearing. Yes, sir.
21.
For petitioner, my lords.
On compliance of office objections.
1 week time maybe.
ಓ, ಇದೇನಾ ನೀವು ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದು? Yes. A week's time is granted to comply, weeks, ಏನ್ covered ಏನು?
ಇದಲ್ಲ my lordship, ಇನ್ನೊಂದಿದೆ court
ಇನ್ನೊಂದಾ?
measurement.
Week's time is granted to comply with the office objections. Interim order subsisting shall continue till the next date of hearing. ಇದು interim order ಇದೆಯಲ್ಲ phone? Yes, 26th IO. Oh, 21, sorry, till 20 ಹೇಳಿದ್ದ ಈಗ? 21. No, 1 week time is granted to comply with the office objections, 26th, yes, Paul.
3 and 153A.
Correct.
He-
Take ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ?
Yes, Lord, while my lord distributing the Mantrakshara of the Ram Mandir.
ಮಂತ್ರಾಕ್ಷರ.
Yes,
Really,
Mantrakshara
charge
of
sheet has been
Ram
filed.
Mandir.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ.
Charge sheet has been.
Stay ಇದ್ದಾಗ ಹೆಂಗಾಗ್ತದೆ ಚಾರ್ಜ್ ಶೀಟ್?
Before he files the petition itself, charge sheet came to be filed.
Then why have you not stated that?
No, my lord, it is transferred from Dharwad bench to Bangalore bench. my
All
lord.
right.
Yes, my lord.
ಇಲ್ಲಿ ಟ್ರಾನ್ಸಿಟ್ ಆಗ್ಬೇಕಾದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರ ಇಲ್ವಲ್ಲ?
Charge
My
sheet
lord,
filed on
ಮತ್ತೆ?
13/2/2024.
13?
Sir,
13/2/2024.
that is after the filing of the petition, before the grant of the interim order.
Because my lord, I have made my lord application immediately before.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಸರ್.
Please, my lord, in the
Interim
meantime,
order ಇರೋದ್ರಿಂದ amend ಮಾಡಿ.
please.
Yes. Counsel for the learned additional SPP submits that the charge sheet has been filed prior to the grant of the interim order, albeit after the filing of the present petition. Therefore, in the light of the pendency of the interim order, I deem it appropriate to permit the petitioner to raise a challenge to the charge sheet.
Interim order is only to not to precipitate, not.
Whatever, sir. so and so. List the matter on 26th. Needful be done by then. Any interim protection subsisting shall continue till the next date of hearing.
Please.
Next.
My lord, next one is my lord 153(1) and 153(2). Though there is my lord such provision
ಇಲ್ಲೂ
is
charge sheet ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ.
Entry ಮಾಡಿದ್ಯಲ್ಲ?
But no provision, my lord, available under the offense under section 153(2). But even though there is no definition.
ಅದು ಪಾರ್ಟ್ ಇವ್ರೇನ್ ಮಾಡ್ತಾರೆ ಪಾರ್ಟ್ ಬಿ ಗೆ ದೇ ಇಂಡಿಕೇಟ್ ಇಟ್ as 2. 506 ಅಲ್ಲಿ there is no B, but they say 506B, it is part 2.
Correct, my lord, but here 153(1) and 2 simultaneously, that is not
Stay
correct. my
ಉಂಟಲ್ಲ?
lord. Stay unto.
Yes.
My lord, this is also, my lord.
You should correct them. 506B ಅಂತ ಹಾಕ್ಬಿಡ್ತೀರಾ? It's
ಕೆಲವು
not
ಕಡೆ ಬಿ ಅಂತ
part
ಹಾಕ್ತಾರೆ,
2.
ಕೆಲವು ಕಡೆ ಪಾರ್ಟ್ 2 ಅಂತ.
The
Part
absence
2
of-
actually, because 506 is a non-cognizable
Yes, ma'am.
offense. If you see part 2, it is a cognizable offense.
Then, my lord, there is no mens rea here, my lord.
No.
There is no mens rea. He
List
has
on-
a, my lord,
List on 26.
has a 7-time MP of the, my lord,
ಅದಕ್ಕೆ mens
constituency.
rea ಇರಬಾರ್ದು
Just
ಅಂತಿದ್ಯಾ?
represented the.
ಅಲ್ಲ ಅದಕ್ಕೆ mens rea ಇರಬಾರ್ದು ಅಂತ.
ಏನು ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ
Just-
wait. List on 26th, interim order subsisting shall continue till the next date of hearing. Yes.
I appear for the party. This is 153 capital A, my lords.
All these 153 years will
Two
take
group.
one day and finish it.
No, this is through WhatsApp, my lord. The police said
Day
through
ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ sir.
5/4/2020.
ಹಾ. There's a detailed orders.
Yes, my lord. Of course, your lordships also interpreted in Raja Singh Thakur's case. 2
153.
groups should be a sine qua non for.
Yes, sir. That is
applicable.
following the judgment of the apex court.
Yes, yes. my lord.
But
And
Javed
so
Hajam-
far as the WhatsApp is concerned,
Javed Hajam and
Javed Ahmad.
Javed Hajam and Shiv Prasad Semwal, both
Yes.
2024. Yes. Heard the learned senior counsel appearing for the petitioner. List on 26th, interim order granted on 5/4/2024 shall continue to the next date of hearing. Yes, next.
Petitioner's form.
Then Leka.
Lord, some defamatory article, my lord, was published in a newspaper. Allegation that he, my lord, give a bite in the media. That is the allegation, my lord. And my lord,
Begun to give bites.
we are ready with the matter, my lord.
Yes, sir. You're ready with the matter. Why are you
Because
ready?
interim order was granted earlier.
ಇದೆ interim order.
Ready?
Ready na?
Ready.
ಹೇಳಿ sir. Yes, sir.
Lord, petitioner was a deputy speaker, my lord, from 6/3/2018 to 17/3/2020, my lord.
ಇದು ಅವಾಗಿಂದ ಇದು?
ಅವಾಗಿನ incident, cognizance taken later, my lord.
All right.
My lord,
Complaint is registered when time?
yes, my lord, it was registered in 1 month, my lord, after the incident, alleged incident taken
All
place.
right.
But the background is this, my lord, petitioner was a deputy speaker, against which, my lord, the respondent makes reckless allegation of, my lord, land grabbing and all. Lord, for which, my lord, he lodges a complaint, my lord, and that was registered as NCR. Then, my lord, the respondent was called to the police station and he was advised, my lord, and then endorsement has been issued to the petitioner. Lord, suppressing all these facts, he files this present complaint, my lord, on 25/11/2019, 13/12/2019, my lord. The NCR was, my lord, closed on, my lord, 25/11/2019. But the allegation is this, my lord, the paper publication, which is produced, my lord, at annexure, my lord, page 58.
Yes.
My lord, right side. Lord, this is, my lord, stated in the context, my lord, where he made reckless allegations. And, my lord, NCR was registered and the endorsement was given. He says, my lord, ಹುಚ್ಚ ಮೂರ್ಖ ಅಜ್ಞಾನಿ ಏನನ್ನ ಬೇಕು ಅರ್ಥವಾಗುತ್ತಿಲ್ಲ. This is the only allegation, my lord, against the petitioner.
How can you term someone as mad?
Lord, this is not he is saying ಹುಚ್ಚ ಅಥವಾ ಅಜ್ಞಾನಿ ಏನನ್ನ ಬೇಕು ಅರ್ಥ ಆಗುತ್ತಿಲ್ಲ, because he makes reckless allegation without there any basis. And, my lord, he simply, my lord, it is like a hit and run case, my lord. He gives
500,
499 500.
Correct, 499.
My lordship, first contention is that that I have not filed affidavit before the trial court.
ಅದು ಹಾಕಿದ್ದೀನಿ ಅಂತ you
ಹಾಕಿದೆ.
take it as your file.
Yes.
Yes, don't get into that contention. ಆಮೇಲೆ
Second contention is that I have not taken the sanction.
That also you have taken.
No, sanction is not required because there is no nexus between the press meet and the discharge of his
Discharge of
official duties.
official duties. Amale.
So third contention is that the trial court has not taken the cognizance and proceeded to record his own statement. In this regard, I want to cite a citation, my lordship.
Citation kodi.
ಯಾವುದು ಸತ್ಯ ಸೈನ್
Page 25, 27, my lordship. In page-
My judgment only you are giving.
This one,
My order, sir.
yes, my lordship.
Pradeep Odair, sir.
Yes, my lordship.
Curable defect.
Curable defect and there is no necessity of mentioning in the order sheet. It is presumed to because
Yes,
mention
sir.
has been taken.
Amale, sir.
And fourth contention is that these words doesn't fall under the definition of 499 and 500. He cannot call any person as a mad idiot.
Idiot.
Yeah.
ಎಲ್ಲಿದೆ
ಮೂರ್ಖ, ಹುಚ್ಚ,
ಹುಚ್ಚ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಮೂರ್ಖ,
Okay,
ಅಜ್ಞಾನಿ. And it sends a wrong message to the society.
correct.
Hence, I pray this honorable court to
Dismiss the petition. Yes, sir. Head.
Now, my lord, the grounds urged are, my lord, one is, my lord, that this is filed as a, my lord, counter blast and afterthought. Number one, my lord.
But the
And-
statements are statements, they are facts. Facts are
I'll
stubborn.
come to my lord.
Yes.
Now, my lord, that's it, that is number one, my lord.
Yes,
The
sir.
second ground is, my lord, the complaint has been filed with the oblique motive in order to harass and humiliate and tarnish. But
ಯಾಕೆ ನೀವ್ ಹೇಳೋದು ಅಬ್ಲಿಕ್ ಮೋಟಿವ್ ಅಲ್ಲ?
ಅಲ್ಲ, ಅವ್ರು ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ನಮ್ಮ ಮೇಲೆ ಹಾಕಿ he makes reckless allegation and I, my lord,
ನೀವು ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿಲ್ವಾ?
no, I gave a complaint, my lord, police that was registered as NCR.
You should have filed a private complaint for defamation.
No, my lord, he also holds a press conference against me, my lord.
ಆಯ್ತು, ಆಲ್ರೆಡಿ
Sir,
he
this is-
also ಬಿಡಿ. ನಿಮ್ ಮೇಲಿಗೆ ಅಲಿಗೇಷನ್ ಇದೆ, ನೀವು ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿಲ್ಲ. You have to answer that.
Yes. But my lord, he gives a statement before the
Our
police.
4 grounds, 4 replies.
No, my lord.
Straight reply, straight answer.
No, my lord.
No beating around the bush.
No, my lord, there is no independent witness, my lord, supported the claim or contention of the complainant.
It's a press conference,
No, my lord.
public domain.
Lord, now the sworn statement has been recorded, which is very bald and vague, my lord. Kindly see, my lord, page. 55 is, my lord, 52, CW1, my lord, the complainant. Lord, he says, my lord, only, my lord, the defamatory statement has been made. Only that he says, my lord. And my lord, there is a difference between, my lord, the date given in the complaint and also, my lord, in the sworn statement. The complaint, my lord, he says, my lord, on 16th, the press meet was held. Then, my lord, in the sworn
Press
statement.
meet is a matter of fact. ಯಾವತ್ತಾಗಿದೆ ಅಂತ ಡೇಟ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದ್ರೆ that does not absolve
lord.
you. ಆಮೇಲೆ
But, my lord, it is a bald sworn statement where there is, my lord, no ingredients has been attracted to,
Aye.
attract, my lord, section
Amele.
499.
Hmm.
Next, my lord, the CW2, who's supposed to be an independent witness, my lord, he should have stated two things, my lord. The complainant, my lord, is a reputed person and his reputation is tarnished by virtue of the alleged defamatory statement given.
Oh.
He has not stated, my lord, anything, only vague statement. Kindly see page 55 for a moment, my lord.
So only a reputed person can be,
No, my lord,
reputed person's image can be tarnished.
not so, my lord. He should, my lord, state two things, my lord. Independent witness should come and say.
You mean to say
is the
reputation is only of a reputed person?
Reputation was there and it has been tarnished. Now, both is missing, my lord, in this case. Kindly see page 55. It's vague sworn statement, my lord. Therefore, my lord, my respectful submission is even 202 is not complied.
ಏನ್ 202
Inquiry.
is not? What 202 is not?
My lord, the cognizance is taken by the special court. But, my lord, accused, my lord, while issuing, my lord, process, he has not complied 202. Inquiry has not been conducted.
Why
properly.
inquiry?
My lord, he is residing outside the jurisdiction, my lord. The complaint was earlier filed before the regular magistrate. Then it was shifted
Transferred to the special court.
special court, my lord. But now, my lord, while issuing
Special
the
court is not there everywhere.
my lord, now the,
It's only one.
yes, my lord.
So the 202 goes next.
My lord, the inquiry as contemplated, my lord, in
Not
order to
necessary, sir.
satisfy himself
There is
that, my
only
lord,
one court.
in order to satisfy himself that, my lord, the matter requires, my lord, issuance of process. That has not satisfied, my lord, is my respectful submission. Lord, the other ground is counter blast, my lord. The moment I filed a complaint, he filed this private complaint. That is one. My lord, another ground is, my lord, suppression of fact. The complaint which was filed earlier, my lord, against him is not, my lord, nowhere mentioned in the complaint or in the sworn statement. That is another aspect. And my lord, delay of 30 days is there, my lord. That is another one. Lord, the other ground is, my lord, the ingredients are not attracted so far as 499 is concerned, my lord.
Why? You can call anybody this, is it?
No, not so, my lord. This is in the context of, my lord, case and counter case, and after thought, my lord, it has been filed. And my lord, here, there are few judgments, my lord, which says even calling merely by naming or calling something like this, my lord, does not attract, my lord, 499, unless, my lord, there is an intention to, my lord, defame.
All right, let's see. Yes.
And he is a habitual complainant, my lord. He has lodged many complaints, my lord, against so many people.
List on
He is
19th.
a
Heard
petition,
the
my lord.
learned senior counsel, so and so, and the council. List on 19th for dictating orders.
But only one
Interim order subsisting shall continue till the next.
one
hearing.
submission, my lord. There is one judgment we are relying upon, my lord. We placed on record, which says, my lord, politicians are, my lord, they should be
Thick-skinned.
thick-skinned. Yes, my lord.
Oh.
He is
I have seen that
my lord, he
thick-skinned
claims a politician, social worker, my lord, and
Control.
also my,
Vinod Kumar has
my
given the
respectful submission
thick-skinned
is, my lord.
judgment.
He's a troublemonger, my lord. He invited trouble. That is my respect.
All right. Yes.
Grateful.
List on 19th dictating orders. We'll continue 2:30.
27, my lord. I am appearing for respondent number 2, received copy today, my lord.
Learned counsel Sharad Dodwad seeks 2 weeks time to file statement of objections, if any, or make submissions. List the matter on 26th. I vote till then. Yes. Heard Kirtana Nagaraj. Yes, next.
28. Plus, I am for petitioner plus.
26th.
Yes,
List on 26th. Interim order subsisting shall continue till the next date of hearing.
Publish plus.
In this case, the respondent, my lord, court notice agli swami. Copy receive agide, ನಮ್ಮ ಕಾಂಟ್ಯಾಕ್ಟ್ ಸಿಗ್ತಿಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್.
ನಿಮ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಸಿಗ್ತಾ ಇಲ್ವಾ?
ಇಲ್ಲ.
ಬೇಲ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಸಿಗ್ತಾರೆ.
My lord's trial is fixed tomorrow itself.
Tomorrow.
Tomorrow. The
We'll
witness
keep the
summons,
petitioner present tomorrow. Complainant or health. Yes, what happened, man?
the trial is fixed tomorrow. Witness
Trial is
summons
fixed tomorrow.
has been issued. It would render a petition infructuous, your lordship. The offense is 3-1R, my
I am
lords.
aware, madam. ಧಾರವಾಡದಲ್ಲಿ ನಾನೇ ಮಾಡಿದ್ದು first.
227
ಇದು
rejection.
cancellation of bail da ಇದು.
ಅಲ್ಲ 227. They come and discharge.
Rejection.
Discharge.
Yes.
No grounds to discharge at all.
3-1R does not attract, my lords, because the entire case, it is completely, there is political vendetta involved in this.
Aware, yes.
Even 504 once if we agree also, but 3-1R, he's merely stating it was not with an intention to humiliate because he belonged to the SCS. There's a para in the complaint, if I may be permitted to read, your lordship.
Yes.
At page 106, the complaint copy.
This is that flex problem.
Flex, it arises, prior to that also, there were newspaper publications published by the complainant against the petitioner.
ನೀವು ರೆಡಿ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಸರ್.
ಯಾಕೆ?
Senior.
Yes. We'll post it on 26th.
That,
1 minute. List the matter. Heard the learned counsel appearing for the petitioner. The learned counsel for the petitioner would seek to contend that the offense punishable under section 3-1R or S would not become applicable in the case at hand. The learned counsel for the respondent seeks time on the score that the arguing counsel hyphen the senior counsel is not available today. List the matter on 26th. Till such time, the concerned court shall defer its proceedings.
3-1R only, my lords, not 3-1S is not. touched.
We'll decide. Yes. Next.
I appear for petitioner. Lords, this is one of those iron ore mining export matters.
ಇದು BS Prasad ಎಲ್ಲಿ? All these matters are the same.
Lords, my lords was the vendor to the, both are the same.
Stay ಇದೆಯಲ್ಲ?
Stay.
Yes. Again, madam, 26th. Madam, 26th ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ ಜಾಸ್ತಿ ನಾವು. Right. 26th, list on 26th. Awaiting the appearance of counsel Shri B.S. Prasad. Interim order subsisting shall continue to the next date of hearing. Next,
30 and 30.1 minutes.
both. Yes.
Please, oblige.
31.
All revision petition will hear on 26th.
Kindly secure the records, send back the, kindly directly register to secure the
Yes,
records.
so SCR sent to Sessions Court. Why?
We filed application for withdrawal of amount, that's why trial court records.
You have withdrawn the amount?
No, Lord. Bank guarantee order ಮಾಡಿದ್ರು 2 lakhs something ಏನೋ
The
bank
registry is directed to secure the concerned court records by the next date of hearing. List on 26th.
much please.
Yes, next.
32.
ಏನಿದು?
CD.
ನಿಮ್ಗೆಲ್ಲ CD ಇಲ್ಲ ಪೆನ್ ಡ್ರೈವ್.
26.
ಅವತ್ತಕ್ಕೆ 26th, list on 26th. Interim order ಇದೆಯಾ? Subsisting shall continue till the next date of hearing. Yes, Balakrishnan sir.
I appear for the petition.
Ah.
Since charge sheet is filed, this may be dismissed as not pressed.
Yes, madam. On the chat. Yes,
Please,
Liberty, yes. Further hearing?
Further hearing 34.
ನನ್ನ ಮುಂದೆ ಐತಾ further hearing?
My lords, I appear for the petition.
Ah.
My request for 26th, my lords.
List on 26th at the request of the council for the petitioner.
For the interim order.
Interim order subsisting will continue to the next date. Namdena. So. Okay. 26th, next.
E group at 230, 35.
Appearing for the petitioner, my lord.
Ah,
Hello, one development says, Professor Ravi appointed as a special public prosecutor in this case.
ಯಾರು?
Professor Ravi Kumar, senior counsel.
ಹಾ, ಸರಿ.
Date accommodate ಮಾಡ್ಬೋದು. Just I have briefed the matters.
ಆಯ್ತು, ಯಾವತ್ ಬೇಕು?
After 12th, any date.
19ಕ್ಕೆ ತಗೋಣ.
ಆಯ್ತು.
19th.
Leonard, yes sir. The Leonard counsel, ನಮ್ಮ ಹೆಸರು sir.
Ashok Naik, special people.
Ashok Nayak.
Yes, any item.
Leonard counsel Ashok Naik submits that counsel, Leonard senior counsel, Professor Ravi Kumar has been appointed as the special public prosecutor in the case at hand in terms of an order dated.
Dated 3/9/2024.
In terms of an order of the state government dated 3/9/2024, the learned counsel would submit that the senior counsel would be briefed if 10 days time is granted. At the request of the counsel for the respondent Ashok Naik, list this matter on 19th. 19th, interim order subsisting shall continue, interim order / protection shall continue till the next date of hearing.
The connected matters as well.
ಎರಡು ಒಂದೇ?
ಎರಡು.
ಹಾ. ಮೂರು ಇದೆಯಲ್ಲ?
ಮೂರಿದೆ. ಎರಡನೇದು
ನಾಯಕ್ ಅವರೇ,
Yes,
ಮೂರಲ್ಲೂ ಸೇಮ್
all
ಮಾಡ್ರ?
the three, yeah.
ಸೇಮ್ ಮಾಡ್ರ.
List number 3, fresh matter, still number 1.
ಪ್ರದೀಪ್ 50% ಮಾಡಿದೀರಾ? Acknowledgement ಯಾಕೆ ಹಾಕಿಲ್ಲ?
Already filed, my lord.
While learned counsel for the petitioner submits needful has been done. Office to verify, list the matter after 4 weeks. Interim order subsisting shall continue to the next date of hearing. Next.
Petitioner, my lord.
List after 4 weeks. Interim order subsisting shall continue till the next date of hearing.
3.
Jagdish Aure, inform the Advocate General that I'll take up the matter immediately after completion of this list, even if it's 3:15 or whatever. Yes. List after 4 weeks, interim order subsisting shall continue to the next date of hearing.
The mediation is on 11th. Mediation, second session is on 11th.
11th.
Client is not agreeable for mediation.
ಇವತ್ತಿಂದ ಯಾವ್ದೋ ಇದಾವ ಐದಾರು
Mediation might not happen, my lord, because
May not happen.
ಇಲ್ಲ possibility.
Be positive, sir.
Being positive, my lord, we tried our level best, but two applications, one is 311 and seeking for video conference overseas. These are the two applications which came to be rejected.
Settlement agata ilva?
Possibility is there, my lords.
11th idea?
11th ಗಿದೆ.
List on 12th in the fresh matters list.
Please.
Yes.
Apply.
Avat agilla andre will pass out.
Please.
Yes.
Apply.
Interim order to.
Interim order subsisting shall continue to the next date of hearing.
Five.
Copy is out to the lower court advocate.
Huh?
One issue.
PF Katilva.
Paid. It's paid.
Counsel for the petitioner submits needful has been done. Office to verify interim order subsisting shall continue till the next date of hearing, till the appearance of the petitioner, respondent. Next. Post immediately after service of notice upon the respondent. Idiyalla bandidare, yes. Why is this awaiting service?
My lord, I,
Huh?
respondents, I,
Alla Ravi Kiran ಅಂತ ಯಾರೋ ಇದಾರಲ್ಲ?
yes, my lord, entered the appearance. My lord, I have deposited the 50% before the family court.
Learned counsel for the petitioners of one ನಿಮಿಷ. This court on 9/8/2024 had passed the following order. The learned counsel, ಎಲ್ಲಿದೆ acknowledgement?
I have filed the acknowledgement on 29.
Learned counsel for the petitioner submits in terms of the order, 50% of the amount of arrears has been deposited before the concerned court. The submission is placed on record. Interim order granted earlier stands extended till the next date of hearing. Will permit the wife to withdraw the amount. Last I'll ಬರ್ಕೊಂಬಿಡಿ before that. The respondent wife is at liberty to withdraw the amount of 50% that is deposited pursuant to the direction dated 9/8/2024. The, on a necessary application being filed, the registry shall transmit the amount in deposit to the account of the respondent wife.
I had deposited before the family court.
Family court.
Please.
ಅದೆಲ್ಲ ಹೊಡ್ದಾಕ್ಬಿಡಿ. The respondent wife is at liberty to withdraw the amount that is said to be deposited before the family court in accordance with law. Yes. Next.
7.
Respondent, my lords. I filed wakalat. I need 1 week time to file.
Learned counsel for the respondent seeks 2 weeks time to file statement of objections, comma, if any interim order subsisting shall continue. Ilva?
ಇಲ್ಲ ಇದೆ.
Continue till the next date of hearing.
Date may
Next.
be, my lords, 26th. 26th.
ಅದೇ ನಿಮ್ ಡೇಟು?
ಅಲ್ಲ 20 ಯಾವ್ದು ಎನಿ ಡೇಟ್.
ಮುಹೂರ್ತ ಚೆನ್ನಾಗಿದೆ.
ಅಲ್ಲ ಹಾಗೆ
ಇಲ್ಲ.
ಎನಿ ಡೇಟ್.
All right. List on 25th.
ಆಯ್ತು.
Next.
Number 8.
For the petitioner, my lord. The election 171.
List after 4 weeks, interim order subsisting shall continue till the next date of hearing. Next. Interim order ಇದೆಯಾ?
ಇಲ್ಲ. The student, my lord, of age 19 years. Sole allegation is that he was alleged to be having an affair with the victim's wife. And on that score, my lord, he came to be.
You are a student of,
I am a student, my lord, of.
you are 19 years old.
19 years old, please.
You are alleged to have an affair with whom?
The wife of the victim.
Wife of the?
Victim. 306 is your.
Wife of the victim.
Please.
Who is the victim?
But he's no more, he's deceased, 306.
What was the age?
He
of
was
the victim?
26, my lord. He was. 26 years, please. ma'am.
Death note ಇದೆಯಾ? Yes,
ಇಲ್ಲ.
madam. ಇದೆಯಾ? Papers ಎಲ್ಲಿ madam? ಬಂದಿದೆಯಾ?
We'll secure documents, my lords.
You have secured?
Please, not at my lords, we'll secure the documents.
All right. The learned HCGP is directed to, notice ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ.
Please.
The learned HCGP is directed to secure the papers of investigation and place it before the court on the next date of hearing, next Wednesday in the fresh matters list. No? Next, let me see.
10.
This is, my lord, 340 proceedings initiated at the behest of the court.
It'll stay there. List after 2 weeks, interim order granted earlier stands extended to the next date of hearing. Next. Shanti Bhushan.
306, my lord, the ingredients of one.
ಕೊಟ್ಟಿದ್ದೀನಿ.
No, my lord, in the similar matter, my lord,
ಅದೇನು similar?
almost similar.
Almost similar.
The allegation is that, my lord,
I directed records. ಯಾರಿಗೆ ಇವ್ರು ಇರ್ಲಿಲ್ಲ ಅವರು. ಇನ್ಮೇಲೆ ನೇಮ್ ಹಾಕ್ಬೇಕಂತ ಅದಕ್ಕೆ ಹೇಳಿದ್ದ. ಎಸ್ ತೇಜಸ್ ಅಲ್ಲಿ ಇಲ್ವಾ? ಎಸ್. ಗೆಟ್ ದ ರೆಕಾರ್ಡ್ಸ್, ಲರ್ನೆಡ್ HCGP, one date. ಏನಿದೆ ಅರ್ಜೆನ್ಸಿ?
And absconding, my lord, his.
ಕಸ್ಟಡಿಲಿ ಇದಾರ?
No.
ಇಲ್ಲ ತಾನೆ? List the matter again on Wednesday in the fresh matters list. The learned HCGP is directed to secure the investigation papers.
Great.
ಅವತ್ತು ಕೊಡುವ. Almost similar. ಅದಕ್ಕೂ ರಜದ್ದು ಅಷ್ಟೇ, ಆಲ್ಮೋಸ್ಟ್ ಸಿಮಿಲರ್, ಅದಕ್ಕೆ ಹಂಗೆ ಕೊಟ್ಟಿದ್ದು. ನೆಕ್ಸ್ಟ್
Please.
12, I represent the petitioner. 12, my lords, I represent the petitioner, counsel.
ಫುಡ್ ಏನ್ ಇಲ್ಲ ಆಗಲ್ವಲ್ಲ ಈಗ?
ಅಲ್ಲ ಆಗಲ್ಲ. But my lord, the only thing is, my lord, I thought I'll assist your lordship to lay down some guidelines for any date convenient next week.
Correct. We'll interpret the
Yes,
provision of law and lay down such,
Yes,
so that problems would not crop up in future.
yes, yes. I will assist, my lord. I'll place before your lordships all the regulations.
Yes, HCGP. Darshan food. ಬಳ್ಳಾರಿಗೆ ಹೋಗಿದೆ.
No, but it will cause the serve of justice, my lord, if lordships
ಆಯ್ತು, we'll
permit me to
lay
assist.
down.
Please.
Connected. ಏನು?
Submission is that, my lord, the homemade food should be allowed, my lord. There is no bar for that. Because the manual also speaks that.
ಹೋಮ್ ಮೇಡ್ ಶುಡ್ ಬಿ ಅಲೌಡ್ ಅಂದ್ರೆ ಅದ್ರ ಜೊತೆಗೆ ಅದು ಇದು ತರ್ತೀರಾ ಅಂತ.
Yes, Sarala, scanning machine is there. They are on deputed on the duty. They are with the liberty, they can search.
ವಾಟ್ ಸರ್ಚ್?
Then, from
ಏನ್
last
ಫುಡ್ ನ
year-
ಸರ್ಚ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಹಿಂಗೆ?
That is with the scanning machine, my lord. Even though from last 2 years the food is stopped, then also the prohibited items are entering. We have not
Entering?
responded, eh? The visitors and the prison relatives are not responsible for the prohibited items which is entering into the prison. There are
Yes.
so many facilities, there are so many things which should be addressed, my lord. Though no good medical
SPP ಬರ್ಲಿ.
facilities, my lord.
Let the SPP come. I'll give a date and on that day we will pass some order.
Because ನಮ್ಮನೆ ಊಟ ತಿನ್ನೋದಕ್ಕೆ nobody can. They what
ಸರ್,
what food
ಒಂದ್
they
ನಿಮಿಷ.
are providing.
ನಿಮ್ಮನೆ ಊಟ ನೀವು ತಿನ್ನೋದಕ್ಕೆ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ, ಆದ್ರೆ ಜೈಲಲ್ಲಿ ಅಂತ ಪ್ರಾಬ್ಲಮ್ ಅಷ್ಟೇ.
Yes, but it is I am covered under Article 21. like,
ಅದು we'll see. We'll answer all that.
If they provide me a nutritious food, then there is no problem.
Correct. We'll see what is their diet and what are they providing. We'll see.
And no, even medical facilities is also not properly given to the prisoners. my lord. So many prisoners are complaining about the painkillers, the root and the normal pain. Yeah, ಎಷ್ಟು prisoners ಗೆ ಹೊಟ್ಟೆ ನೋವು, ಇದು kidney problem,
ನೋವು.
hernia problem. Until and unless it is addressed before the court, the CMO and the doctors in the prison hospital.
No, we'll lay down all comprehensive guidelines. Wait. Yes, Jagdish.
And another thing, my lords, a 90 years old lady is also, she is not provided good food in the Gulbarga also, the prison, my lords.
Why not provide food?
Necessity of 90 years old lady. my
Why
lord,
is she in custody?
She is convicted for 4 years, my lords. And even if she filed for a parole also, she is not entitled because she has not completed still 7 months. She has completed only 7 months until she has completed 2
ಅದು
years.
ಗುಲ್ಬರ್ಗಾ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ಕೇಳಬೇಕು.
This is state problem, my lords.
State problem.
Yes. State prisoners problem, my lords, they are facing. And there should be a guidelines, some education should be given to the prisoners. Instead of wasting the time in the prisons for years together, if compulsory education is given to the prisoner, then then the reformation theory starts, my lords.
ರಿಮಾಂಡ್ ಹೋಮ್ ತರ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು?
Easily, my lords. Yes. Because there are so many things, guidelines are issued, they should strictly, they have to work and like there are so many laws, my lords, in the.
We'll do something in this.
In fact, there are various guidelines, my lord, that education is given. People have written degrees, many degrees.
Some people are taking, my lords. There should be a compulsory education for undertale and convict prisoners, so that there will be a reform, they will reform and come outside.
We'll answer everything. Senior is also there, so we will, in the name of food, we will enter into other things. Yes.
Some date which is convenient or whatever.
We'll take it on 11th at 4 PM. List on 11th at 4 PM. ಇದು 63 and this tag ಮಾಡಿ. List on.
Connected but not listed.
ಬಂದಿಲ್ವಾ ಅದು? ನಂಬರ್ ಕೊಡಿ.
13 WP 13.
ನೀವು ಬರ್ಕೊಡಿ. Yes. List on We'll take it on 11th. Jagdish, ask the SPP to come. List on 11th at
Please.
4 PM for further hearing. Orders.
Order 13. 13.
Process. 2 weeks.
Process ಆಗಿದೆ, needful done ಮಾಡಿದೀನಿ.
Huh?
Needful done ಆಗಿದೆ ಇವರು.
Needful done ಆಗಿದೆಯಾ? Yes. Counsel for the petition submits needful has been done, office to verify. Interim order ಉಂಟಾ?
Interim.
Continued. Madam, ಎಲ್ಲಿ ಹೇಳಲ್ಲ. Interim order continue to the next item. Next. ಇಲ್ವಾ? ಇಲ್ಲ ಅಂದ್ರೆ ಅದೇ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಇಲ್ಲದೆ ಇರೋದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Yes. Where's your file, sir?
It's a highly contested matter.
Where's your file, sir?
To come from there is a task, Manoj.
Yes.
But this, no, Manoj, there was an urgency from a learned friend's side. That urgency seems to have been
Electricity
subdued
was
to a certain
disconnected, has
extent.
now been.
Now it is reconnected.
Reconnected.
So urgency is now obviated.
No, that has been.
But Manoj, one, may I
There's
just?
one other aspect, my lords. My gate is locked. I am jumping.
No, Manoj, no.
That is because, my lords.
How old are you?
My lords, I'm 51. I'm a lady. I have to jump
Oh.
through my neighbor's house.
No jumping.
No, Manoj, let me just make a submission. to the
I'll
record.
watchman
As far
post
as,
there, a gate locked.
as far as the house is concerned, this belongs to senior citizens 85 and 80, Manoj. Here, what she has done is, Manoj, she's cordoned off the entire ground floor. I don't have access to my own house. And it's come to a situation where a latest FIR, no, five FIRs are registered, Manoj. 4 by JP Nagar police station.
My lord,
She's hit the
case-
senior citizen with a hammer, Manoj.
Huh?
With a hammer, she's hit him.
Who?
The daughter-in-law. She hits him with a hammer, Manoj.
Hits whom?
Hits the father-in-law. 85-year-old
Father-in-law hitting father-in-law by hammer.
man with a hammer, Manoj.
There's no such, my lord, no.
I
hammer
have
can use,
videos
no-
to that effect also.
My lord, those FIRs are there, that also, my lord, we are.
Why
fighting.
5 FIR?
Five
My
FIRs,
lords, the problem is this, my lords.
Hmm.
Now, my lords, the in-laws, my lords, they live on the first floor. I live on the ground floor.
Hmm.
My lords, I instituted proceedings under the Domestic Violence Act. I had
Okay.
protection orders, my lords.
Yes.
An appeal was filed, my lords, by my husband. My lords, a stay order was obtained.
All right. Granted,
Granted, my
not
lords.
obtained. Yes.
Sorry, granted, my lords. I sought for, my lords, modification.
Hmm.
To the extent, my lords, that the protection orders may remain in force. Whatever was the maintenance given, that may be reconsidered, my lords. I had served a copy on my learned friend on 9th, my lords, to have the matter listed on the same day.
Hmm.
My lords, I moved the,
Which are those matters? Give me.
yes,
Give me all the matters.
Please.
We'll
There are
put a
4
quietus
matters,
to all
Manoj.
these problems.
482, there's 4. Manoj, I may just suggest one thing, Manoj. Now that the situation is such that they have registered an FIR against me, 5th FIR, I've registered an FIR against them. Manoj, I've spoken
We'll
to
give
my
a
learned friend.
quietus to everything. You just give me all the numbers.
I've spoken to my learned
Kudil.
friend, Manoj. If there's a possibility, we'll refer it to mediation, Manoj, because if there's a possibility,
That
I've
is-
given him an
I'm
offer
not
as well.
coming in the way of settlement, my
All
lords.
right. Now,
I've given him an offer as well.
the parties to the list are in scope, the father-in-law and the daughter-in-law
Everyone, Manoj.
and other
Mother-in-law,
members of the
mother-in-law,
family
son-in-law,
are in deep squabble.
son-in-law, sorry, not son-in-law.
All right. The learned counsel appearing for the petitioner and the respondent would in unison submit that if the parties are referred to mediation, possibilities of, they could explore the possibilities of settling the dispute and giving a quietus to all the problems. The learned, therefore, the parties to appear before the Karnataka Mediation Center. Yavat Friday ಹೋಗ್ತೀರಾ? 13th.
Next week. Manoj.
Friday the 13th ಬೇಡ. Will.
Next week.
It's not a good day.
It's very ominous. The
ಅದಕ್ಕೆ Friday the
relationship is bad
13th
to
will
begin
not
with,
send
Manoj,
you.
ಬೇಡ.
Yes.
My lords,
Next week, Manoj.
20th, my lords.
List on, but to appear before the Karnataka Mediation Center on the 20th.
Yes.
List the matter on 25th in the fresh matters list. If nothing comes about, numbers ಕೊಡಿ ಎಲ್ಲ, criminal petition numbers ಎಲ್ಲ. ಕೊಟ್ಟಿರಿ, will tag everything, will
Please.
close it.
Yes, ma'am. Right now, my lords, there are
Enough
only
of
two-
father-in-law and
Manoj,
daughter-in-law
20th,
fighting. Yes.
Manoj, looking at the number of disputes which they have, 20th, it will not happen in one session for sure.
Then
Manoj.
no problem. You take your time.
ಅಲ್ಲ,
But
ಯಾಕಂದ್ರೆ
I will give.
20th ನನಗೆ ರಿಪೋರ್ಟ್ ಮಾಡಕ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ
ರಿಪೋರ್ಟ್ ಏನ್ ಮಾಡೋದ್ ಬೇಡ. ನೀವು ರಿಪೋರ್ಟ್ ಮಾಡಿ ಏನಾಗ್ತಾ ಇದೆ.
please.
But don't report a next crime being registered.
I'm hoping they won't, Manoj. 5 FIRs against us.
Yes, no
Equal,
sixth,
my lords, equally filed by them again.
I don't have any.
no
JP
sixth
Nagar
from both the
police
sides.
station, Manoj, ಏನಾದ್ರೂ ಗೀಚ್ ಇದ್ರೆ they register an FIR for that.
No sixth from both the sides. I'll
I
take
will
it on
before my
25th.
lodge, Manoj, we're already filing 480 for the other one.
All right, yes.
Please.
They have
Yes.
not yet been filed. We have to file those other two 482s, my lords.
Whatever.
Bagin, better, fire
For one
register
second,
again.
First ನೀವು ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ.
Yes, my lord.
Please, grateful.
Highly grateful. my lord.
Interim order ಇದೆಯಾ?
ಇದೆ.
Interim order subsisting shall continue till the next date of hearing.
14 and 14.1. both.
ಯಾವ್ದ್ರಲ್ಲಿದೆ? If any,
both.
interim order if any, comma, in any shall continue
In
till
all?
the next date of hearing.
Both.
All right.
Yes.
yes.
Highly obliged. my lord.
Obliged.
Next, yes. Compounding, POXO. POXO ಅಲ್ಲ ಇದು.
Child marriage.
376.
Child marriage, 76.
Jagdish. Huh? No. At the time of incident, 15, huh?
6.
I will not settle. Don't worry about the child. The state will take care. We will direct the state to take care. We will not settle. ಇದು ಮ್ಯಾರೇಜ್ ಆಗಿರೋದಾ?
Marriage.
ಇನ್ಸಿಡೆಂಟ್ ಆದ್ಮೇಲೆ ಇನ್ಸಿಡೆಂಟ್ ಮುಂಚೆನಾ?
Incident ಮುಂಚೆ.
ಮುಂಚೆ
Child marriage act.
ಒಂದು ನಿಮಿಷ ಕೊಡಿ.
The victim herself is the
One minute. Victim herself may be the complainant. You got married first or the incident first?
got married first.
Who got you married?
Parents.
In this case, you take the parents into, in the sense, we will haul the parents into crime. Henceforth, parents should not register the crime. This should be a lesson to them. They go on getting the children married, notwithstanding the fact that they are less than 18. And Madhu Admila, offense will come about.
The parents should be allowed to.
No, parents should be brought to books in this case. We'll bring the parents. Why are you panting? Parents and
No, I just came
you
down.
came running. Okay, fine.
And there is an inordinate delay of 16 months. She was residing with petition number 1.
That's all right. Parents should not indulge in these things. They should stop. Huh?
They are also.
They are also accused, true. But they are responsible for getting the children married at an underage and bring them into POXO. Then religion permits, adu illa. Yes, we'll see. We'll list it on Friday 13th. Idu judgment is idu kalsi madam. Yes, next.
16. Appearing for the petitioner. My lord, this is that 363 matter. It may be taken up next week. My lord will report settlement with regard to that. 17 years jail marriage.
Aಯ್ತು ನೋಡ ಇದು ಅಷ್ಟೇ. List on 20th.
Please.
Yes. Next.
17. Lord, there was an interim order not to frame charge till then, my lord.
16. Madam, ಯಾವ್ದ್ರಲ್ಲ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಇಂಟ್ರಿ ಮಾಡಿ ಅಂದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡು.
Please. Grateful. 20. 16 9.
ಇದು ಅದೇನಾ? 20th. Yes.
18.
For petition, my lord.
Here 10.
After
16
major,
years.
after major, the marriage has been taken care.
So what?
The second FIR also registered, my lord. And they married, my lord.
Look into this judgment of the Supreme Court latest. I cannot settle a single case.
Now she's around 19-year-old.
What to do? Supreme Court, sir. Yes, 20th.
Interim order.
Interim order subsisting shall continue till the next date of hearing.
Serial number 19 to 23 is to be connected with serial number 5.
ಏನ್ ದಿಲೀಪ್ ಇದು?
Same.
POXO.
ಇದರಲ್ಲಿ 421 ಅಲ್ಲಿ they have issued a NBW. I mean, they are trying to arrest a in FIW.
Why are ಎಷ್ಟಿದೆ?
2 lakhs something ಇದೆ.
In 138 proceeding.
ಹೌದು.
You are the accused.
I am the accused.
The matter was settled, is it?
Matter was settled.
Settled where?
Settled in the court only. The court has acquitted the accused.
On settlement, you are acquitted.
ಹೌದು.
Amal, you did not adhere to the settlement?
I could not make the
You could
complete
not come.
payment.
You are convicted, is it?
It is not convicted, it's acquitted.
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 Acquitted on account of settlement.
ಹೌದು. And then
acquittal ಮುಂಚೆ ಏನಾಗಿತ್ತು?
initially it was the court.
Proceeding pending ಇತ್ತ, conviction ಆಗಿತ್ತಾ?
It was economic submission.
Conviction ಆಗಿತ್ತು.
Conviction ಆಗಿತ್ತು. We went up to appeal.
I will restore conviction now.
No, no.
You will be taken into custody. If any accused will come before the court and settle the issue and get away with the conviction and later on breach the settlement or terms of the settlement that are arrived at before the court,
It was not intentional.
I will restore conviction in every case. Accused cannot roam around free after having settled the matter and showing that the complainant will get back his money.
I do agree, my lord.
ಎಷ್ಟಿದೆ?
My lord, the different amount, my lord, in each and case. In this case, there is a 4 lakh.
ಟೋಟಲ್ ಎಷ್ಟಿದೆ?
Total would be around 58.
Victim comes forward to say that, yes, I will settle, seeing that he will get some money. And immediately after the settlement, you walk away with nothing
There was-
and roam around free. ಎಲ್ಲಿಗೂ ಯಾರ ಕೈಗೂ ಸಿಗಲ್ಲ. I will restore conviction now.
No, the different case, my lord, where the.
Definitely restore conviction in such cases. You get acquitted by a process of law, not by settlement.
Not intentionally, my lord.
Intention. Intention was deceit only. Otherwise, you would have adhered to the terms of settlement. Yes, sir. What do you want? ಎಷ್ಟಿದೆ? Total ಎಷ್ಟಿದೆ?
Total would be around 60 lakh.
16.
60.
60. ಈಗ 30 lakhs deposit ಮಾಡ್ತೀರಾ?
You have
Stay
already
ಮಾಡ್ತೀರಾ?
deposited 20%, my lord,
Where?
in the lower court.
That is 148A proceedings. ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. ಅದಾದ್ಮೇಲೆ settlement ಆಗಿರೋದು.
ಇಲ್ಲ.
And settlement, sir, settlement ಆಗಕ್ಕೆ condition precedent is that 20% should be deposited. So you have deposited. There cannot be a settlement without 20% being deposited.
No, before that only the mat was settled. my lord.
No problem. sir.
Even before
ಈಗ
conviction, the
ಆಯ್ತು,
mat was settled.
another 30%.
But
I will state only if you deposit 30% on the rest, 50 is 30, 20 lakhs.
ಮಾಡ್ತೀನಿ, but reasonable time may be.
No, sir, you're an accused who has breached the settlement and is walking free. And in victim settle ಮಾಡೋದಲ್ದೆ,
Right.
go before the executing courts, go roam around for getting the matter executed, the decree executed.
It's a project, my
ಆಯ್ತು,
lord.
FLW, sir.
It's a project, my lord, where the house they have wanted to buy, and then your honor, there is a dispute between the landlord and the.
ಏನಾರು ಇರ್ಲಿ, you have settled the dispute, you better obey the settlement. Otherwise, I'm going to restore conviction.
30% reasonable time.
20%. List the matter on 27th September in the fresh matters list.
My lord, 4
There
weeks,
shall be,
4 weeks.
there shall be an interim order of stay of any kind of warrant hanging on the head of the petitioner, subject to the condition that he would deposit 20 lakhs of the amount by the next date of hearing. List on 30th ಅಂತ ಮಾಡಿ. 30th in the fresh matters list.
30% ಅಂತ ಮಾಡ್ಬೋದು.
ಬೇಡ, 20 lakhs. Yes. All, tag all these petitions, madam.
My lord, the serial number 5 is connected with all these matters.
5,
ಹೌದು.
5 ಜೊತೆಗೆ, ಯಶೋಧ madam, 5 ಜೊತೆಗೆ
19 to
19,
23.
20, 21, 22, 23, all together. Yes. Next.
24. Petitioner, my lord.
Along with council submission,
I filed joint memo.
settlement,
Yes.
offense,
Folks,
also,
marriage,
marriage,
marriage was done.
Age?
Registered at the time of incident, 17 years, 7 months. There,
17/7. Then day after tomorrow. Yes. Don't get the parties until I tell you, madam. In POCSO cases, please don't get the parties. Only if I tell that there can be a settlement, then get the parties. Let's day after tomorrow. Yes.
25. Appearing for petitioner, my lordship.
ಅವ್ರು ಆ ಕೇಸ್ ಅಲ್ಲ, ಏಜ್ ಪ್ರೂಫ್ ಇಲ್ವಾ?
Birth certificate.
My lordship, she's turned 18 years, my lordship.
Where is the birth certificate? ಇದು ಪೊಕ್ಸೋನಾ?
Aadhaar card is filed, my lordship.
ಆಧಾರ್ ಕಾರ್ಡ್ ಬೇರೆ ಏನಾದ್ರು ಕೊಡಿ. ಇದು don't get the parties till I tell you. List day after tomorrow.
My lordship, latest order sheet, my lordship.
ಕೊಡಿ. Yes. Counsel with the petitioner files the complete order sheet maintained before the court. Same is taken on record. Next. Day after.
Obligement.
Madam, separate list ಮಾಡ್ಬಿಡಿ ಪೊಕ್ಸೋದಲ್ಲ. Day after tomorrow.
Mapping for petition in this.
ಅದಕ್ಕೆ ನಾಡಿದ್ದಾಗ್ತಾ ಇದೆ.
Mapping for petition in this case ಮಾಡೋದು. Petition in this case ಮಾಡೋದು.
ಇದು day after tomorrow. ಜಗದೀಶ್ separate list ಮಾಡಿಸ್ತಾ ಇದ್ದೀನಿ. You get ready in all those cases. Yes, next.
27.
For second respondent, SPP may be directed to take notice. He is a medical officer. Age proof of the victim, my lord, is
ನಿಮ್ದು ಪೊಕ್ಸೋನಾ?
child marriage and folks.
ಆಯ್ತು.
Age, my lord, 18
Age
years
proof ಎಲ್ಲ ಕೊಟ್ಟು day after tomorrow will take. Learned additional SPP is directed to accept notice for the second respondent petitioner to produce the proof of age of the victim by the next date, day of tomorrow. Next.
28.
ಇದು ಅದೇನಾ?
11.
Petitioners, 311 application reject ಆಗಿದೆ sir.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನು?
Petitioner number 2 and 4, name wrongly mentioned some names.
311 application rejection. We'll dispose it tomorrow. List tomorrow in the fresh matters list.
13/9 ಡೇಟ್ ಇದೆ ಸರ್.
13/9
ಡೇಟ್ ಇದೆ ಸರ್.
13/9 ನಾಳೆ ಏನು? 10 ಅಲ್ವಾ? 13ಕ್ಕೆ ಮುಂಚೆ ತಾನೆ? ಆಯ್ತು, ನಾಳೆ. ಎಸ್.
29.
By special order. Why?
Yes, last time it.
Bail matter. Yes.
Bail, 324, 307, 506.
Today. Tomorrow in the fresh matters list. Give the records. One more day. Tomorrow.
5 months in the.
Tomorrow. Yes. Records kodi.
30.
Vacating interim order.
Petitioner, my lord.
Today it has to be heard under today. It's not possible.
My lord,
Not to.
is a case of accidental fall, my lord. They have given a color of 302 it is. My lord, a FIR, my lord, was registered as an UDR initially. Let me hear the facts, my lord. My lord, it is a death of wife, my lord. My lord, wife, husband and 2 children, my lord, they were residing, my lord, in an apartment which is located, my lord, at 16th floor in Golden Garden apartment at Yeshwanthpur. My lord, on the day of festival, my lord, they had prepared some special food. My lord, this lady went to keep, my lord, in the ladder, my lord, this that utensil. She slipped, my lord, and fallen from 16th floor to down. My lord, she sustained multiple injuries and died. My lord, everyone lodged a complaint, my lord, it is a case of accidental fall. The respondent number 4 here, my lord, who is the son, himself is the complainant. He wrote complaint in his handwriting, reported to the police that my mother died because of accidental fall. My lord, the police registered UTR. My lord, after UDR, my lord, the body was shifted to mortuary. Next day, my lord, body was preserved till the arrival of all the blood relatives. My lord, neighbors were all secured. The police investigated. My lord, the apparent cause of death during inquest was, it was an accident fall. Maybe by slip, the deceased might have fallen from 16th floor. My lord, this was consistent by virtue of even autopsy report conducted. Now, my lord, that after this was over, my lord, the corpus was given, they performed funeral, my lord. After 15 days, my lord, the parties, my lord, they are from Punjab. They went to Punjab, my lord, to put this hasti in some river and all that. They returned back after 15 days, my lord, with the story that she committed suicide. They lodged a written complaint, my lord, that my mother committed suicide, and therefore the FIR, my lord, for 306 only registered.
Then when did 302 come?
302 comes in the charge sheet, my lord. You may kindly see, after 15 days, the FIR was for 306. My lord, investigation was taken up for 306. My lord, the accused was arrested immediately on 11/9. My lord, he was there in custody. After 15 days, he was granted bail. Once the father was granted bail, my lord, the son, my lord, he got annoyed. My lord, at the instigation of maternal uncle, my lord, one more petition was given. And my lord, they went to magistrate and gave a statement under 164 stating that it is not a case of neither suicide nor accidental fall. It may be a case of murder. My lord, now this, from this stage onwards, my lord, after 164 statement, investigation, my lord, was continued for 302. My lord, no legal material could be collected. Lord, may kindly see, neither there is a medical evidence to show that it is a case of homicidal death, nor any person deposed evidence that they saw that this accused committed any act which could constitute offense of homicidal act. My lord, in the absence of it, my lord, that they filed a charge sheet, my lord. In the meanwhile, my lord, what happened was, a pressure was that the investigation officer to be changed. Now, my lord, that a petition was given to commissioner. Commissioner, my lord, that he did not pass any order. The DCP, he passed one letter, my lord, stating that let the investigation officer be changed. Originally, the matter was before RMC Yard Police Station Inspector. He issued a letter stating that Bagalgunta Police Inspector may take over this investigation, investigate the matter. From that stage onwards also, he could not collect any material. With regard to the overtime that was committed by this accused, which should constitute
Charge
offense
sheet
of
is
302.
filed by which investigating officer?
Bagalgunta Police, that police inspector. Here, one point of law, you lordship may kindly consider. The transfer order which was given by DCP, from RMC Yard Police Inspector to Police Inspector of Bagalgunta Police Station. But the charge sheet is filed for the same crime number of RMC Yard Police Station, for which Bagalgunta Police Station officer was not the officer in charge of the police station.
Then it requires.
This is the point,
It requires detailed hearing.
Yes, it requires, that we be permitted to file that letter, we could not.
Whatever you want, you file. I'll fix a date. We'll
Interim order is there,
we'll hear it. Yes, Manu, you also file the entire list of dates and judgments or whatever you want to file.
Discharge application.
Discharge hakidara.
Discharge have been dismissed, that is what they didn't charge.
We filed an application for
Whatever,
discharge
yes.
against that,
List the matter on 18th, 19th at 4 p.m.
Lordship may kindly on 24th, Lordship.
Why?
The division bench it is posted, matter is there.
19th.
Yes, 17th, 18th, 19th.
All right, then 24th. List on 24th at 3:30 p.m. for further hearing. You file whatever is to be filed. Yes. In advance, if you file, I will go through and come. Yes.
I also have to
Yes,
file an
you go ahead.
application.
ಏನೇನ್ ಬೇಕೆಲ್ಲ ಹಾಕ್ಬೇಕು.
Yes, sir.
Yes. List, so and so, interim protection / order, if any, subsisting today shall continue till the next date of hearing. Yes, Vinod Kumar.
My lord.
Post immediately after service of notice upon the second respondent, interim order there. Interim order subsisting shall continue till the next date of hearing. Same order. 32.
My lord, one submission.
Yeah.
Serial number 7, my lord, could not be present, my lord. Interim order may be extended.
ಯಾವ್ದ್ರಲ್ಲಿ?
Serial number 7.
ನೀವು ಇಲ್ಲದೆ ಇದ್ರೆ interim order extend ಮಾಡಿರ್ತೀವಿ sir. Yes.
Much obliged.
32.
Office objections.
It's compliant. Only 2 objections, my lord, we have.
Only 2.
Alla,
That
adralli-
also objection ಏನು?
One is that, my lord, the page.
Accepting
horizontal-
submission of the counsel for the petitioner, office objection stand overruled. List day after tomorrow in the fresh matters list. Next.
Grateful.
33.
PF. Rakshit.
My lord, respondent number 2 is none other than state itself, my lord.
None other than state. Yes, Leonard HCGP is directed to accept notice for the respondent. Second respondent as well, registered to print the name of the additional SPP as appearing for the second respondent. Sorry, HCGP as appearing for the second respondent. Interim order ಇದೆಯಾ?
No, my lord. My
Yes.
lord, this is the matter where JJ board did.
ಅದೇ JJ board documents ಕೊಟ್ಟಿಲ್ಲ.
Yes, my lord, yes.
We have to lay down some, we'll see. ಎಲ್ಲದರಲ್ಲೂ ಅದೇ ಆಗೋಯ್ತು. List the matter on 18th. R2?
R3 ಬೇರೆ.
R2 state ಅಂದ್ರೆ?
R3 ಬೇರೆ ಇದ್ದಾರೆ. R1 and
R2 is not state, sir. A 2 weeks time is granted to take steps qua R2. Yes.
Please, ma'am.
ಬೇರೇನು ಬರಿಬೇಡಿ ಮೇಡಮ್. ಅಷ್ಟು ಸಾಕು. Yes, next.
Hearing on IA 34.
My lord, I'm appearing for the petitioner.
ಹೋಗ್ಸೋಣ.
Illa, sorry, 498A.
ಆಯ್ತು,
Matter is settled in BMC, divorce has been granted.
ಆಯ್ತು ಕೊಡಿ.
I've also
Yes.
filed the joint
Page,
memo of
page.
settlement.
Page.
Lord, and the IA for compounding, page number 15 is the joint memo reporting settlement.
ಎಲ್ಲಿದೆ?
I filed an IA under 322.
ಎಲ್ಲಿ? Madam, settlement. Yes.
Page number 15 is the memo reporting settlement. In this, R2 has signed the memo. I have also filed the BMC settlement and the judgment of the
The
family.
petitioners are before this court calling in question so and so. Parties are there?
All 5 petitioners
Yes,
are
the
here.
petitioners are before this court calling in question proceedings in so and so other prayer lakpadi. The parties were before, the husband and the wife were before the family court in MC 2394 of 2020, where they have settled the dispute amongst themselves by drawing up certain terms of settlement. A term of settlement would,
Point number 11.
term of settlement also recognizes the closure of these proceedings. The respondent ilva? Respondent is
She's
here.
served, she's not engaged her advocate in the first
But
matter.
where is the respondent?
Respondent is not present.
What is this? How can I settle it?
Her advocate is present for the second matter. She
Where is the advocate?
He was here. He was
Pass
here.
over, wait. If he comes, tell me. Yes, pass over, sorry. Next.
35.
For the complainant in this.
35 minutes.
Charges have already been framed, my lords. Charge sheet all charges.
Alla, before or after?
No,
Then
After the filing of the petition. Stay in illa.
stay ಇದೆ ಅಲ್ವಾ?
Stay illa, stay.
ಇಲ್ಲ ಹಾಗಾದ್ರೆ ಹೋಗ್ಲಿಲ್ಲ.
No. Your lordship, it just perused the order sheet.
Uh.
That the time was taken by the state for perusal
No,
of the.
I am not on that ground. Come on merits.
Correct, my lord. But the complaint is saying that there is a transaction between the complainant and the accused regarding finance is concerned. That he admits that 40 lakh rupees, he's taken loan from me. And then it is his contention that he's repaid the entire amount at the cost of 15% of the.
I will, if that matter is over, I'll take up these admission matters or fix a date. Yes, Advocate General is come, Learned Advocate General. I'll start.
Could your lordship was on the 18th, my lords, 18th.
ಎಲ್ಲ all on 18th, if the matter doesn't get over. ಇದು list on 18th ಅಂತ ಹಾಕಿರಿ. I'll let you know.
Meantime, there's an interim order is passed.
Interim order ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ.
ಇಲ್ಲ, ಅದು
2 years ಇಂದ ಇಲ್ಲ. 18th will take.
Only the order was that his presence will not be precipitated.
That will continue.
That should be continued.
Whatever protection orders are pending, just continue them. Yes.
Number 4.
Wait, I'll finish that and come back. You're in a hurry.
But serial number 52.
No, if I take one, then I'll have to call the
Yeah.
entire list.
No, it may be accommodated tomorrow.
ಮತ್ತೆ ಅದನ್ನ ಇಂಡೈರೆಕ್ಟ್ ಆಗಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. Wait, sir. Yes. ನಿಮ್ದು ಯಾವ್ದು? Wait, I'll just finish this and get back. Yes, ಶ್ರೀದೇವಿ ಮೇಡಮ್, ನಿಮ್ದು ಏನಿದೆಯಾ? Wait, yes.
Please,
It will take an hour?
please. I'll
1
take
hour.
it 1 hour.
Yes. So others can come back at 4:30. Madam, ನೀವು ಹೊರಡಿ.
Please, my lord, only on the point of law, my lord, I'll not go into the facts as it is, my lord. Only 2-3 aspects, my lord, which your lordships have already dealt with. I just want to, the judgments which your lordships have mainly dealt with, my lord, is the prior
I have not dealt with it. Oh, Ashok.
Ashok
All
and
right.
Pradeep Kumar and Shri Rupa, all those judgments, my lord, what your lordships have dealt with is where a case prior, cases where, my lords, prior approval has been granted under 17A by the competent authority, my lord, which were questioned before your lordships. This is a case, my lord, slightly on the lines of Dr. Ashok, my lord, where a private person, my lord, seeks permission, prior approval under 17A. So therefore, my lord, the distinguishing feature is, my lords, where prior approval is sought by a police officer and which has been granted as against a private person seeking a prior approval, my lord. So just, your lordship may kindly see section 17A for a moment, my lord. It says that no police officer shall conduct any inquiry or investigation to any offense alleged to have been committed by a public servant under this act. Then, my lords, where the alleged offense is relatable to any recommendation made or decision made by him, taken by him, by such public servant in discharge of his official functions or duties with the previous approval. Then, my lord, second proviso is important, my lord. Provided further that the concerned authority shall convey its decision under this section within a period of 3 months. So therefore, my lord, the condition precedent for this is, my lord, there should be
a preliminary inquiry done by an investigating officer, my lords, which has to be placed before, given along 17A, my lords. The reason is this. When,
So,
Please.
to get clarification, sorry. Now, are you suggesting that prior to 17A, approval being granted, there should be a preliminary inquiry?
as held by Lalit Kumari, that is what your lordship is saying.
Then you are equating 17A order to an FIR.
No, that is why your lordship is.
If you're equating 17A order to an FIR, preliminary inquiry is necessary.
Therefore,
Otherwise, yes.
Therefore, my lord, if your lordship sees if your lordship sees, my lord, Lalit Kumari clearly says, my lord, in so far as cases of corruption cases.
Not true, para 120.1.
One and
6 postulates there.
Six
Yes.
postulates.
Hmm.
We come in clause D, C and E, my lord.
Yes.
If we come under clause C and E of Lalit Kumari, my lords,
Hmm.
it is mandatory that a preliminary inquiry is done. I'm not talking about inquiry as contemplated under 17A. What I'm saying is pre-17A. Your lordship may kindly see pre-17A is a mandatory requirement.
Pre-17A, all the three circumstances, inquiry, or investigation.
I'll be able.
For all the three, you need 17A approval.
Correct.
Where is the question of the 17A, prior inquiry under 17A without compliance with 17A?
So, your lordship may, I'll take Lalit Kumar, your lordship may kindly see.
Please take para 120.6,
Please,
2014,
your lordship may
21,
kindly
page 1, yes.
This court, written submission, I've just culled out the relevant paragraphs. Photos.
ಅದು ಓದಿ ಹೇಳಿ ತೊಂದರೆ ಇಲ್ಲ 14 SCC page 1 para 120
Your lordship may kindly turn to page 61, my lord, of my. At page 62, 61 it starts. my lord.
The list of other written.
No, just a notes, instead of going to all the judgments, my lord, whichever judgment I'm relying upon, I've culled out the relevant paragraphs, my lord.
All right.
As the lordship pointed out, my lord, that 120.6 D and E, my lord. 120.6, as to what type and which cases preliminary inquiry is to be conducted will depend upon the facts and circumstances of each case. The category of cases in which preliminary inquiry may be made are as under. So,
D and D.
D and D, where the case is abnormal delay in latches. This is a case of 22 years, more than 20 years, my lords. 1998, according to them, my lords, is a case of denotification, assuming for.
Oh, you're.
No, I'm saying it is a case
You're
where.
thinking to that. Yes.
Please.
Where there is abnormal delay.
Abnormal delay. So
Then you may be just.
Please. So.
All right, yes.
So therefore, my lords, coming under the corruption case and under abnormal delay, my lords. The question is preliminary inquiry is mandatory. So therefore, my lords, that is why, my lord, the language used, first portion, no police officer shall conduct any inquiry or investigation, so and so, so and so, and so, as committed by a public. If your lordship read the SOP, my lord, which will give further more clarity. Your lordship may kindly take volume 1.
Page 703.
Please, my lord.
706, yes.
That's the crux of the whole thing, my lords.
Volume 2, 706.
Absolutely, my lords.
Yes.
Annexure M, my lords.
Yes, sir. SOP of the Government of India on 17A.
Please, my lords.
Yes, sir.
So the private person cannot be put in a higher pedestal than a police officer, my lords. What, assuming, my lords, the preliminary inquiry has to be done. This is what the crux of the whole 704, my lords. So as to standardize and operationalize procedure with a view of achieving uniform and effective implementation for prior approval, processing under 17A of the Act, the set of SOPs are hereby conveyed. First stage processing of information received by the police officer. In this case, my lords, this has not been done. Then, my lord, 705, what as your lordships are pointing out, standard operating procedure for handling information in respect of a public servant alleging offense under the PC Act, seeking of previous approval for conduct of inquiry or investigation under section 17A. Then, my lords, clause 2, it may be emphasized that the provisions of section 17A stipulates a mandatory requirement for a police officer to seek previous approval for conducting so and so, so and so, so and so, alleged to have been conducted. The police officer upon, this is the requirement, 3.2.
No, that would bear reference only to a crime registered before a police officer. That would not cover private complaints. Private complaints was a
Yeah.
concept that was evolved by this court in GV Ashok, so that SOP won't help.
No, it will help. The reason is, it is a case of private complaint before the police officer.
Where?
Here is not sorry,
complaint
private, a
before-
complaint registered before a police officer. That I'll come to 154, 173, 1 and 4 much later, my lord. Here is a case where a complaint is given to a police officer, sufficient time is not given. They jump the gun and apply for 17A in compliance of your lordship judgment in Dr. Ashok's case.
Where is jumping of the gun here?
Because, my lord, I'll come to the facts with regard to 150. Why preliminary inquiry, what is stipulated, that is 15 days to 6 weeks. They don't wait for that. Then they apply for 17A for compliance of Dr. Ashok's case. So therefore, my lords, what has to be read is the preliminary inquiry. Ultimately, my lords, the governor does not do the preliminary inquiry. He only grants prior approval. In this case, what has happened, my lords? He sits as a preliminary, does the preliminary inquiry. That is hearing the complainant for 1.5 hours, according to them. Then issuing show cause notice, seeking clarifications, seeking reply. So therefore, my lord, that is the sole jurisdiction of the police officer as per the SOP and as well as the judgment of this.
And even as per 17.
As per. I'm born into it. I'll just point out, to highlight a few aspects in this SOP. Your lordships have read, my lord, just to. Then clause 4, my lord, page 705, 3.1, Roman 4. Roman 3, specific acts of commission or omission attributable to such public servant. This, whether such acts are relatable to the official functions or duty by the such public servant, specific to the office post held at the time of commission of the alleged offense, specific recommendation or decision taken by the. My lord, all these aspects are very crucial because this says when the police officer or the investigating officer seeks for sanction, these requirements has to be placed before the competent authority. Then, my lord, page 706, that Roman 4, the proposal of the police officer of the appropriate shall contain the following information. So therefore, my lord, the proposal is the formation of an opinion by him prima facie that cognizance of this case has to be taken. 4.4, the appropriate officer of the appropriate rank shall make a proposal of the to the appropriate government, as such case may be through a single window process as laid down by these SOPs, and shall ensure that the proposal is in accordance with the requirement laid down in the checklist, enclosures, clear, legible and authenticated documents as may be required. Separate proposal shall be submitted for, this is important, what your lordship just said. Separate proposal shall be submitted for inquiry or investigation as the case may be. Your lordship may now kindly see the page 707, my lords. What it says, incomplete proposal should be sent back by the competent authority back to the investigating officer. Then so therefore, what is the approval which speaks previous approval is the proposal sent by the investigating officer. In this case, my lords, or if I'm giving a hypothetical, tomorrow all citizens or any busybody gives complaints against everybody, my lords.
That's precisely why I wrote prior approval is needed.
Dr. Ashok has said, because it first compliance of 154, prior approval, then comes the complaint. Here, my lords, what has happened, as I said, 154, here, my lord, even what is applicable to a police officer, the same procedure ought to have been applied, the competent authority.
Followed by the governor?
No, governor ought to have asked the private party to say that, give the information with regard, there are two aspects, my lord.
So much of information is given.
No, with regard to the format, allegations have been given. My lord, there are two aspects. One is formation of an opinion can be done only by the investigating officer, not by a private party. His opinion will not make any difference. So therefore, there are two stages. One is you ought to have given as per the requirement of law. Once having received it, my lords, the competent authority does not act, does not do the preliminary inquiry. It is the competent authority could have asked, as required under law, the investigating officer to give the information. He would not, he ought not to have sat as an inquiry officer, investigating officer. In fact, Your Lordship, what is page, if Your Lordship see page 709, the checklist goes to show, my lords, when prior approval is given, the competent authority has the benefit of all the material and data which is required under 17A. Can I read the page 79, the checklist, my lords? First is name and designation of the officer, office held by the public servant. Then post or office held by the public servant at the time of the alleged commission. Then whether the request is based on a complaint received, if yes, copy of the same. Whether the complaint prima facie reveals deriving of an undue advantage by a public servant, whether any information is available in respect of bribe given, then please provide specific details of recommendation made or decision taken by the public servant, which is relatable to the offense alleged against the public servant. In case of preliminary inquiry was undertaken at the early stage, please enclose, my lord. Then whether any criminal offense. So therefore, my lord, this is what is approved under 17A, which goes to show that there is an application preliminary inquiry done, there is a proposal, there is a report, and application of mind is to this. Therefore, my lord, my submission is on point of law is, my lord, is that the allegation or the complaint which was sought for under 17A ought to have been returned. Second aspect is, my lords, if it was accepted, preliminary inquiry information, instead of asking the complainant or the show cause not having issued to the petitioner, it is information ought to have sought for from the investigating officer in terms of 17A or the SOP issued by the central government. That's my first submission. Therefore, my lords, I'm not going into as to the rest of the process. The main thing is you ought not to have entertained the application itself. As your lordship initially pointed out, my lords, 17A does not contemplate preliminary inquiry. I bow down to that. What is requirement of Lalit Kumari and your lordship's line of judgment, my lord, that preliminary inquiry is mandatory, is what ought to have been followed. Your lordship may just. The next aspect is, my lord, insofar as recommendation is concerned, next is the heart of the whole thing is, my lord, is whether there is any recommendation or decision made. My lord, it applies both ways. What ultimately the argument will say, I don't need the protection because I'm not in any other case, if 17A application, if the protection, if we are seeking saying that it does not come within the 17A, the protection under 17A goes.
If you do not offense under the PC Act,
PC Act, that is under.
All right.
So therefore, my lord, what is crucial, my lord, is that offense has to be relatable to decision, recommendation, and the office head. The lordship may kindly see 2-3 judgments on those lines, my lord. I just reproduced it in my compilation. I just would like to take a lordship to the relevant paragraph, my lords. Your lordship may kindly turn to page 27, my lords.
Yes.
This is Nara Chandra Babu Naidu versus State of AP, my lord, 2024 SEC online. I'll just read para 3 just above that, my lord. In this context, the current case, these definitions underscore the importance of establishing a clear connection between alleged corrupt act and the official recommendation or decision linking the same with the public servant. This interpretation reinforces the protective intent of section 17A, ensuring that the public servants are shielded from unwarranted investigation from acts not directly connected to their official duty. Para 55, in para 4, section 17A has the following 4 more facets. Inquiry or investigation of the offense under PC Act. Alleged offense should be related to the recommendation made or decision taken by a public servant. Such recommendation made or decision taken by the public servant should be in discharge of his official functions or duties, and the previous approval of the authorities mentioned therein. Malod, in fact, in B.S. Yedurappa's case, Malod, case of denotification, the division bench of this court, Malod, in para 31, I've just quoted that as said, even otherwise, the order of denotification passed by the petitioner, in this case, it's not passed by the petitioner, para page 31, in the circumstances discussed above, cannot be construed as any recommendation made or decision taken by the petitioner in discharge of his official duty so as to attract section 17A of the PC Act. So, Malod,
Yes.
this is, and next, Malod, even the Gujarat High Court also has held on identical. The word relatable is an adjective. The legislature in this wisdom has used adjective relatable to connect the offense to a recommendation made or decision made. Therefore, such approval shall be required when the offense is associated with and connected to a decision taken or recommendation made by a public servant in discharge of his official duty or function. Use of the adjective relatable to the offense is considered opinion of this court, limits and restricts the offense to be associated with and connected to a decision taken or a recommendation made by the public servant in discharge of the official duty or function, and therefore can't be extended to all offenses under the PC Act. The same is Madhya Pradesh High Court, para 6.3. Section 17A is attracted only when the offense alleged under section PC Act relates to the act of recommendation made or decision made, but is not attracted when the offense relates to demand or acceptance of bribe, taking to an illegal gratification or disproportionate.
No, that's why trap cases gate is not applicable.
Please, Malod. Then last, this Kerala High Court judgment, Malod. Ultimately, Malod, that is why the SOP becomes very, very important, Malod. The checklist gives for the purpose of formation opinion, para 9. The most crucial part of section 17A provides that the previous approval is required in relation to an inquiry or investigation into an offense alleged to have been committed by a public servant under this act, where the alleged offense is relatable to any recommendation made or decision taken by the public servant. It seems that the above part of the section is most crucial part of the section, since imposes a rider that otherwise the absolute power under section 17A, so and so, so and so and so and so, in every act needed prior approval.
Yes.
Well, next, one other aspect, if your lordships kindly turn to page number 13, Malod. This is with regard to H1 Sinha versus CBI, with regard to preliminary inquiry, Malod. Just going back.
3.
Page 13, Malod.
Yes. Sirajuddin is followed.
Sirajuddin is followed, H1 Sinha and Prabhat Kumar Dubey, Malod. The reason I'm using the preliminary inquiry, Malod, preliminary inquiry has to be, so even in case of Shrirupa, Malod, what the courts have said that while doing the investigation officer should have credible evidence based on which an opinion is formed by him for the purpose of seeking of prior approval under 17A.
Yes.
So therefore, Malod, in this case, Malod, I mean,
according to you, the petitioner has not done anything that is relatable to a decision taken or a recommendation made.
I'll slightly modify it. What is not there in this is, Malod, it is only an investigating officer who can give.
No, I'm only asking a simple question.
Please, Malod.
According to you, the petitioner has not done anything that is relatable to it. Sir, petition. You're appearing for the complainant?
No, your lordships are saying petitioner
No.
is accused.
Petitioner is accused. That is what I'm saying. according to you, you are for the government, right?
Please, please.
Now, your suggestion is that petitioner has not taken any decision or recommended anything that would become an offense as is that your submission?
Please, no, your lordship.
No.
No, I'm not on that.
Hmm.
That's the legal position, my lord. In order to invoke 17A, that is a condition precedent, my lord. As your lordship pointed out. Here, I'm slightly one step further to entertain an application, my lord, under 17A. There should have been a preliminary inquiry.
That I understood.
Please.
What you're saying is even for an application seeking prior approval under 17A, there should be a preliminary inquiry as is necessary in Lalit Kumari and the SOP that is by the Government of India. That's your submission. So here there is no preliminary inquiry and the competent authority himself has now acted instead of referring it to the police for preliminary inquiry as an approving authority conducting inquiry himself and passing an order. That is your submission.
Second submission. And the third is, my lord, what your lordship felt, if the petitioner decision or recommendation and holding the post. So these are the three requirements, my lord. If I may read section 17A, so what is required is relative recommendation, decision by the public servant. Third most important, in discharge of his official.
Correct. That is there. That is the soul of the, see, that is the soul of 17A.
17.
In discharge of his official duty, if there is anything recommended or any decision taken, this can be set into motion. That is the purport of 17.
And your lordship has said, what is the object and purpose also of 17A
Yes,
is to
that-
protect the thing. And why it should not be abused also, your lordships have dealt in Dr. Ashok and Pradeep Kumar and all those cases.
All right.
Keeping those in mind, my lord, the question, what your lordships question, your lordships will decide is, my lords, not only in this case, any other, I mean, on a principle of law, my lords, a trigger-happy complaints are filed day in, day out against various public servants to the competent authority, my lords. Then the nature of inquiry, again, which ought to have been done, hearing the complainant, hearing the accused, then a decision being taken, my lord, that will send a very bad precedent or a proposition of law insofar as granting prior approval for investigation, my lord. It will defeat the purpose of section 17A. So therefore, investigating officer has to be only an police person, my lord.
Oh, you are coming at that.
I've been trying to come at that.
Yes. All right. Yes.
So therefore, my lords, ultimately, unless that report is there, that is what, I mean, that is what they say, the investigating officer forms an opinion. That ultimately, my lords, there may be, ultimately, my lord, it is for the competent authority to decide on the material, to grant or not to grant. He may not be bound by the
Report of the investigator.
investigating. He independently, he gives approval to, therefore, my lord.
Approval for what if there is already a report by the investigating officer?
No, therefore, he may accept it or reject it.
No, approval granted in case he wants to grant approval. For what does it grant approval?
Investigation.
It is already done.
No, he forms an.
You said investigating officer submits his report and seeks approval. For what does he give approval? For investigation again?
Please, my lord. So therefore, my lord, that is, I'll just put it. Preliminary inquiry is with regard to cognizance on offense which he formed, the investigating officer forms in view of the bar under 17A. He has to seek permission from the competent authority and the competent authority gives approval to that. So without the approval, he can't investigate. That is why he seeks the approval.
You're trying to blow hot and cold. Now, prior to approval, you said there should be some inquiry or some report prepared.
That is what Lalit Kumar has said.
That makes sense. You're hinting upon Lalit Kumari's principles.
Principle. Then, my lord, your lordship, the lordship circular also may be kindly seen, my lord.
Lordship circular, High Court circular.
Your pursuant to your lordship's
order,
pursuant to your
Ashok, yes.
lordship judgment in
Page-
Dr.
Page,
Ashok-
Dr.
Ashok's-
V. Ashok or something, yes.
Please, my lord.
Page,
That is-
sir.
That is at page number, my lord, volume 1.
Citation, madam, volume 1. it's put in.
Page 260.
260.
In fact, my lord, what you're keeping in mind, the object of 17A, my lords, what your lordship said.
60.
260, volume 1.
1 second, sir. Of the
Petitioner's paper.
Petitioner's volume.
petitioner's paper.
I'm sorry. I took it for granted that your lordships know all the page number, but I need not.
No, ಯಾವ volume ಅಂತ ಹೇಳಿದ್ರೆ volume also I should know. 1 minute. Because that SOP you said was last 3 pages of that paper book.
So
That's why.
easy to remember.
ಹಾಗಂತ ಎಲ್ಲ ಗೊತ್ತಿರುತ್ತೆ ಅಂತ. Yes, sir. Page 260.
First, it refers to Priyanka Shivasa, my lord.
And Yashwant Sinha later.
Please, my lord.
Yes.
That is affidavit 173(1) and 173(4). I'll come to that, my lord. Here, page 261, my lord. The language, what your lordship has said at page 261 is, my lord, even if not to entertain such complaint if they do not comply with the following. That is, my lords, one is registration of the complaint, then prior approval in case of a prior complaint. Then last paragraph, my lord, these directions become necessary in the light of the fact that once the matter is referred for investigation, the police will have no choice but to register the crime. Therefore, such approval being appended to the private complaint is signed for maintainability of the complaint, except in cases where concerning disproportionate, which your lordship gave as an exception, such complaint shall bear the scrutiny so and so. So therefore, my lord, pre-requirement is compliance of 154 or 173, then 17A. So therefore, my lord, again, my lord, here comes back to Lalit Kumari once again, my lord, because it has, there is no application of mind, or not application of mind, no preliminary inquiry. I put it the language used by the Supreme Court, my lord, no preliminary inquiry done in this matter, my lord. And coming back to insofar as 154 and 173, your lordship may kindly see on the 3 volumes were given by the counsel for the governor, the Solicitor General, my lord. If your lordship sees, my lord, on those volumes, there is no complaint is given by respondent number 3. Respondent number 3 on 18th July and 25th July, my lords. And the immediately next day,
26th July.
26th July, immediately next day, prior approval is sought. So therefore, my lord,
Prior approval is sought and show cause notice is issued.
no,
On
the
26th.
points I'm trying to make here is, my lord, the question is.
No preliminary inquiry.
So therefore, he had not given an opportunity to conduct that inquiry. If he had given, we don't know whether the police officer themselves might have or might not have sought for prior up.
No, if your submission is accepted, that permission was not given up to
Sufficient time.
sufficient time or whatever. 17A ಆದ್ಮೇಲೆ ಅದೇ ಆಗೋದು.
No, that's a different aspect, my lord. No, just because it's going to happen after 17A.
Not just because, only because.
No, only because, my lord, your lordship, go by to the Supreme Court judgment and the judgments of your lordships and the SOP cannot given a go by because it is likely to, the scope of that is entirely different, my lord. Once the complaint, 156(3), that's entirely scope. I'm not on.
No, if you are hinting on some inquiry, investigation should happen. Now, if the impugned order, I mean, like, by the impugned order, what is done is that only.
That he could not have done. That's the whole point, my lord. He is a competent authority, not a preliminary inquiring officer.
All right, yes.
That is what is prohibited in law.
All right.
Sum and substances. So therefore, in fact, para 3 and para 9 of the written submission says, we have done preliminary inquiry. We have not done, given prior approval. Your lordship may kindly see the written submission given by them.
By whom?
The Solicitor General, my lords.
Kodi?
All they say that we have done a preliminary inquiry as required in Lalit Kumari.
That is prior to giving approval.
By the competent authority.
Prior to giving approval.
authority,
So
which,
according to you, police officer should do that.
that's what the law says. Your Lordship, that is the requirement, my lords. So therefore, the application of,
Sir, two things.
please,
If the crime is registered before the police, now if it, or the locaयुct or whatever it is, if it is touching upon or an amalgam of offense under the Prevention of Corruption Act and the IPC, prior approval will have to be sought.
correct.
All right. The police officer or whoever files a prior approval before the competent authority to inquire or investigate. Permission comes, then he starts investigation.
Correct.
Starts investigation by what? By registration of a crime. All right. Now it is a private complaint. Straight away, a private complainant goes before the court. He seeks reference under 156(3), now under 175 of the BNSS. Now, if the matter is straight away referred, now say it is.
Your Lordship says it's not permissible.
No, that's what I'm telling you. If the matter is straight away referred for investigation to any authority, to a jurisdiction police or to XYZ, no choice but to register the crime.
Correct.
So what happens to 17A?
So therefore, what,
By way of a private complaint, you get, obviate the process under section 17A and straight away get a crime registered where 17A, if it is before the police station or before the officer in charge of a particular police station, be it the lokaयुkta, 17A would be required. All right.
Correct.
Now, 17A, the approval is sought before the competent authority. Here, the competent authority is the governor. Governor initiates certain process, do not that day it is granted or what day it is granted. How it has been granted?
I'm
will
not on
answer.
that, my lords.
Yes. So according to you, Lalit Kumari had to be followed, preliminary inquiry had to be conducted. Now in the written submissions, the learned SG says that preliminary inquiry is conducted
By the,
as contemplated under Lalit Kumari by the competent authority.
which is not permissible.
That is your submission.
It's virtually impermissible. He does not act as a investigating officer under law. He only is a approving authority, what is sought by the investigating officer. That's the summon. And all he, and what the whole case and the record shows that 25th was the complaint, 26th, the file movement, he was heard, show cause notice issued, and reply sought for, and a decision is taken, clarification sought from the complainant, and then a decision is taken, which according to them is a preliminary inquiry is what they have done. Can I read para 3, Malats? It is of the written submissions.
Yes, sir. Page?
Page 9, para 3.
Ah.
It is submitted that the stage of granting approval under 17A of the Prevention and Corruption Act, it is not a stage where claims and counterclaims have to be weighed or weight of the allegation is to be tested. It is submitted the only test that ought to have been adopted is whether there is an allegation which discloses the commission of a cognizable offense and apprehension exists that offense may have taken place, requiring an investigation to be conducted in accordance with law. Para 9, can I request, Malad?
Yes.
That is at page number 12. It is submitted the order to further understand the scope of inquiry at the stage of approval for investigation. The principles laid down in the case of Lalit Kumari versus so-and-so, the Honorable Supreme Court ought to be referred to. In the case, the Honorable Supreme clearly held that once the cognizable offense is disclosed in a complaint, the FIR must necessarily follow. The said principle was laid down in the light of statutory provision and so-and-so, and the understanding that the FIR is merely the starting point of a lawful means to uncover the truth of the matter. So the point here is, Malad, who has to do this preliminary inquiry? It's not in dispute according to them also, Malad, that preliminary inquiry need not be done. According to them also it has to be done. He says, I will do the preliminary inquiry. So therefore, Malad, there is no doubt that preliminary inquiry has to be done, even according to them. Then, Malad, page 14. Para 10.
All right.
I'm sorry.
Yes. No. For whatever is to be done, preliminary or otherwise, 70.
Please,
All right. Yes.
Malad, what my submission is preliminary, as your lordship in the initial start, preliminary inquiry cannot be read into 17A.
All right. We'll consider. Yes.
Para 10, it is submitted that for the approval of investigation must be exercised guided by law laid down by the Honorable Supreme Court, it submit in the case of information given to the police, discloses the commission of a cognizable offense, the approval for investigation is to be granted unless the allegation appears to be wholly biased, motivated, and false. In furtherance of the aforesaid, it is submitted that the intent of the Honorable Governor was to ensure that proper investigation is conducted in the present matter to merely uncover the truth in the matter and to take not to take any specific sides.
So according to you, according to them, preliminary inquiry is conducted by the competent authority.
Please. Ultimately, what they said, we have followed Lalit Kumari. Then one of the important aspects, my lords, with regard to your lordships, I have held in Dr. Ashok's case also, my lord. In this case, my lords, insofar as respondent number 3 is concerned, my lords, as I pointed out, complaint is given, not even 24 hours is what was ought to be waited for before approaching the governor on the 26th. Immediately, my lords, he is heard on the same day. That is one aspect of the matter, my lords. Whether you could have heard
After a few days.
No, not after, whether he could have been heard at all. At all. And what was thought to be argued, like the procedure need not have been followed. The question is, there's no such procedure. Rightly, my lord, there's no such procedure to hear the private citizen or a complaint. My lord, especially, my lord, when at the cost, allegations is made against an accused, whoever that may be, my lord, without his presence. And subsequently, my lord, issuing show cause notice, the whole procedure is not contemplated in the eye of law at all. When that being the case, my lord, the question, what your lordships will consider whether application of mine, principle of natural justice, reason order, I don't want to go into those aspects.
So you are at the root.
The root
It cuts at the root.
Because the third, fourth, and the fifth complaint, my lords, here also I am not sought to give follow the requirement of section 154 or 173, my lords. If your lordship may kindly take the few dates in the written submission, my lords. Your lordship may kindly page 7, my lords.
Page 7?
Page 6, page 5, I'm sorry, my lords.
Oh, this table.
This table, which is forthcoming from the compilation of documents given from the governor's compilation, my lords. On 18th July is the complaint given to the inspector of police, my lords, Lokayukta.
No, but it was argued that you had tendered an opinion saying that it is, they only have to seek the prior approval at 17A.
No, what, I'll come to my opinion later.
No, that's what I said, because
no, they have
no,
to.
now you're saying that police officer has to register, police officer has to seek permission.
No, what, they're slightly different, what the opinion and given, what I'm submitting, my lord. Here, my lord, if they are complied with 154, my lords, as I submitted earlier, it is, he would have done a preliminary inquiry, then sought, as your lordship just pointed out, my lord, he would have, if it's a cognizable offense, he would have sought for a prior approval under 17A. The question is, my lord, whether 154 or 173 was sought to be complied. My lord, this 154 argument comes when private complaint is filed. But what my submission here is, my lords, the entertainment of the competent authority ought to have seen whether that procedure is followed prior to entertaining an application under 17A, my lord. The reason is this, my lord. If that was not followed, you should have seen that such a procedure is followed so that that material was with him. Here, my lord, 154.1 is not followed, or 173.1 or 173.3.4 also is not sought to be.
151.
154,
1 and 3.
1 and 3 has not been.
171.
No, so please, ma'am. So therefore, my lord, to entertain that application also, application 17A, my lord. This crucial aspect, whether the compliance of 154, my lord, was done, or 173, 1 and 4 was done, was very crucial. If that was not done, my lord, it ought to have been returned back, saying that comply with the said procedure, then you file an application. And in fact, insofar as Pradeep Kumar is concerned, my lord, that is respondent number 5, no such complaint is given at all. And insofar as respondent number 4 is concerned, my lord, application is filed subsequent to filing a complaint before the competent authority. And the competent authority has considered the application dated 5th July 2024, which pertains not seeking prior approval, but seeking CBI inquiry. So therefore, my lords, insofar as application of respondent number 4 for grant of sanction was not there, neither in the file of the competent authority, the Honorable Governor, my lords, or in the statement of objection. So therefore, my lords, the application sought for ought to have not been entertained on this count also.
Yes.
Then finally, my lords, one of the point coming to now the aid and advice, my lords,
163.
163.
Hmm.
Insofar as courts, MP police establishment, and they've all said, my lord, the discretion is with the governor. The question is, what is this discretion? How he has to exercise this discretion? For example, my lords, on the basis of if the aid and advice or there is material, we'll take a situation, my lords, where recommendation is given, the aid and advice is to grant sanction, and the same is rejected. It can work both ways. In this case, my lords, the advice is not to grant sanction, it has been granted. There may be cases, my lords, where recommendation is to the other.
Not to grant sanction, but sanction is. But sanction is to grant sanction, sanction is not granted.
Not granted.
All right.
So therefore, my lord, this discretion is not his absolute power or absolute discretion which he can exercise. This is limited to what has been held by the Supreme Court in MP Police and Justice Punchi's judgment and Nawab Rabia and all these judgments. Ultimately, I just like to write 2 paragraphs of the judgments, my lords. My lordship may kindly take to page number, my lords.
48.
Please. Page 41 for a moment, my lords.
The discretion begins there. Your submission is at page 48.
Note on points with regard to.
Yes.
So therefore, my lords, with regard to limited discretion, narrow scope of discretion, reason and caution, my lords, keeping that in aside, my lords, I'll just, where is that paragraph? Your lordship may kindly turn to page 55, my lords. At point number 4.
MP Police.
Which has been reiterated in AG para 4, my lord. It is pertinent to note, as evident from the impugned order and the materials put forth by the governor, there has been assumption of bias contrary to the legal principles established in MP Police establishment, Nawab Rabia, and so on and so and so. The exception carved out in this landmark judgment for when a governor may act against the advice of the Council of Ministers have not been addressed or satisfied in the present case. The impugned order and the material produced by the Honorable Governor fails to provide any substantive reasons from deviating from the aid and advice given by the Council of Ministers, nor does it demonstrate how the Cabinet's recommendation against granting sanction was irrational or unsupported by material evidence or suffered from bias. Furthermore, the order lacks a reasoned explanation to establish its own rationality or to show that it is based on through consideration of relevant materials. This absence of reasoning, coupled with apparent haste in the decision making, raise serious question how the propriety and legality of the impugned order potentially infringes upon the constitutional scheme and governance principle of federalism.
Yes.
Your Lordship may to page 43, my lords, for a moment.
Yes.
The 43 last paragraph, my lords, 4.2.15
Yes.
explains, referring to Shamsher Singh and M.M. Punchi's commission's report, my lords. It's just been culled out over there.
Yes.
Which page 43 highlighted portion. Thus, the scope of discretionary power as provided in exception to clause 1 and in clause 2 of article 163 has been limited by clear language of two clauses. It is an accepted principle that in a parliamentary democracy with a responsible form of government, the power of the governor as a constitutional or formal head of the state should not be enlarged at the cost of real executive with the council of ministers. The scope of discretionary power has to be strictly construed, effectively dispelling the apprehension, if any, that the area of excessive discretion covers all or any of the function to be exercised by the governor under the constitution. In other words, Article 163 does not give the governor a general discretionary power to act against or without the advice of his council of ministers. This area of exercise of his discretion is limited. Even this limited area, his choice of action should not be arbitrary or fanciful. It must be choice dictated by person, actuated by good faith and tempered by caution.
Prudence, caution, all right.
So, my lord, this is the, so therefore, my lord, the lordships will see, my lord, whether the impugned order comes within the four walls of this aspect. So therefore, my lord, the reasoning that the impugned order says it is my discretionary because there is bias apparent and evident is not a ground. As already pointed out, my lord, it should be by reasons with which the reasons should be in the order itself, not in the file, my lord. I would just like to take your lordship to the file for a moment, my lord.
Which file?
The governor's
Oh,
file.
right.
Just I'll end with that, my lord. Just want to point out 2-3 aspects
Yes.
in that, my lord.
Madam, copy ಕೊಟ್ಟಿದ್ದಾರೆ. Copy ಕೊಟ್ಟಿಲ್ಲ.
Volume
No, it's in volume
1.
That's the order.
Oh,
Impugned
the order sheet.
All.
Proceeding.
Yes, yes.
If
Which?
page, my lord, page 1, my lord.
Ah,
If your lordship sees, my lord, reference subject is sanction for prosecution, my lord, of so and so. Petition, so and so dated 26/7. Kindly produce petition by so and so, serial number 1. Then next page number 2, my lords. Please pursue papers, pre-paras, the complaint addendum. Then next at page 3 on right on top, my lords. I have heard so and so in person and gone through the petition and supporting documents submitted by him. Prima facie, I am of the view there might be irregularities and misuse of power. Hence, show cause notice to so and so within 7 days. So this is what the preliminary inquiry sought to be done, my lord. Then can I request, my lord, page 7. Speaks about, my lord, the reply given by the petitioner, then the proceedings. Then last at para 20, my lords, put up along with the comparative statements of petition, chief minister's reply and cabinet decision. Then at page 8, my lords, as directed at para 20, comparative statement of petitioners received so and so, reply are placed in the file for kind perusal. Perusal file discuss the issues, hence resubmit, kind notes, points dictated. Then this is page 9, para 25 is important, my lords. Insofar as TJ Abraham, my lords, what is taken note of is the 26th July. Insofar as Pradeep Kumar, my lords, is 14/8, and my lords, Nehemiah Krishna is 5/7, my lord. 5/7 pertains to referring the matter to CBI, not the additional memo which has thought to be filed on court. So therefore, my lords, what was sought to be argued on principle of law, my lords? In fact, your lordship's judgment in Ashok and Pradeep Kumar all says the reason should be in that order itself, my lord, because it is a 17A is a protection given to the public servant, the files or the notings in the
So file notings will not supplant
supplant.
what is not there in the order,
What is
or
there.
supplement what
Sup-
is there in the order.
order.
Not
So
supplant.
therefore, to say, my lords, I did A, B, C, D, E, F, G, but my order may be wrong. But look at A, B, C, D, E, F, G. Ultimately, my lords, what is looked into is the order. If the order is bad, it's bad. So don't try to, as your lordship says, supplant the file to look into the order. If the order does not satisfy 17A, my lord, the order has to
Go.
go.
Yes.
So therefore, my lords, insofar as this legal, because these submissions are made on what the, therefore,
So, understand? Any other submission?
that's it.
Your synopsis, your written submission also is the same?
Same, my lords, on the same lines.
Why have stated position of the governor under Article 163?
No, not this governor, generally governor.
No, it, point 3 at page 656.
Page
56 of your written submission.
My lords, this is a
Nothing.
federal structure, well, not insofar as this impugned order I'm talking about.
In general.
In general, man, I'm not dealt with the impugned order in specific at all.
Constant assembly debates. Article 143 there.
Please. In fact, my lord, the discussion, I've enclosed those copies all over discussion, my lord. Ultimately, my lord, as your lordship, the discussion is there to what extent it all depends upon facts of each case, my lords, which your lordship will consider.
Yes, sir.
I'm
Anybody
grateful to my
else?
lords.
Anybody else? Yes.
I'll make my submissions after Dr. Singhvi.
Yes.
Dr. Singhvi.
But I will be doing it on 12th, Palas. I will do it on 12th.
12th, sir. Yes, we'll finish it on 12th.
Unless my review
The
petition
complainants-
succeeds.
Complainants have all completed?
Yes.
Yeah. They completed last.
You have submissions to make? No?
Reply to reply.
After the
Reply.
After the reply by Dr. Singhvi, sir. All right.
Unless after my reply,
Again, it will
Palas,
go on then.
normally-
This
no, after
rejoinder,
my reply,
adella-
I am a rejoinder, Palas. I will be doing a rejoinder. There can't be a
One minute,
reply
one minute.
after
Yes,
that.
sir.
Palas, after I reply, I had opened the matter, Palas. It has to be, if somebody argues after me, Palas, then I will need a reply to that also. No,
Then it will
except
go
my
on.
learned friend. No,
See,
except my learned friend on my
whatever you
side.
want to reply, file by way of reply, and you want to any clarifications later, you submit on that day because you have not submitted at all. And sir, also, if you want 5 minutes, that's all.
No,
Oh, sir.
No, ಇಡೀ ಗ್ರಾಮ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Huh?
ಇಡೀ ಗ್ರಾಮ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಕೆಸರ ಗ್ರಾಮನ. I have to show it to the court. It is not.
No, my learned friend can.
No, he's sailing with you, sir.
No, I thought it's somebody else, fellas. I thought I didn't see his face.
Dr.
He can
Singhvi,
argue after me.
No, I said I'll make my arguments after you complete your arguments.
No problem. He's on the same
Yes,
side.
yes, that is
I
what
thought
I
it's somebody else arguing.
No,
Well,
no.
It is.
I'm only going to supplement what you make, what
No,
you
that's
submit.
all right. I misunderstood.
Without repeating
I
what
thought-
you said.
I thought it's somebody else. I'm sorry.
No.
So, ಕೆಸರೆ ಗ್ರಾಮ ಇದೆ ಅಂತ ಹೇಳ್ಬೇಕು.
ಕೆಸರೆ ಗ್ರಾಮ ಇದೆ. ಆಮೇಲೆ ಸರ್ವೆ ನಂಬರ್ 464 ಇದೆ. ಅವೆಲ್ಲ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ತೋರಿಸ್ಬೇಕು.
ಇರೋದನ್ನ ನುಂಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ನುಂಗಿಲ್ಲ. ಈಗ ಹೇಳಿದ್ರಲ್ಲ. ಗ್ರಾಮನೇ ಇಲ್ಲ. ಜಮೀನೇ ಇಲ್ಲ. I'll show. Where is the village? Where is the? I'll show.
All right.
Okay.
So this will go on and on. I am not.
No. I'm only going to reply. No, sorry. I am going
Right,
to
1 minute.
reply.
Sir. 1 minute, 1 minute. The right of reply is always there. You have submitted, right of rejoinder submissions is always there. If any clarification to that, yes. You can't go on and on like this and it's not it becomes a circle, sir.
Whole day it was argued saying that Kesara Grama is not there.
No,
I will
1
show
minute, sir.
where is
What-
Kesara
1 minute. For whatever you have submitted, they have a right to reply, they will reply. Then after that, it's not that you have a right to reply. It's not like sir rejoinder, filing sir rejoinder, sir submissions here.
reply to reply is unknown, sir. Unknown.
But they will, sir, you, 1 minute.
I don't know why my
You
learned
have
friend
made
is-
some submissions. They have a right to rebut, 1 minute, rebut those submissions. If it is by way of new things, what can be done?
No, I don't know.
In
why-
justification, they will say whatever is there. Allah, I can grant time, that's not a thing, but it will go on. How long do you argue the same thing?
So 12th, my lords, 12th.
New proposition, where are the new propositions, sir? You have submitted the whole day on 31st from 10:30 to 4:45. We'll see. You also want to clarify?
With respect to the chief minister's role that is, your lordship.
All right, let Dr. Singhvi sir finish it. We'll see, yes. 15 minutes. No. We'll see. First, let the respondents finish. Avatte ಮಾಡ್ತೀರಾ sir ನೀವು?
Petitioners, yeah.
Petitioners.
ಅವರು Dr. Singhvi ಮುಗಿಸಿದ್ಮೇಲೆ
The moment
I don't
Dr.
want to
Singhvi
repeat.
completes your-
Yeah, I'll immediately start.
My lords, let me just make one thing clear. If anybody has any new point, they should give it to your lordships today or tomorrow. Because if when I am rounding it
Today,
up.
no new points, sir.
After my finishing, if somebody argues
No,
other than Mr.
just a
Ravi
moment.
Kumar,
Then you
I'll
submit
be a
whatever
great
you want to
disadvantage.
submit.
Yeah.
If you want to say straight about the role, please state. Then Dr. Singhvi sir will reply to that also.
That's all. Well,
I will hear you. How long will you take?
5 to 10.
That's all. Then you, if you're ready, you state. Yes.
Lordship,
Obliged.
Your lordship had put forth rules. What is the role of the chief minister ultimately in this entire matter?
Yes.
Key words are check period. Check period, your lordship. What happens is in all prevention of corruption matters, the date in which the position of power was held by the person, that is critical. Check period is what is taken into account for any irregular accounts that have entered into the person's account or the wife or any other family member. If the check period is gone into, then all of this falls in place. Your lordship, ultimately, we are only looking at when are the periods in which the petitioner held a certain post, and that is the time during which all of this took place. Your lordship, it is only between the year 1996 to 1999. 1996 to 1999,
Deputy Chief
he was the deputy CM. That period, your lordship, is the denotification period. I'm not going to expand further. The 1996 to 1999 is the entire denotification period which took place, and subsequently is the year 1999 to May 1994. That is the period when 2004, wherein the petitioner was not in power since he had lost his elections. Therefore, your lordship, that period is the lull period. Nothing takes place then. After that is during the period of 2004 to 2007. That denotification portion is over. So therefore, 2004 to 2007, the conversion phase starts. So from 2004 to 2007, documents are already there and they have gone into in length in that. So that is the conversion period. Subsequently, 2008 to 2013, your lordship, this is when the transfer takes place from A4 to A3 to then A2. That happens between up to 2010. Your lordship, between the year 2013 to 18, when he is the chief minister, at that point of time, A2 takes over. The vice gives all the representation stating, give us compensatory land. So the phases of denotification, phases of conversion, and then phases of submissions of representation, and then seeking compensatory lands. Your lordship, the key period that the petitioner seems to state is that all of this took place when they were not in power. Your lordship, what happens is the year 2018 to 22 is critical. 2018 to 2022, the petitioner was very well an MLA. Now, it is not about which political party is in power. It's ultimately, did the individual hold a position of power or not? He held a position of power at that point of time. And at that point of time, what happens is that the 14 sites that are allotted are done at a government guest house, done specifically for that. Your lordship, what happens is A2 doesn't go to the sub-registrar's office when MUDA gives this.
That's permissible in law.
That is permissible under the
For the
Registration
purpose of
Act.
registration of sale deed.
Registration of sale deed, that's permissible under the Act only for the person who is exempted from his presence there.
Disabled.
Disabled is one. There is also a list of people who need not be present at the sub-registrar's office. And that
So
is
you're attributing the connection to power.
absolutely every single act that has taken place has been done on behalf of the petitioner. And that has been established all through. And then subsequently, when actually the year of 2023, when all of this is unfolding, at that point of time, the petitioner says, all right, take my 14 sites, give me 60 crores. And so starting from the period on which we start with denotification, where A1 makes A4 to do all of this. That is, the petitioner asks A4 to do it. Up to the time they say, all right, give me back my money. From then onwards, the role is established. Your Lordship, we have only given a set of judgments which the others haven't, and only those we will mention, Your Lordship. These are only with respect to check period. Check period, Your Lordship.
In a Prevention of Corruption Act case.
In Prevention of Corruption Act cases, Your Lordship.
Yes.
I'll
from
very quickly.
Period A to period B.
Period A to period B.
Date of joining service till the date of search.
Absolutely. And in most of the cases, Your Lordship, it is more of disproportionate income, and therefore they calculate the income during the time when he was in power and when he was not in power. In this, there is a
But
slight
how is the
shift.
concept of check period relevant to this, or you're trying to paraphrase that to this?
We are drawing a parallel. In this, there is no money that you could attribute to have entered into at that point of time, but it is directly attributable to the acts that have taken place during that time. Your Lordship, and also with respect to what is the role of all of these judgments, Your Lordship, I will not take Your Lordship into detail, but all of these judgments only state that even if let us assume that the wife, that is A2, would be probably not working, or would have a source of income, maybe an agricultural source of income, and would file income tax returns. Nevertheless, the courts have held that if the person who's in position of power has purchased certain properties in the name of the wife or in the name of any other family member, it would still ultimately be attributable to them and their role in all of this. Directly, Your Lordship, all of these judgments, Your Lordship, I have...
Paragraphs hakidira?
Your Lordship,
You've
we've put
indicated
in.
the paragraphs of these judgments?
Paragraphs
Yes,
have also been mentioned,
Yeah,
Your Lordship.
yes.
In Ponuswami's case, Paramasivan's case, Balashankar Lingam's case, then Ponnumudi and Soundararasu, and also Wahidida Jayaraman, Your Lordship.
All right.
All of this directly on the point of when a particular person is in power. And that should probably connect the dots, Your Lordship. That's it.
So that's the link that you're trying to draw.
Absolutely. And to say that I was not in power when all of these 14 sites was allotted, he was definitely in power.
No, not in power is not the submission, but not taken any decision directly or any recommendation made by him. That is the submission.
Your
He was
Lordship.
in power, that they accept, that's a matter of fact.
Please, Your Lordship, anyway, the judgments are clear. We don't need a direct recommendation or any letter from them. If we are able to show the link at that point of time. For example, how I've been able to establish that the time when he was not elected, there's a lull period. But all the times that he's elected, activities have taken place. So that is sufficient. And the question always should be, what is the role of A2, A3, and A4, as opposed to asking what is the role of A1? Because A1 is established very clearly. A2 and A3 and A4 could be at best aiding or abetting. And that is something, it's just a matter of trial. But with respect to A1, it's very clear. That's about it.
All right, yes. Yes, now, Professor Sir, you have heard the council also. Elladakku seri reply on 12th. Singhvi Sir?
Yes,
On
fellas.
on 12th, Sir.
Yes, 12th, fellas.
12th, we'll take it at 10:30 or at 2:30?
Well, it's not at 10:30, but maybe around 12 or 11:30 or
All
something.
right, we'll take it at
I'll
12-ish.
come to the court, yes.
Yes, sir. 12 o'clock.
Yes, fellas. Obliged.
Heard the learned counsel Ellardu Hakpade and counsel Srimati Lakshmi Angar appear for which respondent, for the fourth respondent. The respondents have all completed their submissions. The learned advocate general has also completed his submissions for the reply submission of the senior counsel Dr. Abhishek Singhvi and the senior counsel Professor Ravi Verma Kumar list this matter on 12th. 12th, we should be concluding this, sir.
Yes, fellas. Yes. Obliged.
ಏನಾರ ಇದ್ರೆ 5 ನಿಮಿಷ ಅಲ್ಲೇ ನೋ ಡ್ರ್ಯಾಗಿಂಗ್ ದ ಪ್ರೊಸೀಡಿಂಗ್ ಅದೇನ್ 15 in the 10ಗೆ ಲೆಟ್ ದೆಮ್ ಫಿನಿಶ್ ಇಟ್ ಫಸ್ಟ್ ಆನ್ ದಟ್ ಡೇ Huh? What do you want to say? The legal submission, sir. ಮತ್ತೆ? ಅವತ್ ನೋಡ್ 12th. Yes, ma'am. List on 12th at 12 PM. 12.
The judgment supporting.
Let us hear, yes.
No, I don't have anything more to say.
Yes, sir.
I have done whatever I had to.
Yes, sir, yes.
The judgments which I have given along with the note, my lord, the full judgment copy has been enclosed, my lord.
ಅದಕ್ಕೆ ಇದೆಯಾ?
Alla, separate compilation.
ಕೊಟ್ಟಿದ್ದೀರಿ.
Separate compilation has been.
There are about 12
Yeah.
compilations of judgments now.
We want
ಬರೀ 2500 page judgments ಕೊಟ್ಟಿದ್ದೀರಾ.
for a 6-page prior approval.
Yes, sir, we'll see. Yes, madam, yes.
Grateful.
ನಾವು ಅದೇ ಹೇಳೋದು for a 6-page prior approval ಇಷ್ಟಬೇಕಂತ.
Alla.
Now,
Raghavan has- Mr. Raghavan has come.
role is sort of explained by the senior counsel Lakshmi Iyengar. Now we will reply to that.
I'll do. I'll do. Interim order needs to be.
That will be extended.
It took so long
For what?
to explain the role.
That is my investigation. That is my investigation.
Your Lordship, the League of Extraordinary Gentlemen went on a marathon. Ultimately, a lady had to take your Lordship through a 100-meter dash.
Let's see. Well, hear it on 12th. Yes. List the matter on 12th at 12 PM. We'll start at 12 sharp. Sir will be appearing physically or Singhvi sir?
No, Manoj, I will be, I'm coming there physically, Manoj. That's why. Very grateful.
That's fine, yes.
Yes.
ಬರಕ್ಕೆ. 2:30 minutes. Settlement. ಒಂದೇ ನಿಮಿಷ. Child is there, is it?
End of list settlement.
Take it. Give it. No problem. Give it. Where the child is there, please give it. Yes. Get that matter, madam.
First matter, there are 5 petitions, all of them are present.
498A. No, let the mother stay out with the child in this rush, not. Oh, fine, yes, fine. All right, yes. No, they are the accused.
498.
But where is the complainant is present?
Morning itself, I make a call to the complainant, she is not.
Not willing. Not willing to settle. Huh?
She is not well, Malas.
Not well. We can close it. Settle ಆಗಿದೆಯಾ?
Settle ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, but
On 16/1, the order has been passed to the family.
ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ? ಮತ್ತಿನ್ನೇನು ಕೊಡಿ. ಎಸ್. ಮತ್ತಿಲ್ಲೂ ಏನು ಡಾಟ್ಸ್ ಮಾಡೋದು? ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆದ್ಮೇಲೆ ಕೊಡಿ.
ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಚೈಲ್ಡ್ ಪಾಸ್ಪೋರ್ಟ್ ಒಂದು ಕೊಡ್ಬೇಕು, ವಾಪಸ್ ಕೊಡ್ಬೇಕು.
ಚೈಲ್ಡ್ ಕಂಡೀಷನ್ ಇದೆಯಾ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ?
ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ.
Passport is expired. It was done when he was 6 months.
So both of you cooperate and get it extended, and visitation and holding of the child or the passport. Child is in whose custody? Child is in whose custody? Mother's custody. So you will apply for renewal or reissuance. Expire ಆಗಿರೋ passport ಅವ್ರು ಇಟ್ಕೊಂಡ್ರೇನ್ ಬಿಟ್ರೇನ್? Yes. All right. ಕೊಡಿ. We'll close it. Don't. ಎಲ್ಲ ಆದ್ಮೇಲೂ ಡಾಟ್ಸ್ ಮಾಡೋದು ಬೇಡ. Yes. Petition. ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದೀರಾ? All right. You take it as settled. Conditions. ನಿಮ್ ಪೇಪರ್ ಕೊಡಿ. ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಕೊಡಿ. Give that. Vijay, parties were before the family court as well. ಇಲ್ಲಿ settlement ಇದೆ, ಅದರಲ್ಲಿ mark ಮಾಡಿಕೊಟ್ಟಿದ್ದೀನಿ. One of the condition is closure of the proceeding. Point number 11, ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ದೀನಿ ಅದು. The learned counsel appearing for the complainant would submit that the settlement is indeed arrived at, but has some grievance about the passport of the child being held with the husband. The learned counsel representing the husband would submit that the passport has expired 3 years ago. The child is now 8 and the passport had expired when the child was 5. Therefore, the respondent mother in whose custody the child is always, it is always open to her to apply for reissuance of a passport in accordance with law. ಅದೊಂದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟು ಕ್ಲೋಸ್ಡ್ ಅಷ್ಟೇ ತಾನೇ ನಿಮ್ಗೆ ಎಕ್ಸ್ಪೈರ್ ಆಗಿರೋ ಪಾಸ್ಪೋರ್ಟ್ ಮೇಲೆ ಸೊ ಅಂಡರ್ಟೇಕ್ಸ್ ಬೋತ್ ದ ಮ್ಯಾಟರ್ಸ್. ಎಸ್ ನೆಕ್ಸ್ಟ್ 230 ಮೂಡ್ ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಿ. ಪಣೀಂದ್ರ ಸರ್. ಅದ್ ನೀವು ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ದು ಅಂತ ಗೊತ್ತು, ಅದಕ್ಕೆ ಕೇಳಕ್ಕಾರ್ತೀನಿ.
Girl and boy knew each other in college.
Girl and boy knew each other?
But this is the wife's complaint after marriage, after I filed a divorce petition. First time she files one complaint, my lords, alleging
POCSO.
POCSO on the wife.
POCSO.
Not on the wife, not on the child. After the divorce petition.
No, 1 minute. What was the age when both of you knew each other?
But in 2019-20, we came to know each other.
What was the age, her age then?
17 years and 8 months.
All right. After that you get married when?
That's on 2021.
No, but what was the age of, what was her age when she got married?
She was born at 21 years.
No, the girl was above 18. Yes, all right.
In fact, on 25/10/2021, I had given a complaint saying she's coming. My father had given, that's the second accused.
Second.
Father, she has involved father, mother, aunt, everyone in POCSO 498A SC.
POCSO.
Now, my lords, 21, I give a complaint. She gives an undertaking, she's not troubled. Then, my lords, the boy and girl elope and get married in Hassan, registered marriage. She admits marriage. Then, my lords, there is trouble between us. Then she gives one complaint to the police saying that he is troubling me, counsel. We undergo counseling, it fades. Then, my lord, 498A, she lodged this. By that time, I had filed a divorce petition. This honorable court grants anticipatory bail on 27/5/2024 on 498A. 6/6/2024, she files a complaint saying I had, my lords, raped her in 2000. That is invoked. 498A first complaint, there is nothing.
And Jagdish sir.
Yes.
25 days ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಿ. ರೆಕಾರ್ಡ್
ಈಗ ನೋಡ್ತಾ ಇದ್ದೆ.
ನಾನು ಈಗ ನೋಡ್ತಾ ಇದ್ದೆ. Date 26/6/24 crime, 24/7/24 charge sheet.
Yes.
Very fast, sir.
And in all the records, father's name is shown as Rajappa.
Who is that?
How she says, my father is Nayak, to claim my lord's SC/ST, she says, her school records, everything shows Rajappa. She says, Rajappa.
Who is Rajappa?
She says, I am the adopted daughter of Rajappa, my father is Nayak. Please see her school records.
CST Atrocity Act 6, charge sheet has to be filed within 60 days. It has to be
ಇದು
filed.
3-1 R&S ಬೇರೆ ಇದೆಯಾ ಅದಕ್ಕೆ?
What?
Any offense left?
R&S.
Nothing more, I don't know, my lords, everything. The boy had to spend 1 month in custody, though he had anticipated. Parents spent about 15-20 days in custody.
Object achieved. Yes. Heard the learned senior counsel, K.N. Panindra, appearing for the petitioner. The petitioners accused 1, 2, 4 are knocking at the doors of this court, calling in question filing registration of special CC 1493 of 2024. The facts would read as follows. It transpires that the first petitioner and the second respondent complainant knew each other while pursuing their engineering. They fall in love, get married. on 23/10/2021. You have a child also? 13/1?
13th of January 2023, the marriage.
On 13 January 2023. Soon thereafter, it transpires that the relationship between the first petitioner and the second respondent complainant flounders. And on the floundering of relationship, certain proceedings are instituted. The husband institutes proceedings seeking annulment of marriage before the family court. Thereafter, the wife registers a complaint. For what offenses is surprising to notice. The wife registers a crime for 498A. There should be no problem with that. The wife further registers proceedings for offense punishable under section, further registers complaint for offense punishable under section 376, 354C, 506 and 34 of the IPs. Charge sheet is filed by the police invoking POCSO. The reason for invoking the provisions of POCSO is before marriage, the relationship, the petitioner is alleged to have had physical relationship with the complainant, at which point in time she was less than 18 years. The marriage having taken place later and the floundering of the relationship between the two cannot give rise to an offense under POCSO which had taken place earlier, albeit prima facie. All the other offenses would touch upon the disputes between the two and the crime being registered as a counterblast. This is again a view that is prima facie. Therefore, till the appearance of the second respondent complainant, there shall be an interim order of stay of further proceedings in special CC 1493 of 2024, 1 additional SPP, 2 emergent notice returnable by 26th September.
Number 2, Shyamki Reddy.
Settlement. An offense?
360.
Offense.
506. Plus it's between a husband and wife. The complaint is the husband as against the wife.
Extorting money.
Extorting money is what they claim. However, the matter is settled with the party. For the
Who is the complainant? Why, if the wife asks you money, it is extortion, is it?
No, my lord.
ಆಯ್ತು ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಬಿಡಿ ನಮ್ಗೆ ಯಾಕೆ ಕೊಡಿ. Yes.
The respondent number 2 is appear via VC.
Huh?
Respondent number 2.
All right, yes, give it. Settlement close ಮಾಡಿ ಅನ್ವಿಜ್.
Application under 359 sub.
So and so, totally. Application is filed on 359 BNSS, not 320. So and so. Settled. Copy ಅವ್ರಿಗೂ ಕೊಡಿ. 363 ಅಲ್ಲ.
Copy ಕೊಟ್ಟೇ ಇಲ್ಲ.
ಕಾಪಿ ಕೊಡಿ. ಗವರ್ಮೆಂಟ್ ಕಾಪಿ ಕೊಡಬಾರ್ದು ಅಂತಿದ್ಯಾ? Not this, sir, your settlement copy, sir. Give it.
Petition copy.
Petition copy no ilva?
230 moved matter ಮೇಲೆ copy sir not.
Other, yes. Forgery, sir. 465, 420.
Connected 498A case was settled before the court on number 22 minute today itself.
Today?
Yeah, criminal petition.
Oh, all right, sir.
That is 2019 minute.
No problem. Close it, yes. I will.
The respondent number 2 appear VC.
Thank you, my lord.
Yes, thank you. Yes. Hello, pages karbiಡಿ.
Page 6, number 36.
NDPS.
NDPS.
ಗೊತ್ತು.
It was for dictation on 5th.
Today not possible.
Please.
18th.
18th.
Yes.
Obliged.
List on 18th. Next.
37 to 41.
Wherever entry order is there, they'll continue. Will they rather 18th?
40 minutes.
Where there is no interim order, they'll come on 18th.
40, my lord, last 2 dates it is.
Huh?
40, serial number 40.
ಏನಾಗಿದೆ sir?
Date also it is urgent. Last date also it is urgent, my lord.
Last date?
Also it is urgent for today.
This date also it is adjourned. Can't help. List on 18th.
List number 1 is arrested.
All matters where interim orders are not there, they'll come on 18th.
My lord, my submission will be number 42.
Wherever interim orders are there, they'll get continued
My lord,
for period for 2 weeks.
My-
Next date of hearing.
my submission, my lord, petition number 1 is subsequently arrested, my lord, and
Subsequently arrested, why?
after filing of this petition.
Why?
For offenses under 376, my lord.
376.
376.
Parallel.
Now the parents who are in Chhattisgarh, my lord.
Huh?
Now the parents who are in Chhattisgarh,
ಅದ್ಯಾವ್ದು ಮುರಳಿ ನೀವೇನಾ?
please.
Interim order ಇಲ್ಲ ಅಲ್ವಾ?
ಇಲ್ಲ, entry matter. Last date also it is.
ಅದು ಲಿಸ್ಟ್ ಆನ್ ಮಂಡೇ ಎಂಡ್ ಡೇಟ್ ಮೇಡಮ್ 16, 17. ಅದ್ರ ಬದಲು 18th ಬರುತ್ತೆ. 17th in the fresh matters list. All right. Serial number 40 ಮಾತ್ರ. Because he is arrested, yes.
Please.
Interim order ಇದೆಯಾ? $55. Tomorrow ಆಗಲ್ಲ madam. Tomorrow not possible. Wherever interim order is there, they'll continue for 2
Number
weeks.
52, my lord.
ಅದೊಂದು ಮಾತ್ರ day after tomorrow.
52, my lords, it's concerning default bail.
52, my lord. Summoning of.
52, my lords, it's concerning default bail, my lords.
Default bail ಯಾವ್ದು?
52.
52.
Please, my lords.
52 also list day after tomorrow in the fresh matters.
Summoning of the.
ನಿಮ್ದು default bail ಆ? Where is it?
I have already.
Pokso na? Pokso is 20th. ಯಾವತ್ತು?
Serial number 52, my lord.
Huh?
Serial number 1 was arrested subsequent to filing the petition.
ಜಗದೀಶ್ ಏನ್ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ರೆಸ್ಟ್ರೆಂಟ್ ಆಕ್ಟ್ ಇದೆಯಾ?
Lots of serial number for
That day after tomorrow ಹಾಕಿ ಮೇಡಮ್. ಅರೆಸ್ಟ್ ಆಗಿರೋದು day after tomorrow ಹಾಕಿ.
serial number 40.
Number 50 supposed to be listed fresh matters, my lord. Serial number 50, my lord, the matter was listed before you last.
ಸರ್ ಇಂಟರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂದ್ರೆ
Fresh list ಆಗಬೇಕಾಯ್ತು, fresh.
ಆಗುತ್ತೆ. ಇವತ್ ನಾಳೆ ಅಲ್ಲ. 17ಕ್ಕೆ ಆಗುತ್ತೆ ಸರ್.
Serial number 39.
ನಾನೇ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮತ್ತೆ ಹಾಕಲ್ಲ.
Subjection over.
ನೋ ಅದು ಬರೀ ಆತರ ಇದ್ರೆ ಬರುತ್ತೆ ಅಷ್ಟೇ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಓವರ್ ರೂಲ್ ಅಲ್ದೇನೆ 1 minute sir. Don't argue with the court officer. Now, no. If I have issued notice without granting an interim order, it will come only in admission after the appearance.
Serial number 39.
ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಬಿಡಿ.
Madam, actually second list ಅಲ್ಲಿ ಇತ್ತು madam ಅದು.
ಬರ್ಕೊಂಡಿದ್ದೀನಿ.
ನಾಳೆಗೆ charge ಇದೆ madam.
Madam, serial number 12 ಯಾವಾಗ